Good morning, everybody.
Good morning.
It is 9:04 a.m. on Friday, February 26th of 2021. As the chair of the Criminal Justice and Public Safety Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, in accordance with the governor's emergency order number 12, pursuant to executive order 2020-04, this public body is authorized to meet electronically. This is a public hearing with the potential for executive sessions to be held throughout. Let's read that again. This is a public hearing with potential for executive sessions to be held throughout. Please note that there is no physical location for the members of the public to observe and listen contemporaneously to this meeting. However, in accordance with emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic platform, and the public has access contemporaneously listen and, if necessary, participate in this meeting by Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice of this meeting complies with House rules and RSA 91-A. Anyone who has a problem accessing the meeting, please call 603-271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. I want to introduce the staff that are on the meeting assisting us. Brad Greenland, who's our committee researcher. Please note that all votes that are taken during this meeting shall be done. Please note. Gary?
I know.
Don't need to say another one.
I didn't know if he knew it was him.
That's what he knows.
He does now.
Good that we made it about 2 minutes before our first technical difficulty.
Yes.
Please note that all votes that are taken during this meeting shall be done by roll call vote. Let's start the meeting by taking a roll call attendance. Hopefully Gary makes it back into the room by the time we do that. When each member states their presence, please state whether there's anyone in the room with you during this meeting, which is required under the right to know. The clerk will now call the roll.
Vice Chairman Welch.
He stepped out.
We saw him, he'll be back. Don't, just keep going.
Representative Burt.
I am here with Representative Hopper.
Representative Hopper.
I think I'm here.
Representative Green.
I am here with Representative Burton.
Representative Wallace.
Present.
Representative Testerman.
Here.
Representative True.
I am present in the committee room.
Representative Pratt.
Present.
Representative Marston.
I too am present in the room.
The clerk is present. Representative Harriet Gethright.
Present.
Representative Pantelakis.
Present.
Representative O'Hearn. Representative Bourdonnais.
Here by myself.
Representative Hughes.
I'm here and I'm in my office alone.
Representative Newman.
I'm here and my wife is in the house.
Representative Golden. Representative Conley. Representative Klein Knight.
Just give her a minute for her. I did see her. She appeared very briefly, then disappeared. But we'll keep going. We'll come back to it.
Okay. Representative Bradley.
Here, and my daughters are with me.
Chairman Abbas.
The chair is present. And I'll just state this in case I forget. My understanding is that Representative Bolden and Representative Conley will be, they have obligations this morning, will be joining us also Representative Welch, the vice chair, was here about 2 minutes ago. So he will be joining us. And wait,
Bordonay didn't answer, did he?
Representative Bordonay,
He did answer.
Oh, he did? Okay. 'Cause I know he's stepping up too.
there he is.
Chairman.
Okay.
Just Representative Knight just appeared. Well,
Representative Plain Knight, are you here?
Yes.
yay. Oh, and here we go. Representative Welch.
Vice Chairman Welch.
Yes.
All right, that was the worst rule. Okay, moving on. This time, the Criminal Justice Public Safety Committee will now hold the public hearing on House Bill 436 relative to eyewitness identification procedures. Oh, this bill is sponsored by 2 members of our committee, as well as another representative. Who will be doing the honors? Oh. Well, I'm gonna find out. Representative Cushing, are you present?
Chairman, I do not see Representative Cushing.
Representative Gafford or Representative Welch, would you like to do the honors as co-sponsors?
I'm not even in yet. I'm sorry. I'm not in yet.
I see our friend Representative Baldasaro's on.
Steve, do you want to introduce the bill?
I'll do that.
At this time, the chair recognizes Representative Welch to introduce the House Bill 436.
Yes, the bill that we dealt with last session. And this is in addition to it. House Bill 436 calls us to eyewitness identification procedures. The bill adds remedies for non-compliance with eyewitness identification procedures. It's largely a result of the Innocence Project. And that's all my knowledge on this bill. Like everyone else, I signed on to it without seeing it. The new section, line 9, is where the creates a new section, remedies.
And Representative Welch, there's people, representatives from the Innocence Project, the New England Innocence Project. And so on. So
Yeah, they'll explain the process a little better than I can.
the bill's now been introduced. And seeing no hands raised, I want to thank Representative Welch for his testimony. The chair now recognizes Elizabeth Powers. And just for members of the public, if you are present and intend on testifying, please raise your hand now, your digital hand. And as a matter of practice, we're going to limit testimony to 2 minutes per witness. However, the witnesses will be permitted to answer questions by members of the committee. Members of the committee, you will be limited to 2 questions per witness at the discretion of the chair.
Mr. Chairman, Ms. Powers is unmuted.
Great. Good morning. May I begin?
Yes, you may begin.
Thank you. Thank you all for the opportunity to testify today and for considering this important reform. My name is Beth Powers. I am the State Campaigns Director for the Innocence Project, a national organization dedicated to exonerating wrongfully convicted people through post-conviction DNA testing and reforming the criminal justice system to prevent future injustice. In 2018, the New Hampshire General Court passed a law requiring law enforcement agencies to adopt a written policy on eyewitness identification procedures that conforms to the model policy issued by the Attorney General. The Innocence Project has attempted for years to ensure uniformity of eyewitness identification best practices across New Hampshire's law enforcement agencies. We're grateful for the collaboration and support that led to a model policy from the Attorney General's office and the completion of multiple trainings by law enforcement officers. However, all of this work, in the absence of confirmation that all departments across the state have indeed adopted the model policy, leaves citizens unnecessarily at risk of wrongful conviction. HB 436 is needed to finally ensure every citizen, regardless of county, can know that law enforcement are conducting proper eyewitness identifications. Nationally, there have been 375 DNA exonerations, of which 69% involved eyewitness misidentification. Many states include remedies in their statutes that dictate consequences for not following established policy, such as instruction to the jury that they may consider the lack of compliance with the policy in determining the credibility of an identification, or instruction allowing a court to consider non-compliance with the policy in considering suppression of an identification. A remedy was not included in New Hampshire's law initially because stakeholders agreed that law enforcement agencies would adopt and follow policies that comport with the core principles of the model policy issued by the Attorney General's office. However, uniform adoption of these policies has not happened and years have passed, leaving New Hampshireites unnecessarily at risk. Details of efforts to confirm adoption of the policy can be found in my written comments, along with further details on the national landscape of eyewitness identification reform. We urge you to pass HB 436, which will assure uniform justice across the state. I'm happy to take any questions.
Representative Testerman.
Thank you, Mr. Chairman. Thank you for taking my question. I notice in here, we have a change that talks about the enforcement manual pertaining to partial identification as of current as of January 1st, 2019. I'm always concerned about putting a manual's date because they always get updated. Is this a good idea to put the date of the manual or what happens?
Sure. Thank you for that question. I understand your concern. And the reason that I think it's a good idea to put the date is because that current version, which actually is an update from when the law passed, to your point exactly, that the manual was updated, the eyewitness identification procedures that are outlined in the dated manual in this law conform to what is widely accepted to be the best practices for eyewitness identification reform. So right now, there's what's called the Core 4 reforms, which are reforms that we know, if these simple reforms are completed, help to ensure that misidentification doesn't happen. And so right now, the date that you see in that law, that particular policy, we know that the Core 4 and what is the sound accepted science is reflected in that policy. So that's why I think it does make sense to include that date. Now, if for some reason we needed to update it in the future, I think that's a conversation that could happen. But right now, if they were continuing to follow that policy and that date, we would be in really great shape.
Thank you.
Representative Hopper.
Thank you, Mr. Chair, and thank you for taking my question. Substantively, it seems like the only real change is changing the words from they to such lineups. They seem to quite clearly refer to lineups. I don't understand what has transpired since this bill was enacted or an event that happened that we find this necessary to vote on this today or to consider this today.
Sure. So I'm sorry, would you like me to answer that?
Yeah.
Okay. So I'm not sure the version, what you're looking at, but there is an inclusion of a new section that allows for remedies if the policies are not enacted. So I do believe there's further to the change of one word.
Representative True.
Thank you, Mr. Chair, and I thank the witness for taking my question. Under the remedies, number 2, the court may consider the failure to comply of this chapter as grounds for suppression. Can't the court right now consider that as grounds for suppression?
You know, I'm going to leave that question for another witness coming up, Professor Scher, who is has practiced under this. I don't want to speak to that. I know that that is not explicitly stated in the law right now. So I know that that is not currently a stated option, but I'm going to defer to him on, you know, what the court is allowed to do in their discretion. What I would say is this makes it explicitly clear that a jury instruction is to happen and that this can be grounds for suppression. But I'd prefer to defer to him as someone who practices in the state, if that's all right with you.
Thank you.
Representative Muse, you're recognized for a question.
Thanks for taking my question. Can you refresh us as to why the remedies that are present in this bill weren't included in the original legislation? I wasn't here in 2018, and I'm just curious what the background is on that.
Oh, of course. Thank you so much. I wasn't here either, but my organization was, and my colleagues were, and I'm up to speed on it. And actually, some of the folks you'll hear from later were here, and some of you were here because this committee supported this bill. So this is an effort that we actually started almost 7 years ago, trying to ensure that eyewitness identification procedures were uniform across the state. And just a reminder on the importance of that. I know I said this in my comments, but of our DNA exoneration, so people that we're able to exonerate with DNA, we're able to see other contributing factors when we have an exoneration. And 69% of those had a misidentification. That's really huge. The fact that people who were exonerated through DNA later were shown to also have been misidentified really is very telling, and shows us that this is something that we need to be ensuring best practice. So we're preventing this from ever happening. So what we did was we began working with the Attorney General's office and working with stakeholders in New Hampshire to say, what do we need to do to get a model policy in place? And to their credit, the Attorney General issued a model policy in 2015. And it really captures what we call, I already said this, the core four. It captures these best practices. And my understanding is that the understanding of us and of the Attorney General's office and of the stakeholders who were involved at the time was that, including the New Hampshire Police Chiefs Association, who deserve a lot of credit and have done a lot of training on the policy, is that a more prescriptive bill laying out the remedies would be filed later if we weren't able to ensure everyone adopted it. But we had sort of the word of everyone involved that this will be done. Everyone will adopt this. Everyone will be using these best practices. And that's what's important to us. What's important is that these best practices are followed everywhere in the state. And that is what has not happened. And we've really tried to run this information down, to find out where is this happening. Ask the Attorney General, please confirm that everyone has adopted this policy. And that is what we have not been able to do over the past few years. And I detail that more in the written comments. But that's why we're here today, because we have not been able to confirm that everyone is using this best practice that really does prevent wrongful conviction.
Follow up, please.
Please.
Representative Muse?
Yes. So as I understand it, the remedies that are laid out in this bill really won't have any impact on the vast majority of police departments that are following the policy now.
Oh, that's exactly right. For the departments who are already following the policy, they're already following the policy. So that's exactly right. And what we're concerned with is ensuring that everyone is, so that if someone in one county happens to be arrested, there's much less risk of them being exposed to a outdated practice that puts them at risk of wrongful conviction. We want to ensure everyone is following this policy.
Thank you.
Seeing no hands raised, I want to thank the witness for her testimony.
Thank you.
The chair now recognizes James Testaverde. And this is a reminder, testimony will be limited to 2 minutes.
Thank you, sir. Can you hear me?
Yes, we can hear.
Thank you, sir. Good morning, Representative Abbas and members of the committee. My name is James Testaverde. I'm currently the Deputy Chief of Police for the National New Hampshire Police Department, and I've served the National Police Department for over 22 years. I'm here to testify in opposition to House Bill 436 on behalf of my agency and the New Hampshire Association of Chiefs of Police. I submitted written testimony last evening, so I'm not going to read that verbatim to you. I'm just going to speak to you on a couple of the points that the young lady of the Innocence Project spoke to. First of all, I would like to say I agree with Representative Testerman in his question regarding placing the date inside the statute. I personally believe it's a mistake. For one, there was not an Attorney General's law enforcement manual written in January of 2019. The newest manual came out in November of 2020. Prior to that, it was 2008. Prior to that, 1993. Prior to that, 1984. I can go on, but you see they're spaced out by decades. And I testified in front of, I believe it was this committee, I'm not saying the same members, in roughly 2018 when this bill was first proposed. And our agency was 100% behind it. So I just want to give you a perspective. In April of 2015, the Attorney General sent out a memorandum saying this is the newest best practice for eyewitness identification. Within months, we began to transition, and within months, the entire agency had transitioned to the newest best practice. That was 2015. 3 years later, I was testifying to say codifying a procedure, a best practice procedure, handcuffs us, pardon the pun, because when the newest best practice comes out, we have to come before you again to amend the legislation. So I believe the statute that you did pass in 2019, that Attorney General's memorandum in 2015 didn't make the manual till 2020. It took 5 years. But as soon as the memorandum hit, coming from the Attorney General, the chief law enforcement officer in the state, we immediately transitioned. Secondly, I know you'll probably hear, I'm assuming you'll hear from many attorneys. I'm not an attorney, but I've been doing this for 2 decades and I've spoken to many attorneys. This bill is looking to place remedies in case these measures aren't followed. Ladies and gentlemen of the committee, in my humble opinion, and I have attorneys agreeing with me, this occurs every day in every court across the nation. Eyewitness identification is a piece of evidence, along with physical evidence, DNA evidence, witness, victim, suspect statements. I can go on and on. If they're not obtained properly, the judge can place different amounts of weight or make them inadmissible. The judge also at trial turns to the jury and explains to them how much weight that they can or can't give a piece of evidence. I've been taught this, and I've witnessed it dozens, if not hundreds of times. So I personally believe the law we have is good. I'm behind the Innocence Project. As far as this is the best practice, we're adhering to it and have been since 2015. And I don't think we need more laws in this scheme. I think we need more education, training, and funding for law enforcement so that we can have positive and ethical outcomes. I'll entertain any questions. Thank you.
Thank you, Mr. Testaverde. The chair would ask a question, and I want to thank you in advance for taking my question. Can you explain how many police departments have adopted or are currently following the best practices?
Sir, I cannot. I can only speak to mine.
Thank you. Representative Marston?
Thank you, Mr. Chairman, and thank you for taking my question. So as I understand it, what you are saying is that this piece of legislation is not needed because it's redundant. We already have it on the books.
Precisely, sir.
Thank you, sir.
And if I just may ask a follow-up question from the chair, and thank you again for taking my follow-up question. So I guess my question would be, how would the departments be required to actually adopt the best practices if it's not written in the law?
Mr. Chair, that's an excellent question. And my answer is this. If you step away from what we're talking about today with eyewitness and pick any other, pick DNA evidence, pick a statement, because they've been conducting interviews for hundreds of years. If we do not adhere to the law, the best practice, NASH was accredited 459 best practice standards, over 200 standard operating procedures, a 555-page, roughly, Attorney General's manual, on and on and on. If I obtain any piece of evidence that's contrary to any of those documents in my training, a judge can, if he or she deems it appropriate, put lesser weight on the evidence or make them non-admissible in and of themselves. I hope that answered your question.
Thank you. Representative Burke?
Thank you, Mr. Chairman, and thank you, officer, for testifying. if I'm reading the bill correctly, there's really only one, well, other than the date change, on line 4, if you have the bill in front of you, it says that they want to remove day to such lineups. I guess I'm confused. Do you know what that means? You know, what would be the difference from they to such lineups? And what would that do to your job?
Having not crafted it, my opinion when I read it is that they wanted to be more specific, and they might have been too vague for the drafters' liking. I don't think that line, the way I read it, would affect us. As I said, and I agree with you, sir, the date, I believe, could be problematic because it wouldn't allow us to fluidly transition to the best practice. And I think that the remedies are redundant.
Thank you, sir.
Thank you.
Representative Knight?
Thank you, Chairman. Thank you, Officer, for taking my question. And thank you for your service to our state. I just want to know, because another representative asked you if you know if this was being followed, best practices in the other police departments. And I heard that you didn't know. Now, with that data being missing, how can we make it our responsibility and hold the state accountable to best practices everywhere if this were to pass?
Representative, I understand your question, and that's why my example before was the Attorney General set out a memorandum. If an agency reads the memorandum and says, we don't agree, we don't think that's best practice, we are not going to use it. Any defense lawyer, any prosecutor seeing that that agency or that officer was not using the best practice will come up in court, which is how the system is set up. That would, in my opinion, be evidence, because an eyewitness identification is evidence, obtained, I don't want to say illegally, but at the very, very least, inappropriately, contrary to best practice, contrary to the opinion of the Attorney General. And having seen how it works firsthand, I would be shocked if a judge said, yeah, that's no big deal, we're going to allow it in. Because I've sat through these procedures where if we're supposed to do A, B, and C to recover a knife used in an assault, and I skip over point B, that knife might not make it in. And that's this is such a huge risk to ignore the Attorney General when they come out with a memorandum. And that's why I gave the example. The memorandum came out in April. It hit my desk in May. We immediately transitioned the Detective Bureau. I have our standard operating procedure in front of me. I actually testified before the committee and brought all these documents, emails I sent out department-wide. I'm just not able to say which agencies automatically adhered, but if they do, I don't know how their evidence and their identifications are ever going to see the light of day in court.
Follow-up, Chair.
Representative Knight, you're recognized for a follow-up question.
Thank you. Are these best practices defined in our law, or are they, like you're saying, they're made up per department? When you get the standard operating procedure that you just told us about, is that law?
It's not, to my understanding, it's not law. The law, well, I'm going to backtrack on that. The law says we have to follow the Attorney General's protocol. The Attorney General's protocol spells out step by step what the procedure is. If you deviate from that, you're not following the AG's procedure. Therefore, in court, that could be shown that that's not a proper piece of evidence. It wasn't obtained properly, if I answered your question.
Sorry, third follow-up, if I may.
Representative Knight, we do have to limit members to 2 questions each per witness.
Understood, thank you.
Representative Newman?
He's not, he's still muted, Mr. Chairman.
Thank you, Mr. Chair, and thank you for the witness for taking the question. Is your concern about the way that this this bill is currently written a function of the date or is it a function of the inclusion of the new section about remedies? And that's my question.
So the date, I believe, is problematic for the reasons I stated before, as far as impeding future best practices that come out. If we had it codified back in 2015, I'm sorry, if we waited for the law in 2015 when the Attorney General's memo came out, we would have waited 3 years to transition to the standard instead of doing it immediately. My problem with the remedies is they occur, and I guess I would say if we put these remedies in this bill, then I would sit here and say, please go through every criminal RSA and add the same remedies when it comes to any type of evidence. It's already happening, but I don't know why you would do it for this bill and not aggravated felonious sexual assault, burglary, arson, so on and so forth.
Follow up, Mr. Chair.
Representative Newman?
Yes, thank you. Would your concern be not as great if the way the date was worded was maybe the current version, and if the remedies were removed from this bill?
Yes, sir. If the date was removed and the law said we are to adhere to the Attorney General's current best practice, I personally believe somewhere in there should be a grace period, and I would even be fine if a date was determined, because we have an agency of 180, Manchester State Police. Large agencies can't do it overnight, but I'd be fine with a reasonable grace period. And yes, if the remedies weren't there, I read the current law. I really have no issue with it, other than it doesn't mention anything about a grace period, and there is a mention to the actual manual, which changes every decade.
Thank you for that answer.
Thank
you.
Representative Conley?
Thank you, Mr. Chairman. Thank you, sir, for taking the question. The current bill does have something of a grace period in that it would take effect 60 days after passage. Is that sufficient time, you think, for a grace period, or is more time needed based on your answer to the previous question?
So based on the answer, and please correct me if I'm wrong, I thought the 60 days from the passage was the date the law took effect. When I say grace period, what I'm referring to is not the law. What I'm saying is, if a new best practice comes out 2 years from now, and there was a grace period for all the, because I believe, to best of my knowledge, there's over 300 agencies in the state, knowing that Nashua cannot adhere to a new best practice within a 24-hour span. If it said, when the Attorney General comes out with a new best practice, law enforcement will follow it, they will have X amount of time to adhere to it, I think that would be fair. And I'm saying that to show it's not that we're against the Innocence Project. When I testified 3 years ago, I said everything they said is accurate. I'm just afraid of codifying a procedure. We're on board with the best practice.
Thank you. Thank you for your testimony. Representative Muse, I see your hand is raised, but we are going to limit questions by members to 2 questions per witness.
I have a question.
Representative Gathright?
Is there Christina Swams in that signed up to testify? She's the executive director for the Innocent Project.
Christine Swan?
Yeah.
No, there was a member from the.
Yeah, I thought 2 were testifying. That's what I'm asking.
Sure. So do you want to talk?
Yeah, no shares there.
Yeah, Shear's here.
We'll get started with Albert Shear.
Okay.
Is it Buzz?
Yeah.
Okay.
Can everybody hear me now?
Yes.
My name is Albert Scher. I'm a professor at UNH Law. I've been in the criminal justice system here in New Hampshire in various capacities for the last almost 40 years. relevant to this particular bill, I teach a course about police investigation and the Constitution, a foundational course called Criminal Procedure, which included in that course is the constitutionality of eyewitness identification procedures. I've submitted, my opinions are mine only, not those of UNH School of Law, nor of UNH proper. I've submitted written testimony, so rather than go through the written testimony, let me try and capture some of the answers to questions that have been raised and comments that have been made. You know, the Innocence Project has been trying to help implement this reform and collaborate with the Attorney General's office for 7 years. 4 years ago, I helped write a survey that was sent out to every single law enforcement agency in New Hampshire in anticipation of the original bill. And eight law enforcement agencies responded as to what their practices were. We then drafted a bill, the bill that, and originally we included remedies in it, and then we negotiated. We had a meeting at the Attorney General's office, which I attended with the Attorney General's office, with 3 members of the Police Chiefs Association, and they said, not to worry, everybody's going to comply with this. We do not need remedies, period. And that's why remedies were left out the first time. 4 years later, the Attorney General's office surveys, collects the information from all the police departments, seeks to collect information from every single law enforcement agency in New Hampshire about whether they're following this policy as the statute requires. Only 45% of the law enforcement agencies responded to that survey. So we do know that 55% of law enforcement agencies that are not responding to whether they're following the policy or not. Included in those who did not respond to the request of the Attorney General's office is some that are following it, like Nashua. Nashua did not respond. So the measures, the remedies that are implemented here are mild. They don't require that if you don't follow the policy, it be suppressed or the jury must ignore it. It just says they can consider it. Under current law, it's up to a judge to decide whether the eyewitness identification procedure has been suggestive, number one, whether it's been unnecessarily suggestive, number two, and whether the identification, even if it was suggestive and unnecessarily so, is otherwise reliable. That's what a judge needs to consider. This adds to that the judge may also consider whether they complied with the Attorney General's best practices. That's all this does, and it allows the jury to also consider it. It's a mild remedy for failure to comply. I know of no judge who's ever suppressed an eyewitness identification because they didn't comply with some policy. They look at the identification itself and see whether it's suggestive and unnecessarily so. So we need these remedies to get police departments in New Hampshire to tell us what they're doing and whether they're complying. It's really simple. It's really straightforward. It's closer to housekeeping than anything else. Lastly, I hearken back to when this original bill was before this committee. Those of you who are on it, I'm sure remember the testimony of Jennifer Thompson. Jennifer Thompson woke up one night in North Carolina being raped. She was scared for her life. She did not expect to live. And she promised herself, if I lived, I'm going to remember everything I can about what this guy looks like so he can be found and prosecuted. She lived. She described the person to the police. She picked a man named Ronald Cotton out of a lineup and she identified him at trial. He was convicted and sentenced to prison. Several years later, post-conviction DNA testing found that he could not have been the person who sexually assaulted her. That's why compliance with best practices is so important. Those of you who were on this committee back then, I'm sure remember her testimony, which was overwhelming and very powerful. And so I strongly encourage the police to follow these practices, but I strongly encourage this committee to vote ought to pass on this. I'm more than willing to entertain questions.
Mr. Chair, you were the beneficiary of a negligence of the chair to keep track of the time, but
I keep trying. I'm afflicted by being a law professor.
If I had to guess, that was over 2 minutes. Representative Bolden, you recognize for a question?
Thank you, Mr. Chairman. I was a little late today, so I'm catching up, but I wanted to ask if the witness is telling us that the consequence of current practices could be that a victim does not successfully identify their assailant and the victim does not get justice. Is that what you're telling us? That and so conversely, if we successfully change the guidelines, that we would have more justice? Is that what you're telling us?
Yes, I think by adopting this, it makes it more likely that those police departments who are not following the best practices of the Attorney General's office will follow them, and there will be more justice both for victims where the right person will be prosecuted and for those who may be wrongly prosecuted.
Thank you. Seeing no hands raised, I want to thank the witness for his testimony.
Thank you.
Last one. Cynthia? Yes.
Yes, so I'm Cynthia Musso. I'm from the New England Innocence Project and formerly of the Public Defender's Office in Manchester. And I just wanted to sort of reiterate a couple of points that Buzz made, and he sort of made them, but I did want to sort of weigh in and reiterate that the reality is, and one of the things I think that we get tripped up on is that there seems to be this sort of idea that this is kind of a punishment to the police, when reality, this is a protection afforded to innocent folks that are facing wrongful convictions, in our system. And it's also an affording of protection to the victims of these crimes. There's a crime in Massachusetts that we represented the defendant in, where he was identified by 5 separate people in 3 separate sexual assaults. And the practical reality is DNA post-conviction testing revealed that he was not the perpetrator of those assaults. Unfortunately, this was so long after the fact that there had these victims who their assailants were never found. These were brutal stranger assaults in Massachusetts. We're really left without justice, as was our client, who was sent to prison, lost his entire military career, and lost all of his hopes and dreams on the basis of these witness identifications in cases where the procedures that are proposed to be put in place were not put in place. It certainly would not have been a punishment to anybody had the procedures kept out these eyewitness identifications, because the correct person could have been found earlier and the wrong person would have been able to go home. And I don't want that point to be lost when we're thinking about the importance of this bill.
Representative Muse.
Thank you, and thank you for taking my question. Can you tell me how the remedies that are in the bill would actually reduce the odds of the situation that you described happening? So a person is falsely accused by 5 different people, and the conviction is later overturned by DNA evidence. How do these remedies lower the risk of that actually happening to an innocent person?
Yes, that's a great question. I think that the important thing to recognize is that what we would rather be doing is correcting these things before people are sent to prison rather than after, right? And so any protections that we can put in place that are going to ensure that unreliable evidence isn't put before a jury is critical in making sure that that pre-conviction process is followed. In this particular case, for example, if the procedures had not been followed and the judge, as the gatekeeper of that evidence, had prevented that evidence from going to the jury, there would have been no evidence against our client to convict him in the first place because there was no forensic evidence that led to his conviction other than this eyewitness testimony. So the practical reality was there would have been no evidence in that case, and our client would not have gone to prison in the first place. Often our post-conviction statistics and the things that we learn in these post-conviction cases highlight the deficits of the criminal legal system that happen pre-conviction. And that's certainly the case with this type of evidence.
Thank you.
Representative Newman?
Thank you, Mr. Chair. My question is, is it your opinion that if we leave the remedies in this bill, it will be more effective in what what the Innocence Project is trying to accomplish?
Absolutely. I can speak to this both as a public defender and as a representative of the New England Innocence Project. The practical reality is that these bills can go into place, but without any remedy, the bills become somewhat meaningless. In other words, if the court doesn't have a way to act on the bill just becomes something that is kind of ethereal. I, as a public defender, was not even aware that this bill had been placed when it was originally put in place, but this remedy will definitely make it accessible to criminal defense attorneys in a way that they can use this in defense of their clients when there is, faulty eyewitness identifications.
Follow up, Mr. Chairman.
Recognized for a follow-up.
Thank you. Is it also your opinion that the fact that some police departments do not comply with the law in a timely manner is a different issue, and that this bill, as it is right now, it does not address that issue, and that is not a problem for you?
The fact that police, I'm a little confused about your question, but I'm going to say is the question that the timeliness is, whether the timeliness is material or not?
So Newman, you may clarify the question.
Yeah, I believe that you're saying that these remedies have to be in there, and my opinion is that the Professor Scheer said that there was a problem because people didn't respond and people are not complying. But that's a completely different issue that we may address some other way other than amending this bill to take care of that. That's my question.
The timeliness, I think, and the non-compliance, the reason that those things are important to be, together and to be here, I think, is that the reality is that again, I mean, I think the fact that the police departments haven't complied with the statute is completely related to the reason why we need a remedy written into the statute. I mean, those things are interrelated. I mean, that's the proof is in the pudding right there, right? At the end of the day, if there isn't going to be compliance and there isn't going to be proof of compliance, this is why we have to have a remedy. Otherwise, the bill becomes meaningless.
Thank you.
Representative Knight, you recognized for a question.
Thank you so much. Thank you for taking my question. When people are falsely accused, as I understand it, the state gets sued and our taxpayers put the bill for non-compliance happening in our police departments. Is that true?
Are you asking me if when people are wrongfully convicted, they can sue?
Yes.
Representative Knight, we can clarify. Thank you.
I mean, I think the practical reality of, is it possible? I am not a civil attorney. I'm a criminal attorney. So that would not be something I would ever give anybody legal advice about. The practical reality is that there are a number of immunities that exist that insulate and protect police departments and the state from answering and having a lot of accountability as far as non-compliance goes. And so the practical reality of suing, whether whether there's a bar to it or not, is that those suits are very rarely successful, even to the extent that they are initiated in the first place.
Representative Knight, you recognize for a follow-up question?
Thank you. So what you're saying is that it's even harder to identify and people to make their cases when they're actually wrongfully convicted as well, not adding insult to injury on top of the people of New Hampshire having to pay out of pocket for the police officers' mistakes on not following a compliance protocol.
Right.
Thank you.
Representative Marston?
Thank you, Mr. Chairman, and thank you for taking my question. Let's say that we got a crime, and let's say we got a couple of eyewitnesses. Eyewitnesses are going to be examined by the prosecutor and going to be examined maybe even by the defense attorney prior to the court hearing. Is that the understanding of how the law works?
So, of course, that's the nature of the trial process. What we've learned from statistics over time and what we've learned from wrongful conviction cases is that people's memories are actually scientifically very unreliable, and that the crucible of cross-examination, which we rely on so often in criminal court to suss out truth, is not always very effective at doing so. The practical reality is we all believe the things that we think that we saw with our own eyes, and explaining to somebody that that's actually not accurate is really difficult. And explaining that to jurors is really difficult as well. It's very often that folks are not lying. The issue is not that we think people are lying. The issue is that people's memories are mistaken. The 5 people that identified our client in Massachusetts as the guilty person were not lying. They just didn't remember correctly, or they didn't remember the details correctly. There's a number of different factors that can kind of go into that. And certainly, yes, people can try to cross-examine, but that's really insufficient. And it's why we need the judge as a gatekeeper and why this remedy is so critical in situations like this.
Oh.
Representative Marston, you recognize for a follow-up question?
Thank you, Mr. Chairman. The question just needed a yes or no, but let me go on to say, the prosecutor is going to examine an eyewitness first.
Representative Marston, when a question is asked to a witness, even if it is directed really to be a yes or no question, we normally don't want to instruct the witness how to answer. It's not
It wasn't intended that way.
My apologies. You may stop the question.
My question resolves in that the prosecutor gets to decide whether somebody is credible or not credible. The defense attorney gets the chance to do the same thing and present that kind of an evidence situation. But let's be honest, the eyewitness, no matter how many of them there are or how little there is, if there's only one, they too have a right to testify. And this is all about credibility. With that all being said, it's so big and subjective, there's no piece of legislation that's ever going to resolve the truth in the matter. That's my question.
The practical reality is there is not one statute that's going to solve all the problems of the criminal legal system, but it doesn't mean that we shouldn't make efforts in small ways that would make dents into inaccurate information being presented to a jury. And the reality is, although we know that, at the end of the day, prosecutors and defense attorneys actually don't make determinations about credibility. That's left up to the fact finder and the jury. And what we're trying to do is to give the jury the most accurate and truthful information, because we don't want the jury to make decisions and make choices about people's guilt or innocence and about their lives based on information that's demonstrably false or has been coerced through violations of the Constitution.
Thank you. Seeing no further hands raised, the witness is excused. Are there any members of the public who wish to testify that are in attendance that have not already testified? Seeing no hands raised, we will now close the public hearing on House Bill 436. And Representative Muse, would you do the honors of reading the sign sheet?
Yes, Mr. Chair, there were 15 people who signed in support of the bill and 4 people who signed in opposition.
Thank you, Representative Muse. We will now close the public hearing on House Bill 436. At this time, we will open the public hearing on House.
Mr. Chairman, point of order.
We're not in any.
Well, when I'm still at point of order, I want to recognize, Chair, to recognize.
You have a question. Parliamentary inquiry, Mr. Chair.
Thank you. We didn't do our pledge of allegiance at the beginning of the meeting. Can we do it now?
Representative Marston, first of all, thank you for reminding me of that. I do apologize for, we did not do that. If everyone doesn't mind, may we be recognized, I'll recognize Representative Marston to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Chair, my question, would it be appropriate to find a suitable and respectful location for the flag? I have a hard time seeing.
It's going to be moved back.
Oh, okay.
Yeah, the flag is only moved to the middle for the Pledge of Allegiance. However, the negligence of the chair, I forgot to recognize Representative Marston. Hence, the flag was in the middle room blocking the view. But you always can see me on the computer, aren't you? Unless you want to see me twice. At this time, we will open the public hearing on House Bill 270 relative to the post-conviction DNA testing. Representative Conley, you're now recognizing Mr. Bill.
Thank you. Sorry for my eagerness.
Watch out for those wires, please.
Mr. Chairman, committee members, I am Casey Conley, State Representative from Dover, here now to introduce HB 270. This bill contains some modest enhancements to New Hampshire's existing post-conviction DNA testing program, which this committee has seen before in a bill from last term offered by the former committee chairman. This bill in a prior term left the Criminal Justice and Public Safety Committee with a 20-0 recommendation. And like many other pieces of legislation that ran into the COVID-related shutdown, it did not advance past the Senate or even to the Senate. So the language contained in this bill does a few important things. First, it clarifies the existing statute on how someone would petition for this type of redress, specifically the court in which they would sort of make their request. It includes a provision to assign an attorney to someone who pursues this type of testing, but only if they meet, who is indigent, and only if they meet existing rigorous requirements to qualify for this type of relief. It clarifies the process for testing the biological material, what labs would be used, how the results would be shared with the state and with the person seeking the testing. Another important point to note is the bill lets people who have completed their sentences but who believe they were wrongfully convicted can request this testing in an effort to clear their name. Person, like all others who might apply for the relief, would still need to meet the existing standards for their request to move forward. So a little bit about why this is necessary. We've become accustomed to this idea of DNA and biological evidence being sort of everywhere, and we see that in CSI and other TV shows, but the reality is not many cases have DNA evidence. And we're talking about a small number of cases where this type of redress would likely be requested. And the number of cases where the individual would qualify and where the biological evidence would be enough to exonerate someone is really a tiny fraction here in New Hampshire. We also have seen, I suspect many of us, news accounts of people exonerated for serious crimes like murder and rape through DNA after serving long sentences. One caveat is that here in New Hampshire, nobody has been exonerated through these means. And while I'd like to believe that that means nobody in our prison system, past or present, was innocent, the data nationwide just suggests otherwise. Passing this bill would give someone who finds themselves in this terrible situation a method of seeking their freedom or their clearing their name. Safeguards in the statute would already protect the state against frivolous claims or attempts to pursue this redress. And finally, while the bill does contain a fiscal note, the Judicial Council has reviewed this, and based on the very few number of DNA testing requests in a year, the fiscal note does indicate, quote, an insignificant increase in expenditures. I asked the committee to recommend passage of the bill. I will take questions. I'm also happy to cede the floor to experts who are expected to testify after me. Thank you.
Representative, yeah.
I just had a question. The new material on this, was that already voted on in the previous bill, or has this been updated or changed since the previous bill?
Thank you, Representative. My belief is that this bill was not significantly changed. I don't know if a word or two changed, but the concept, the broad concept has not changed.
Representative Marston.
Thank you, Mr. Chairman. Thank you, Mr. Conley, Representative Conley, for taking my question. I heard you say that, to the best of your knowledge, you don't think that this has taken place in the state of New Hampshire where somebody has been exonerated because of the DNA testing. Is that correct?
Representative, in my job as a reporter, you learn not to say something is the first or the only, because there's always one that someone will come back. That is the best of my knowledge that a DNA has not cleared someone. I suspect if I was incorrect, somebody will correct me in testimony, and I will certainly correct to the committee.
Representative Marston, you have a follow-up question?
Thank you, Mr. Chairman. So my follow-up to you, Representative Conley, is this is not to address a wrong and trying to right it. It's being proactive ahead of time in case it should happen.
Thank you, Representative. We have this process on the books already. This essentially it's really a housekeeping bill in terms of aligning our existing statute with best practices from other states. It's not a radical reforming. It's really just cleaning up the statute in a lot of ways.
Representative Testament.
Thank you, Mr. Chairman. Thank you, Representative Conley. Is this a capability now that will end up with less, in this case, the prisoner's DNA is in some larger database? Can other agencies access this and maybe make a connection with previous crime? In other words, this person, is he opening himself up to prosecution? Like happened out in California with Gold, whatever it is, guy crossed, they ended up with his DNA and they found out who he was.
Representative, I don't have a good answer to that question. I believe in the California case, it was a family member that they tracked him down through. I could be wrong on that, but I don't know enough about what's in place with DNA in our state, but I suspect other people might be able to answer that.
Okay.
Seeing no further questions, the Representative Chu, thank you for your testimony.
Thank you, everybody.
The chair will recognize Elizabeth Powers.
Mr. Chairman, I'm not seeing her.
Hold
on, no, Sergeant. Somebody else. Oh, she's back. Hold on.
Hi, good morning. Can you hear me?
We can hear you.
Fabulous. Thank you.
Testimony will be limited to 2 minutes to members of the public. We will do a better job of enforcing that this go around.
Yes, I will be quick. Thank you so much. Thank you for the opportunity to testify again and on this bill. I really appreciate it. My name is Beth Powers. I am the State Campaigns Director for the Innocence Project, a national organization dedicated to exonerating wrongfully convicted people through post-conviction DNA testing and reforming the criminal justice system to prevent future injustice. This committee heard and unanimously passed this bill last year, and we thank you for your support and again ask for your support this year. Nationally, there have been 375 DNA exonerations. However, none have occurred in the state of New Hampshire, which is what Representative Conley just stated. That does not mean there are not wrongfully convicted people in the state. It means that we have not had any exonerations proven through DNA. HB 270 would clarify and modernize the current process for seeking DNA testing post-conviction. This change would not make it easier or lessen the standard by which a conviction is overturned, but would rather simply create a clearer path for obtaining DNA testing. These changes not only benefit the wrongfully convicted, often in the course of settling an innocence claim, the actual perpetrator of the crime is also identified and therefore prevented from committing additional crimes. Changes to the existing post-conviction DNA testing law would enable justice for the few who have experienced the unique horror of wrongful conviction, who could benefit from proving their innocence through DNA testing. For those few, this bill is monumental. I've provided written comments that detail the changes proposed in this bill, along with national context. I won't go into that now in the interest of time, but I'm happy to answer any questions. I thank you and urge you to pass HB 270.
Thank you, Ms. Powers, for your testimony. The chair would ask to inquire of a question, and I want to thank you in advance for taking my question. This is more of a nationwide question, but your organization has handled a lot of post-conviction cases involving DNA. How often or how difficult is it for that DNA to be provided for, testing?
I would say that is going to completely depend on the case and on the state. There's a lot of factors to consider. How old is a case? What is the evidence preservation in the state? Are they required to preserve the evidence? If someone, oftentimes our clients who are exonerated have served 10, 20, 30, 40 years in prison. So we're talking about very old crimes. So I would say that it's going to depend on so many factors. One of the reasons this bill is so important is because being able to actually get the testing is so critical. That's why this is so important. New Hampshire's law right now is significantly out of line in terms of how hard it is just to request the testing. Imagine being in prison for something you didn't do, thinking there's DNA in your case and wanting it tested and not being able to get that tested. That's what this is about. But to answer your question, there's just a lot of factors that will change that answer state to state.
Thank you. And when it comes to testing of DNA or any biological substance, do you know the approximate cost of that test?
I think that's also going to be dependent on where you are and in the state. It really can vary. I know that it can be a costly process, but in regard to this bill, the number of folks this would apply to is really small. And so I think that Representative Conley spoke on this, on the fiscal impact, and I think you'll hear from Buzz later, who anecdotally can speak to the number of these types of claims he has seen. And my understanding is it's in the range of 10. It's a really small amount. So I don't think that, the systems that are already in place to do the testing are there. They exist. This is not building anything new or anything like that.
Thank you for taking my question. Representative Testerman?
Thank you, Mr. Chairman. Thank you, Ms. Powers. I have a question. If one of your clients were to submit his DNA for testing and it would ended up collected in a database, could the law enforcement people, if there was a match, prosecute him for some other crime, possibly?
That's a good question. I think that's something that someone would have to weigh out in making this decision. I think that someone who's incarcerated and sitting in prison for something they didn't do is probably willing to take that risk. So yes, I think potentially if you tested someone's DNA and it came back, I'm not aware of it ever happening. I'll say that to you. That doesn't mean it hasn't, but I'm not aware of it happening. But I think more often than not, you have a circumstance where someone knows they didn't do this and they're sitting in prison. And so they want this tested. But what has happened, similar to your question, is we've had instances where someone is innocent, we're able to finally test the DNA, and it matches someone else in the system. It's often matched someone who's currently incarcerated for something else that could have potentially been prevented if that person had been correctly identified in the first place. So that it does happen that hits come back and match to someone else.
Thank you.
Thank you. Seeing no hands raised, I want to thank the witness for her testimony.
Thank you.
Oh, excuse me, Representative Knight, you had your hand raised?
I did, but I was too late. I'll respect that you closed it out. Thank you.
Chair now recognizes Albert Shear.
Good morning again to the committee. My name is Albert Scher. I'm a professor of law at UNH. The opinions I express are my own and not those of UNH Law or UNH proper. This area is central to my area of expertise. I've been litigating and lecturing and training and writing about forensic DNA evidence since the early 90s. I handled the first DNA case in New Hampshire. I've worked on a 13-year-long Innocence Project case. I'm going to make every effort possible to not take 2 minutes. The number of cases that that there even is available biological evidence is really small. You don't see DNA evidence, with some rare exceptions. You don't see it in drug cases. You don't see it in any financial crimes. You don't see it in most burglaries. You don't see it in most assault cases that are not sexual assault. Usually you see biological samples of unknown origin in sexual assault cases and murder cases. Those are important cases, but it's a small subsection of all the cases out there, number one. Number two, going forward, and certainly in the last 5 to 10 years, where DNA testing has been used far more aggressively by prosecutors' offices in this state and around the country. So going forward, you are going to see less retesting of DNA samples because it's already been done. There may be a few here and there where there's an allegation that mistakes have been made. So going forward, you're not going to see that many. Finally, I've done an informal survey of over 200 criminal defense lawyers in New Hampshire through a listserv in which I participate. None of them have litigated have even applied for have litigated the availability of post-conviction DNA testing under the statute. Some of them know of inmates who have tried to make their way through the statute and failed because process-wise, it's a good bit more difficult than we want. But practically speaking, this is a housekeeping measure that makes it simpler and clearer for what few prisoners are out there who may wish to avail themselves of it, do so. Finally, in answer to Representative Testerman's question, everybody who's convicted of a felony in New Hampshire is obligated to give the state of New Hampshire a DNA sample. So the huge majority of circumstances, their DNA is already in a state genetic database and the national genetic database. The irony of it is their DNA is in there, but under the current statute, it's really hard for them to get testing of the biological sample. So I think that's really the best answer for Representative Testerman's question. Hopefully, Mr. Chair, I came under 2 minutes.
I don't want to ruin your day. But if I may ask, the chair may ask a question, and I want to thank you in advance for taking my question. It's my understanding this would change the standard from clear and convincing evidence to, is it preponderance of the evidence?
Yes.
So, do you mind explaining to the committee the difference in those two standards?
Yes, preponderance of the evidence is it's more likely than not that the proposition that is being put forward is the case. So it's, it's 50.00001% is more likely than not. Clear and convincing evidence is somewhere between preponderance of the evidence, and beyond a reasonable doubt, which is somewhere over 99%. Clear and convincing evidence, oddly enough, the best way to characterize it is to play with the words. You need to be clearly convinced. It's hard for somebody to convince another person that they are to be clearly convinced of a proposition, particularly in these circumstances where judges they don't have very much availability to evidence, and what you're trying to establish is, well, the proposition is it's the case that this would likely provide exculpatory evidence, even though I was convicted. And so to have a clearly convinced standard, a clear and convincing standard, is a pretty rigorous standard. I think those people who try and quantify these standards think it's somewhere over 75%. But, I'm not a big fan of quantifying numbers, but, it's somewhere over 75%, which, for little reason, puts a substantial barrier in the way. I mean, I think we all now recognize that with these statutes in other states, the floodgates are not opening to frivolous efforts to get DNA testing, given all the other protections. And there's no reason to put so substantial a barrier as clear and convincing evidence in the way.
Thank you for taking my question. If I just may ask a follow-up question, I want to thank you in advance for taking my question. To your understanding, and this is an approximation, how much does it cost to actually do the DNA test?
In a state like New Hampshire that has a forensic DNA laboratory, it's a trivial marginal cost to do one more round of DNA testing. I couldn't even put a figure in it, but their lab is set up to do this testing. It's just them doing one more test, and they do hundreds of tests a year. If it had to be sent out, I've seen it cost anywhere from $500 to $1,000. In the first instance, that would be paid by the individual if they were declared not indigent.
Thank you for taking my question. Representative Hopper.
Thank you, Mr. Chair. Thank you, Professor, for taking my question. A couple of times in the legislation, it refers to RSA 526:4, which seems to put a 3-year limit on the ability for somebody to petition the court to check their DNA. Is that a problem, or?
Yes, it is a problem, and that's one of the things we've attempted to fix with this legislation. There's no logical reason that there should be a 3-year limit on filing a claim for post-conviction DNA testing. There are statutes out there that govern how long the state needs to preserve evidence after the conviction is final and there's no pending motions or court actions. And that's what should govern how long a person has to file. There's no logic behind a 3-year limit. And the goal of this legislation is to take this statute out of that 3-year limit and let it depend on the availability of the biological evidence as governed by other statutes.
Thank you. Representative True.
Thank you, Mr. Chair, and thank the witness again for taking my question. You know of any instances in the state of New Hampshire where somebody in custody or somebody who's no longer in custody has asked for that DNA testing to be done and the courts have denied them to have the right to have it tested?
I know of cases where pre-trial lawyers have asked for DNA testing, and for one reason or another, the government opposed it and the court did not order it. It's not very common at all, but I know of those kind of cases. There are cases where the government, after they arrested an individual, there's a famous murder case out of Hopkinton in which They arrested an individual for killing a young girl, and they were considering charging that individual with capital murder. They sent the testing out for DNA testing down to the FBI, I believe, because they didn't have a DNA lab at that point in New Hampshire. And the testing came back exculpating the individual. So that's a good example of the more prosecutors and judges allow pre-trial DNA testing, the less people will need to take advantage of this statute.
Seeing no hands raised, I want to thank the witness for his testimony.
Thank you.
I believe we're on to our last witness, but if there are any other members of the public who wish to testify that are in attendance, please have your hand raised. Chair recognizes Cynthia.
Hi, my name is Cynthia Musso. Good morning again. I am the representative from the New England Innocence Project, and I am a former public defender in New Hampshire for a number of years. I had some comments prepared, but I wanted to highlight just a couple of things. And I did submit written testimony as well, so I don't want to go over that again. But what I want to highlight, what I really want to reiterate here is that these amendments make very small changes that would be very impactful for the innocent folks in New Hampshire that are unable to access DNA post-conviction testing at this point. I think the reality is one of the things we've been discussing today is numbers. And my understanding is that the reality is there have been, and I want to commend Representative Conley. That's right. There are no DNA exonerations in New Hampshire at this point. The reality is that even though we know that, it's not reflective of the fact that New Hampshire is in fact a perfect system, but rather that the malfunctions that actually plague the criminal legal system are just as present here. And the reality is we're not catching these. We're not catching them. And these amendments to this statute are going to make it more likely that we're going to catch these cases and be able to help some folks that have been wrongfully convicted of crimes. But it's still very, very limited. And there's some sort of natural limits that are already in place, which have been discussed today, like as Buzz highlighted, the cases that haven't been, that don't involve DNA evidence, the preservation statute, which is RSA 651D3. There's also the fact that people aren't going to access the statute unless DNA is going to be exonerating. So the reality is if folks just because you have DNA in your case doesn't mean the statute is going to be something that you're going to access. So the changes are small, but the impact for folks that have been wrongfully convicted is great. And the reality is that justice for the victims is also at play. And I would reiterate that there are a number of cases. We just had a case in 2019 in Massachusetts where we had a DNA exoneration. The DNA was entered into the system and the actual perpetrator of the crime was found that way, as Beth discussed in her testimony. So the consequences are really significant in terms of justice, and the changes are very minor.
Thank you for your testimony. Seeing no hands raised, the witness is excused. If there are any members of the public who wish to testify, that are in attendance, please raise your hand. Seeing no hands raised, we will now close the public hearing on House Bill 270.
Support,
Representative Muse, you want to do the honors?
Sure. We had 26 people sign in favor of the bill, including Catherine Cooper from the New Hampshire Association of Criminal Defense Lawyers, and we had 2 people sign in opposition.
Representative Muse, do you mind repeating that?
Yes, we had 26 people sign in support and 2 people sign in opposition. And one of the folks who signed in support of the bill was Catherine Cooper from the New Hampshire Association of Criminal Defense Lawyers. She's somebody that we've heard for before on this issue.
Thank you.
Thank you, Representative Muse. At this time, We're gonna open the executive session on House Bill 270. That's literally the bill we just heard.
Yeah.
Representative Conley, you are recognized.
Thank you, Mr. Chairman. I would move on to pass on HB 270.
I'll second.
Has been seconded by Representative Marston. And just for the members at home, this is not a rule, but maybe as a better practice, during the executive sessions, maybe want to just keep our videos on, just to make sure it would make my jobs easier here.
Just back up 1 second. I did not have the paperwork in front of me just yet, so Representative Conley made the motion of about to pass.
About the pass, and I believe that was seconded by Representative Marston.
Thank you.
Representative Conley, do you wish to speak to your motion about the pass?
Mr. Chairman, there's little I could add that would be better than the remarks from the witnesses just now, so no, I just hold off.
Would anyone else, I'll open the question up for discussion. Representative Rhodes.
This isn't really a question, I guess it's just more of a statement. I really don't see anything negative that could come from this. You know, if as Representative Testerman, asked if is there the option of being found guilty for another crime with the DNA, but I think you're only on trial for that particular crime, right? So that, I don't really think that would come into play. I think you could probably answer that better, is what I'm trying to say, but.
Well, it's just like any other evidence, I'll say. I'm not speaking about any specific case that I haven't worked on, but if I'm gonna request something and if I know that it's gonna incriminate, the defendant or my client, there is somewhat of a discretion to not request, at least advise the person, are you sure you want, one that comes up often unrelated to DNA, but a drug driving case. If the person really is impaired, do you really want to request the booking camera? It may not necessarily help you in your defense by asking that to be produced and preserved. So sometimes it's within the discretion of the attorney, but that's just one example. But just regarding this, in throughout the country, these cases, some attorney generals have taken these all the way up to the Supreme Court of their state, and they spend hundreds of thousands of dollars trying to not produce evidence that's in their possession, which if it's not exculpatory and it's only going to prove what they already know, I understand there's no harm in producing it, but there has been exonerations throughout the country where people have been in jail for 10, 15 years. There was one out of Florida involving a hair sample. This person was in jail for 18 years, and this was actually a case worked on by the Innocence Project. And it's a little complicated, but the hair sample, I suppose when someone passes away, you can tell by their hair after a couple hours that they passed away within a certain time period. Well, the hair sample that they had inside that linked the the defendant to the case, it was taken post-mortem. So when the person was charged with murder, that hair sample wouldn't have been there. So they were actually able to prove that the evidence they were planting. Although that person did get a very high civil judgment thereafter, I believe it was $18 million. They did spend 18 years of their life in prison for a crime that it was proven they did not commit. And the reason why it took so long was that it took decades to get the DNA tested that everyone already had. And this is not Florida. They must have spent more money defending that case in Florida. And then civil judgment there, this never should have gone on that long. They had it the whole time. I would be supporting off the pass. Representative Hopper.
Yeah, this is just because I'm new to the committee, I'm kind of curious. The reference to 420, whatever.
What line?
I don't know, I'm just not looking on my tablet, so I have no idea what line it is. 426:4 says that there's a 3-year limit. Obviously, it doesn't apply to this. But why is there only a 3-year limit? Why would people be able to appeal their conviction?
Line 19.
much later than 3 years, that's kind of problematic.
Yeah.
When was that put in?
I don't know, I've already kind of moved on beyond that, so I don't know if I can look it up.
I don't know when it was put in, but it actually says this is with, notwithstanding the RSA, so it's kind of eliminating the RSA, which is good.
And you want to eliminate the 3-year period, which this does, and the reason for that is that some of the DNA technology that existed at the time of the conviction may not exist in the present time. So there are circumstances where the test you would be asking for didn't exist within that 3-year window. Well, that particularly is more relevant to cases from the early 90s, mid 90s, but it's still a good idea, I would say, to keep that.
Yeah, that's really not my question. My question, I understand that this bill says notwithstanding, so therefore it ignores 526:4. But what I don't understand is why there 526:4 has a 3-year limit. Why would they do that? I'm just.
I understand the question. That may be an issue for this committee to discuss on a different day. I mean, because
it just seems very short period of time because people can find something out 10 years after and say, wait a second.
I think that's something that we all should look into. And I think it's, now that it's been raised by Representative Hopper, let's all do it, and I think we'll discuss it. Representative Muse?
Just one thing that I wanted to say, I'll be supporting this bill this year, just like I did last year. But one of the things to note is that this is a very good bill that addresses a very, very, very small number of people. And hopefully one of the outcomes of a bill like this is that somebody who may have been wrongfully convicted will be released. But it is interesting to note the way that this bill was paired with the previous bill. And the fact that many more people are subject to eyewitness identification and sometimes improper identification. So the potential impact of the bill we heard earlier is significantly greater for a wider range of people. So I just wanted to kind of note how the bills seem to work together. And I know we're not talking about the other bill, but I guess I'll leave it there. Just
yeah.
I support this bill. Thank you.
Seeing no hand, Representative True.
Thank you, Mr. Chair. I certainly, I don't know, not really a feel-good bill, but we're addressing an issue that's never happened in New Hampshire. We're addressing an issue that no one has ever been denied the opportunity to go back, even after when you're released from jail, to go back and have DNA tested. Nobody's ever been denied that. Nowadays, DNA is very common. I mean, I would think most defense lawyers would be looking at DNA testing if they're for their innocent clients. So it's a great idea. It's a great bill. That means little to nothing in New Hampshire. Okay.
Well, I respect the comments of the representative. I will just explain that what this is doing in our justice system. And I respect our system. I believe in our system, and I work in the system, and I stand by it. But I will say there are limited occasions where a person is wrongfully convicted. One wrongfully convicted person is too many. And I would think that this, if it did happen, this puts that person in the best position to right or correct that injustice. And the fact that it hasn't happened yet doesn't, just because it hasn't, we haven't proven it that it's happened yet, doesn't mean it hasn't happened yet. I'm not implying that it's happened anywhere in the future, but I would say being proactive on this would be the best approach. Because if someone spends a decade incarcerated, keep in mind, if you have an innocent person in prison, and most likely we're talking about rape or murder, and you have the wrong person in jail, that means there is a chance that there is a murderer or rapist out in the public who is actually getting away with that crime. So there's really two injustices there, because the victim of that and the victims' families, you know, they deserve justice too, to have the actual correct person prosecuted in charge of the crime. So I think it really, we owe it to the public as well. That's just my opinion. Representative Burke?
Thank you, Mr. Chairman, and if you could answer one question before I spend 68 seconds on my speech, you could stop that. It's up to the AG. I mean, the AG could fight if somebody wanted to do this test. Is that correct?
Yes, they have the option to object to it, or they can consent to it. And
okay. All right, and may I continue then? All right. Now that I understand that, which I thought that's what was the case, I can't remember who the presidential candidate that lived in Goffstown, she was on the Democrat side.
Tulsi Gabbard.
Yeah, she mentioned an AG in California on the debate stage where she did exactly what we're trying to prevent here. So what my point is we really can't control the future. If we don't do anything, we can't control the future AG person in New Hampshire if they went rogue on us and started doing this like the California AG did years ago. So I'm thinking, why not support this because of that situation? You know, right now, it probably hasn't happened, but we can't control the future AG office. But this law will control it.
That's an excellent point, Representative Burke. Seeing no hands raised, the clerk will now call the roll. The question is ought to pass. If you were in support of the motion of ought to pass, please say yay. If you were opposed, please say nay.
Vice Chairman Welch,
Yes.
Representative Burke,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yay.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston.
Yes.
The clerk votes yes. Representative Harriet Gathright,
Yes.
Representative Pantelakis,
yes,
Representative O'Hearn, Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes, yes,
Representative Bolden,
yes,
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
yes.
Chairman Abbas.
The chair votes yes.
Mr. Chairman, with only one person being absent, we have 20 to nothing.
By a vote of
I'm
20
sent.
by a vote of 20 yeas and 0 nays, the motion of ought to pass is passed. We'll move to vote on consent. Representative Conley, will you be writing the, you still call it a majority report, but
Absolutely, Mr. Chairman. Thank you.
thank you. This time, Representative True?
Thank you, Mr. Chair. Could you explain what's the cutoff of when a bill with an FN can go on consent and when it can't go on?
Excuse me, that's a good question. This can't go on consent, can it? This one.
Oh, what does this one affect?
Zero.
Zero.
Indeterminate, no, not zero, indeterminate.
No, undetermined.
Indeterminable.
All right, and just so the members understand, and before we take a million questions, unless you know the specific answer to the question, please don't raise your hand. But my understanding is that in order for something to go on the consent calendar, it cannot have a fiscal note.
You are correct.
So this has a fiscal note of $0, but it's a fiscal note nonetheless. Of course, right?
It says on the end of that fiscal note, there would be no impact on state, county, or local revenue, county.
What I'm gonna do is that we'll put this on consent for now, but I will consult with the clerk to confirm the answer. If it's not, it would have to be taken off consent. I'm just
Yeah.
gonna state that.
I just wanted to mention that there was testimony that the defendants would have to pay for the testing. And the other piece of that is that the state, if they're the one that's trying to prove it, of course, they're gonna have to pay.
We'll put on consent, but I will be sure to consult with the clerk on that. Representative Newman, is this regarding that specific issue and you have an answer for it?
No, I have a question of the chair, just. Joe.
We might be able to do another executive session, but okay, what's the question?
I understand that. I'm just concerned about, or I have a question about, there was a issue raised in this bill about the time limit and that it was very short. And in this time of time restraints, I was going to vote for this bill and maybe we could fix that later. Is that a right approach to that, or is there?
That's a question that I would be offering my opinion or advice on how. If I can control how you voted every single time, Representative Newman, it would make my life a lot easier.
If I didn't understand you, I didn't hear your comment.
If I could control how Representative Newman voted all the time, it would, I'm just a joke, but never mind, not funny. Moving on.
Thank you for your answer.
We're just gonna wait to 10:45, which is in 1 minute, and we're gonna start. the public
Depends on
hearing.
which clock you want to use.
You have 1 minute left.
Clock on my computer.
Yeah, me too.
Oh,
Those are about
1 minute.
5 minutes apart.
Yeah.
GMT minus 5. I think we should track it. So it's
Okay.
GMT.
It's just this strip here.
I could. It's like, that's one of those representative
Members at home are worrying about us. We're having some heating issues here. It's on full blast, so it's like a sauna.
Well, you can go to Cedar Waters for a dip.
We're 1 foot away from that.
Gary can show, Representative Hopper can show you where Cedar Waters is.
Representative Wallace, I did send a message to Karen and she was gonna see if she could get somebody maybe from maintenance to help us out with it.
Well, that one's set on 76. This one's on 71. They're both at 68.
Yeah, but they won't stay, that's the problem. You have to set them, then set them, lower them and set them. I tried, but I can't get it to work.
I'm just
Open
gonna,
the window.
Can't you just set it? and-
I'm just gonna sweat it out.
Is that the Emerald's air fryer?
Are you warm?
Oh, yeah. It's nice though, it feels like summer. All right, let's take our seats and we can start on HB
I can
525.
make a motion if you guys can take off your jackets.
I wouldn't move forward to address those. At this time, we are opening the public hearing on House Bill 525 relative to the seizure of personal computers and other electronic devices in child sexual assault cases. The chair is going to recognize Representative Marston to introduce the bill. If there's any members of the public who intend on testifying that are in attendance, please raise your hand now.
Thank you, Mr. Chairman. And thank the fellow members of this committee for hearing me. I've got a little story to tell you because this bill, as it's presented, also has an amendment to it. We'll talk about that in a moment. The reason the amendment came about was because when I put this request into OLS and they sent it out to me, as you all know, you ask for a bill, they research or what have you, and then they send it to you for your approval. Well, I waited and waited and waited, and I never got anything back from OLS. So I ended up inquiring what happened to my request for a bill. Well, we sent it to you 14 days ago. Oh, what address did you send it to? My old 4-year-old email address, which was a legislative email when I was up here before, and I had long since deleted it. And now I've got that all straightened out with the state so that people know, just send it to my regular email. So when I finally got it, I only had 3 days to approve it and get it back in, or it would have died off. So I just went ahead and said, yes, it's good, let's go. Then when I read it some more, I realized there were some mistakes in the bill, and that's why the amendment is there. But now let's talk a little bit about the bill and what it's about, because I'm a firm believer that we have bills presented to us that try to rectify problems. If there's no problem to be solved, why have a bill? Well, in this case, it's a very serious problem. I believe it, and I've been involved with Little Leagues, and so I know about child sexual abuse. Not that I've done it, but I know that there are people that do it. My point is that this case came about because of a constituent of mine who came to me and said their child was sexually abused. The person that did it was arrested, was convicted, and is in jail. I believe he got 2 consecutive sentences, running, I guess, one after the other. So he's in there for a little while. This started way back in 13, if I'm not mistaken. And I've got a lot of notes here from the parents that they gave to me. And what they're looking for is not any more to do with the case and the predator. That's done and over with, and they're happy with the results. But they had one question from the get-go. They asked the police when they went into his apartment, and he was an acquaintance of the family, and arrested him. And they knew the story, the police did, that this happened on this guy's couch with a computer looking right at the couch and all the technology. Now, this was not an ordinary computer. This was something that was handmade, or to that extent that somebody created it and put all kinds of devices into it and on it. So you could end up being able to take either photos or videos. And this was in the room where the molestation occurred. The police didn't impound or confiscate the computer. They didn't ask for a warrant. The prosecuting attorney didn't do anything about this guy's computer. Now, mind you, the parents are jumping up and down at this time saying, we want to know if our son has been videotaped or had pictures taken of him in the process of this crime. And everybody ignored them. They got to court. They asked the judge the same thing. And he said, oh no, you don't have a right to do that. So I take that a predator, a child molester, has more rights than the parents of the kids to know if they're going to be posted on the internet. Does that make sense to any of us? A predator has more rights than the parents to know if their kid is on the internet. And everybody is saying, no, we don't want to look at that. We're not interested. Well, the parents are. Not for their case. They just know it happened to them. They don't want it to happen to some other parents, some other children. And we know, and I know, having been a president of a Little League and looked into, I one time went on site to find out how many predators were in the district that my Little League was in, and it was somewhere in the vicinity of 150 to 200 predators around Little League fields, et cetera, et cetera. So they're out there. And they love taking pictures, and they love putting it on the internet. And we gotta find a way to stop that. And so the section about computers and pornography and child exploitation, they're there. If they had gone in and looked at this guy's computer and found pictures, images, or video, that would have then became also a federal crime, as I understand it. Now, I'm not a lawyer, and I could be wrong, but I understand it could be a federal crime, which would enhance the penalties. That didn't happen. So the bill as it is asking that we seize the personal computers and electronic devices. A law enforcement officer who has probable cause to believe that the personal computer or other electronic devices is being used to violate any provision of this chapter may, now here's where I messed up, without obtaining a search warrant, seize such personal computer or other electronic devices. So my amendment changes that it has to have, it's not without a warrant, there has to be a warrant, and then they can seize it. And they're only seizing it for the purpose of looking into the computer. Somebody who doesn't have a gripe in this, it's not the parents looking at it, it may not even be the law enforcement people. What they want to do is look in this guy's computer and find out if he's got images, and he's playing around as well after he's done the molestation. Now, this molestation happened to this young man about 5 years. And maybe a parent is going to testify after I get done to just give you some of the flavor from their point of view. So I found that this is something that I like to ask a question when people bring a bill up. What are you trying to solve? What are you trying to do? And what is the cost? To go to the last part of it, the bill does have a fiscal note, and it's just an estimate, a guess. I would tell you, I read it, of about $10,000. Now I don't understand how that comes into play, but I don't want to not point out all the parts of the bill. So I want to have the amendment brought up, and I'm assuming that can be done at this time, Mr. Chairman?
No, it would need to be offered during the executive session, but if I understand your amendment, and if I can just maybe clarify the testimony, the original bill on line 6 contains the language without obtaining a search warrant. That same language on the original bill appears on line 13 without obtaining a search warrant. Is it my understanding that the amendment, which is amendment 2021-0170H, all that does is change line 6 and line 13 of the original bill by saying after obtaining a search warrant?
Correct.
Do the members at home have a copy of the amendment? And if they can just give me a thumbs up, a thumbs down on the video.
We have it here in the chamber. You have one at your desk.
Yeah, we'll provide one for Representative Cromie. The people here, it's the easy way. I'm talking about the.
And I asked Karen to send it out.
Thumbs up and thumbs down. Seeing no reactions. Representative Marshall, may continue your testimony.
Okay, thank you, Mr. Chairman. Thank you for the help. So I know that this is kind of a strange piece of legislation, but I hope I've explained where I'm coming from, and this needs to be resolved in some manner. Unless people here kind of think, oh, we're just child molesters. Well, if we catch them, we catch them. If we don't, we don't. And the materials can be on the internet for the rest of humanity. And that's the question and the problem that I'm bringing to you. And with some corrections to this bill, I'm seriously hoping that we can get this into a situation of ought to pass with an amendment. And I will take any questions that the members wish.
Representative Gathright?
I don't know, maybe it's me, I think I'm confused a little bit. So the whole essence of this is that if they believe people are dealing with child pornography and everything, or exploiting children, you want to make sure that they have a warrant before going in and confiscating, let's say, their laptop. Is that what you're saying?
Representative, yes, in a few words, yes. The question really came down to, this man was arrested, but at the time they went into his apartment and arrested him, they didn't take the computer, and the parents were saying, take the computer, we want to know if my kid's on it. And so they would have needed a warrant. Let me give another example, if I may. If you had a murder and the guy is shot and the gun is on the floor and the police walk in, they're not going to grab the gun. They might have to have a warrant before they can pick it up. But don't it make some sense that they're going to take the gun, they're going to examine it. Who owns it? Has it been fired? Is it the same caliber of the wound in the person? Is there evidence that the guy that's dead fired it because he's got residue on his hand? Or what is the story? They're not going to just look at that gun on the floor and go, oh, that don't mean nothing. What the heck? Guy's dead, but it don't mean it. So they're going to do something with it. Well, what the parents are asking here is, this kid was in a room on a couch while being molested, and this was not just a one-time incident. This went on for several years. The parents thought this guy was okay with their kid. They had already investigated him, but they didn't know what was going on. But in this room is the computer facing the couch, looking at it, and able, if in operation, to take pictures or to take video. And the parents simply wanted to know, is my kid on there? Doesn't that make sense to anybody here who has children or hopes to someday have children? And if they were being molested, would want to know if their kids now been put on the internet? Am I right? Or am I wrong? Did I answer your question, Matt?
Can I respond? Thank you.
Representative Gathright, recognized for a follow-up.
Okay. You want them to take the computer, right?
With a warrant. Yes.
Okay, so if they.
Recognized for follow-up.
Oh, sorry. Yes, thank you. So if they're going in because they believe this person, have these offenses. However, I believe you're saying they shouldn't be going in, period, because they didn't have a warrant? Because when I read the original bill, maybe that's where my confusion is coming in. It looks like they seize the property on the original bill when they go in. Because they believe the person is guilty of computer pornography and everything else. So however they went in, I'm assuming that they might have had a warrant to go in, or they might have just gone in because somebody called and complained and just said, my neighbor, has been touching my child or whatever, and they go in. Typically, they would take the computer. But you're saying if you didn't have a warrant, don't take the computer. Is that what you're saying?
Yes and no. The complaint that got the police to go in to arrest this man had been done many times. The parents had complained to the Manchester Police Department, and they had looked into this matter, and then they finally determined that they were going to arrest this gentleman. And when they walked in and they arrested him, I'm assuming, I don't know police procedure, but I'm assuming they have the right to arrest somebody without a warrant. That's my understanding. But they don't have a warrant to grab his computer, and therefore they didn't touch his computer. It would be the same thing in the sense of the gun on the floor. They going in to arrest somebody, but they're not gonna grab the gun because they don't have a warrant to pick up the gun. They gotta stop everything. We go get a warrant from a judge.
I can't fit out that way.
That's fine. I have no objection.
Whatever that is.
I'm hoping that they answer.
Representative Castellano.
Thank you. So what you want is for automatically when they go in to arrest a suspected child molester, to make sure they always take the computer so that they can check to see if there is anything on it. Is that what you're asking for?
Yes and no. No, if the guy's got a computer in another part of the house or in another room, no, don't, you have no right to go touch his computer. But if where the molestation is taking place in that room and he's got a computer facing that couch, which in this case, that was the case, there is no way of knowing whether he did or he didn't. It would almost need an independent person to look into his computer and not be looking to see what other things he's doing, but is this child in his computer on video or pictures? That would make sense because it's not just indiscriminately, but it is that they should have a warrant to still take his computer because it was a part of the crime. It was used in the crime, not his computer in another room, in the room that it was being done.
Computers and or the components from computer can be anywhere in the house. They could have been used previous to that particular time. And my question is, I'm of the belief that you ought to seize all the computers, take a look and see if there's a problem. You know, wouldn't you want something that just says mandatory and if there's something there, fine. Particularly,
I would agree with you, but I've talked to lawyers and I've talked to people and I've talked to the police. And I go back to a statement that I made in presenting this piece of legislation. The criminal has more rights than you, me, the children, the parents. They got more rights than we do.
News? Did you have a question?
No, Mr. Chair, I waive my question.
Senator Pantelakis? See your hand up.
Thank you, Mr. Chairman. Thank you for taking this question. This, to me, sounds like we are telling the police what procedure they should do in making an arrest. So am I correct?
Thank you for your question. Somebody has got to tell somebody what to do when you make an arrest and you see the weapon, if you will, or the instrument of the crime. Do you not think that be the case?
Yes, I do, but further question?
You recognize for a follow-up question?
Do we know for sure that that computer was never taken?
Yes, absolutely.
Thank you.
Representative Kleindienst?
Thank you, everyone. Thank you, Representative, for taking my question. You know, the last couple of bills that we just heard hearings from on protocols of documentation and procedures on evidence gathering, wouldn't that streamline the process for this problem specifically and solve future problems across the state and make sure that indeed we are gathering the correct evidence?
Thank you for your question. And if I understand you correctly, yes, that is correct.
Thank you.
Representative Green.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. What you, what you're saying is without a warrant, that this could be thrown out at any time. But because there is a warrant and they have the evidence, then it makes the case solid.
I would say so, but I'm not a lawyer and I'm not in that profession. And that's why myself and the family that's brought this to me, that's what we're trying to figure out and see if we can't solve a problem, because they never, ever, that computer still exists today to the best of their knowledge, unless somebody, as the father said, unless somebody has, as of recently, which makes no sense anyways, but taken the computer and thrown it in the Merrimack River. But yes, that's what we're trying to solve.
Thank you.
Seeing no further hands raised, I want to thank the representative for his testimony.
Thank you all, and I hope my parents end up having a chance to testify. Thank you.
Chair recognizes Scott Spence.
Ask them to unmute, Mr. Chair. Oh, there they are.
Hi, my name is Scott Spence. I am the stepfather of the child that was abused in this case. And just to give you a recap, what happened in this case was that, like Representative Marston said, the computer was there and present, and it had cameras that were available on it. The computer does exist to this day. And the reason that we were told that the computer wasn't taken was that in the CAC interview that was taken by my son and my stepson, because my son was the one that actually caught the abuse happening to my stepson. So basically this happened to two children in the course of what happened. They didn't mention the computer, so it wasn't taken. And they actually went to the perpetrator and asked the perpetrator if he used the computer on the children. And he said no. So they didn't even bother kind of going after it. And when we pressed the issue, they went to, the prosecutor did go to a judge and asked the judge, and the judge said no, because it would violate his Fourth Amendment rights. But at this point, the computer was gone from the premises. Basically what we would like to be asked with this bill is that when the time of arrest, a search warrant be issued to go for the electronic devices. So that way they can be checked. So that way another family doesn't go through I guess the not knowing of what we've gone through. And it would bring it to a different level if there was something. If there wasn't something, hey, no problem. There's no harm, no foul, I guess. But there is stuff there. And like Representative Testerman said, if there is something there, then a computer can be moved. So if there's something in the house, it should be checked. So that's what kind of we were asking, is that, and a kid wouldn't necessarily know. For instance, my stepson wouldn't have known if he was being recorded, because not only in this computer system, there were cameras in the monitors, but there was also a camera sitting on top of the monitor. So that could have been turned easily, and he could have been videotaped, and he never would have known. So basically, like, what we were asking is something be issued at the time of arrest. So, thank you.
Thank you for your testimony. Representative Wallace?
Thank you, Mr. Chairman, and thank you for taking my question. I'm sorry that you had to go through this horrible situation. my understanding correct that you'd like to see, to make sure that there's no images of what may have transpired, not so much for the purposes of conviction, but to prevent further victimization of the victims in these types of situations, and to ensure that those images do not get out to the World Wide Web.
Correct, absolutely. We have no idea whether our son is out there in any type of I guess the dark web or wherever, and I really don't have the stomach to go searching either, so we don't want any other child to go through this, or family, I should say, to go through this. And I don't want my stepson to be on the computer one day and all of a sudden there he is. And once these things are out there, it'd probably be very difficult to pull it back, but I don't want it to be not found and be able to be put back out there sometime later on in the future. And if it does, if images are found, it will add to a case against the perpetrator.
Certainly.
Representative Burt?
Thank you, Mr. Chairman, and thank you for your testimony, sir. I'm just curious, could you elaborate a little bit more, because it's confusing to me why the judge would not issue a warrant. I know there is a Fourth Amendment and other issues there, but can you explain a little deeper why the judge, if would refuse a warrant? Because I would think a warrant would be, easy to obtain on that.
What we were told was that both our sons did not mention it in the CAC interview, and that it would violate the perpetrator's Fourth Amendment rights. That's what we were told, and that's as far as it went. And as far as we are concerned, in my view, that was unacceptable. End of story. I think that personally, more investigation should have been either taken, or that something like this should exist so that it could have been taken at the time of the arrest.
Thank you.
And you can't, I'm sorry if I could elaborate, and you can't rely on the child knowing whether or not they were videotaped.
Representative Knight?
Thank you, Chair. Thank you for taking my question. And I'm really sorry that this happened to you and your family.
Thank you.
I just want to go on the record and say, for everyone here, we take this on the committee very, very seriously. And I want to know if you would be okay because the issue really is a lack of streamlined process and procedures of documentation that our police are having in this state. Would you be okay if this issue were to be resolved in another bill?
It all depends upon the wording and such. I wouldn't know. Again, I'm not a lawyer and I don't know how. As long as the issue was, I guess, resolved, where the point where that it was the perpetrator possibly isn't getting away with a crime, and it's basically it's not only what my goal is, not only to help the families in knowing whether or not that images are possibly not on a computer and getting them off, but it's also possibly aiding the police or law enforcement in knowing and getting extra charges on a possible perpetrator. So that's the goal, point blank. So if it's in this bill or another bill, so be it.
Thank you so much. And again, I'm sorry for what you've had to experience, and it's really brave and to come before the state and share that with us. Thank you so much.
Thank you.
Representative Conley?
Thank you, Mr. Chairman. I'm still confused about this bill, and this is a reflection of probably me, but I got some clarity on what is proposed here. I understand this awful situation that the gentleman from Manchester and his family went through, and that's horrifying. But as I understand it, the original bill would remove the requirement for a warrant to seize electronic devices. Is that correct? I'm a question of the chair. I don't know if it's still appropriate. I'm confused. I'm hearing different things. I'm curious what's before us.
Well, Representative Conley, what I'll do, the chair will entertain the question, but while we have a witness on the stand, maybe we'll delay your parliamentary inquiry after the witness is, excuse me.
Thank you, Mr. Chairman.
Representative Muse?
Thank you for taking my question. On past bills, we've heard testimony from folks on the State Police Internet Crimes Unit. And I do know that they investigate crimes involving pornography, children, and computers. And I'm curious if any attempt, or if you know any attempt was made between the Manchester Police and this particular unit, because it would seem like a computer in the same room that the assault took place would constitute probable cause for their involvement. And I'm just curious if that is anything that came up.
No, and actually, we've sort of kind of reached back out to that department recently because of this bill coming up. And basically, it's kind of fallen on its face again because we actually know where the computer resides to this day. And it's fallen on its face again. But that was just our personal thing. And we've kind of resigned ourselves to the fate of that computer and everything else. And that's not the point of this bill, is to get anything for ourselves. It's for the future. So because this bill came up, the Manchester Police chief did reach out to us because he had heard of this bill. And he talked with us about, our case and et cetera. And we did talk to a detective and stuff, and it kind of fell flat on its face. So nothing went forward on that. But one would think that it would do exactly what you said, but no, it did not.
Thank you.
Representative Rodriguez?
Thank you, Mr. Chairman. Thank you for taking my question. I may be dumb about this, but I always assumed when they arrested somebody that they took the computers and whatnot in order to prove their case.
That was our assumption as well, and that is not the case. That's what
Thank you.
We're trying to get out of this bill. So
thank you.
That's the goal.
I'm sorry for what's happened.
Thank you.
Seeing no hands raised, I want to excuse the witness, and I want to thank the representatives. A lot of us have, the ones who didn't speak, I'm sure I can say that we all are sorry for you, what you and your family are going through.
Thank you.
Chief Alan Aldenberg.
Good morning, Mr. Chairman. Can you hear me?
Yes, we can hear you.
Appreciate you listening, giving me the opportunity to speak. This is in fact a Manchester case, and we are extremely sensitive to these cases. And this case, in fact, was thoroughly investigated, and the person received an extensive prison sentence. Obviously not up to the family. It never is in these type of cases. Unfortunately, Manchester Police Department investigates hundreds of these cases a year. We have detectives that are very well versed and trained in this. I'm hearing all this testimony, and at the end of the day, what it comes down to is probable cause. And that's why we went in front of the judge to obtain a search warrant for that computer, and there was not enough probable cause. So if we're trying to circumvent, it's going to be a dangerous world if we're trying to circumvent the search warrant process simply to seize a computer that we cannot substantiate that there's a probable cause to believe that that's evidence of the crime. To me, that's not meant to be insulting to anybody. I'm not trying to dismiss what the family's going through, but at the end of the day, if there's not enough probable cause to seize a computer that may be where the crime took place or another part of the home, based off the investigation, we do what we can do and establish as much probable cause as we can to make an arrest and to get search warrants on any case that we investigate, no matter what it may be. So there's already a process in place, and it's called the Constitution, in my opinion. Thank you for listening.
Thank you. And thank you for your testimony. The chair would just want to inquire with an inquiry, and I want to thank you in advance for taking my question. So if I just understood your testimony correctly, the police department applied for a search warrant to seize the computer, but it was denied by the judge or the court. Was that correct?
That's my understanding, sir.
Thank you for taking my question. Representative Hopper?
Thank you, Mr. Chair. Thank you, Chief, for taking my question. From the beginning of this hearing, I was rather confused, but now it seems like I understand. My question is, a statement and a question. The statement is, I'm sure you're aware that most people who engage in abusing children sexually are also typically have addictions to pornography and all kinds of other crap. Why isn't that nexus between a person who is engaged in sexually abusing a child and the great probability that he also has information on a computer? People stated that the computer had to be in the room, but the computer could be in anywhere, and you could still videotape. So my question is, how can we rewrite this so that when somebody is being, you have substantial evidence that somebody is being sexually abused, that in and of itself is probable cause to seize electronic devices that may have been used in the crime?
Again, I think that would be a stretch without articulating the appropriate level of probable cause to get a judge to sign the search warrant. I mean, there's no way around that. If you do the investigation, if you do or do not establish enough probable cause to get your warrants, that's the world we live in, rightfully so. So I don't think you're going to circumvent that. In this case, in many cases like this, the children go through CAC interviews, very difficult interviews done by trained forensic interviewers that, based off those interviews, they may develop additional probable cause that, hey, there appears to be, in fact, that a computer may have been used. Okay, then we can reapply for a search warrant or amend our initial search warrant to try to get into that computer or computers. But without that probable cause, the judge is not going to allow you into that computer.
Thank you.
Representative Burt?
Thank you, Mr. Chairman, and thank you, Chief, for taking my question. Originally, I think the bill, if I read it correctly, was that you have the right to just grab that computer, and I agree with you, the Constitution would probably come down and slap anybody that did that pretty hard. But now, the amendment says that you have to get a search warrant. Is that the case already?
Yes. So if I walk into your home and there's evidence of the crime that we're investigating, and the representative used the example of a gun on the floor. Okay, there's guns there. It's relatively clear that may have been used in the commission of a crime. We are going to lock that residence down, and we're going to apply for a search warrant before we remove any property from that home. So just because it's going to say, the amendment's going to say you have to apply for a search warrant, well, that's what we do now. And if there's not enough probable cause for a judge to sign that search warrant, then we're not getting into the computer. That's what the process is now. I don't mean to sound demeaning or it's just, that's the Constitution.
And just And just to clarify, I don't believe anyone in the committee finds your testimony to be demeaning or insensitive by any means. We all understand it's a very sensitive subject, but, you know, the Fourth Amendment is written as it is, and I think that's what the chief is saying, and we have to respect, especially law enforcement who are impacted by the Fourth Amendment. So I just want to clarify, and I'm sorry, I didn't perceive anything being insensitive. Chief, we thank you for your testimony. Representative Byrd?
Yeah, just to follow up, Mr. Chairman. Thank you, Chief, for taking my follow-up. Again, with a very sensitive situation as this is, and I'm sure you guys did everything you could to get that warrant. Now that the bill went to that you're going to grab the computers, which would be against the Constitution too, you've got to get a search warrant. You know, I hate to say it, but the bill's really not needed at this point because you have to get a search warrant now. Would that be true?
That's correct, barring any constitutionally accepted exigency. But in these cases, I'm not, you know, I'm not part of ICAC, but we have people that are. But I'd be comfortable to say that 100% of the time, those type of investigations result in a search warrant of a computer.
Thank you, sir.
Representative Pantelakis?
Thank you, Mr. Chairman. In the other representative's testimony, he said that the judge said that they did not mention the computer. Is that the reason why it could not have a search warrant?
That's correct, Representative. There was not enough sufficient level of probable cause for a judge to sign a search warrant to search that computer. Now, that does not mean that, you know, you don't stop your investigation, and, you know, if further information comes forward, then you can reapply for a search warrant. But in my understanding, in this case, there was no additional information to substantiate that.
Thank you.
Representative Newman?
Thank you, Mr. Chair. My question is the way the amendment is written, it says may seize the computer after getting a search warrant. So it seems like you may do it if you get a search warrant. And isn't that the case right now?
Yes, sir.
Follow up?
Representative Newman, you recognize for a follow-up?
So just make sure I completely understand. It does not require you to get a search warrant and seize the computer in all of the cases that deal with the violation of this law.
I want to make sure I understand your question correctly. Are you asking if we'll apply for a search warrant every time in these type of cases if computers are involved?
Representative, you may clarify your question.
Yes, my question is since it says may and not shall, does the law require is it your opinion that this law causes you to have to get a search warrant every time you arrest somebody for this kind of crime?
We would anyways.
Okay, thank you.
Representative Testerman?
Thank you, Mr. Chairman. Is there any law, rule, whatever, that would allow you to assume, and I know this is a difficult word, but when you go into a situation where you're going to arrest somebody for child abuse, to assume that any computers in the area may have been used for that, and having to go to a judge and say, well, I'm sorry, the child didn't mention computers, and therefore I don't have probable cause, to me is a little shaky. I'm just frustrated that there has to be some way to get you to let you go in, seize any electronic devices along with the suspect, and take a look and see if there's something on that that's related to the case. I'm not sure that's a Fourth Amendment issue, but maybe it is. So is there any kind of wording of a law, a rule, or something that would always make that to be the case?
Not that I'm aware of. I mean, I understand the frustration. I understand the frustration of the family in particular. But just to assume that something's on a device and for us to just arbitrarily go into it, and then say if you do that and say you discover stuff that incriminates the suspect and you've done so without a warrant, you've now compromised your case. So again, in these type of cases, a search warrant will be completed. The process is already in place. I don't like to find workaround. I don't like to find workarounds to the Constitution, to be honest with you.
Seeing no hands raised, I want to thank the witness for his testimony. If there's any members of the public who wish to testify that have not testified already, that are in attendance, please raise your hand. Seeing no hands raised, at this time, we will close the public hearing on House Bill 525.
And Mr. Chair, we had 0 people signing in support of the bill, and we had 10 people signing in opposition.
Thank you, Representative Muse.
Makes sense, first draft.
At this time, we're going to open the executive session of House Bill 436. It was the relative to eyewitness identification procedures. It was in a public hearing this morning at 9 o'clock. And the chair will recognize. Come on, I'm gonna take my time. Take it down.
I couldn't have walked away.
President Jaffe, would you have any assistance?
Yeah, I know.
Don't worry about it.
It's crazy. Gets put up in this other one.
I'll be honest, I haven't found it either.
I know, but my notes are on.
Representative Martin, you have a question?
I have a motion.
Well, you're not recognized for a motion.
I realize that.
Then you're not recognized.
So,
Representative Gafford, are you recognized to make a motion?
yes, I move ought to pass on HB 436.
Representative Welch?
I'll second that.
Representative Gafford, do you wish to speak on your motion?
Yeah, I can speak a little bit to it. It was very concerning to hear that the group, what is it called? The Innocent Project had actually reached out to all of our police departments asking for, information as to whether they were even compliant with the agreement. And from what I heard, most of them were not compliant. A deputy chief from Nashua basically stated that Nashua is certified in so many different ways and what have you, but we're here representing the state, not one town or one city or anything. We're here representing the state, the citizens of the state. So with that said, even if only 2 police departments are compliant, it seems like we need to do something to bring the other departments across the state in compliance with the agreement that was made 7 years ago, from what I can tell. So that is my reason for wanting to go forward with this bill, because obviously it's not across the state. And in terms of the concern about the date, I don't know what's the right date, so I can't speak to that. But for what the bill is trying to do to hold our law enforcement accountable for policies that are in place today. So again, I vote to pass with this. And I'm not sure if anybody else read any of the documentation that was sent to us from the Innocent Project as well as from Buzz. And it was quite moving to see that so many people had worked on this and on a very good bill, and that it did pass previously. But here we are again, like a lot of other bills that passed, to go through this all over again. And the testimony of the young lady was really, really emotional to me. So I just hope that my colleagues agree and that we move this bill forward for it to pass.
Representative Welch?
Yes, there was some concern, I understand, during the testimony about remedies for this. Well, the only remedy is the jury shall be instructed as to whether or not there's credible evidence of compliance or non-compliance. There's no sanctions to the law enforcement or anything else. It's just a jury instruction. The judge will have to do that.
Representative Testament. If I just say, for the members at home or participating remotely, if you don't mind just raising your digital hand, sometimes the hand being raised is off the screen. So just, I would raise the digital hand. It's actually easier for the chair and the maybe, I don't know, technical assistance is great.
Yeah, I'm having, the purpose of the Innocence Project, it's a good idea. It's you know, long overdue. And there's a lot of cases of that, you know, innocence has not been properly adjudicated. But here's my problem. We've got a law that wants to fix the Innocence Project, and it's really fixing police procedures or police. They told us these several hundred agencies that we sent something to, some of them didn't respond. Not necessarily that they didn't have procedures in place. We're trying to tell the police to do their job, and this isn't the bill for it. I understand the issue of people being concerned about police not doing their job, and there's some people who are more concerned than I am because I think they do a good job. To use that as evidence to pass a bill, I'm not sure I see a need.
Representative Testament, and thank you. Comment, Representative Burke.
Thank you, Mr. Chairman, and I am going to vote against the opt to pass motion. And the reason is, you know, hearing the National Police officer speak on, and where I'm having the problem is the date. You know, why do we have to back up to 2019? And, you know, the fine representative that made the motion cannot explain that. So I'm stuck on that part. You know, I've supported a lot of things that the Innocent Project has brought forward, and I do support them. I just think this was poorly written in the way they're going down the path is going to be very problematic for the officers or the police. I would have been a lot happier if they said that this was going to start on X date in the future, you know, with all the manuals written to make sure that it's in there. I would have supported that. Just the way it's written, you know, it's just very problematic, as the officer said. And again, you know, I go back to line 4 where they want to remove the "they" to such lineups. You know, there was really no clear explanation of why they wanted that.
I'm gonna do my best to convince both of you to agree with the chair and see how I do it. That's my skills. So I agree, on line 4, you know, changing day to such lineups, I didn't find the original confusing. I think they just but while they're going through this bill, you might as well clarify, if you see language in any bill, it never hurts to make it clear if you see something. You see often like it says he shall do this. They tend to change to say he or she. I mean, it's just clarification. For procedures current as of January 1st, 2019, it was my understanding of the testimony is that every 10 years, an updated police practices manual will come out. So the most current one is January 1st, 2019. I understand that this eventually may become outdated, and I would assume that that would be on January 1st of 2029. Right? So I would think at that time, we would want to maybe revisit that issue then. But you're right, it did say the latest. The problem that's happening, and so if there's a best practices guidelines set out, and when it's being applied, involving identification of witnesses, there's so many little procedures that, I can go on all day about it, but it can lead to false identifications very easily. So when you're encouraging the police to follow the best practices, it's to make the identification as reliable as possible, which would actually support a conviction, not necessarily finding someone innocent. Because that can be, for some crimes, your only evidence to link the defendant to the crime is the identification. If the identification procedure is not followed correctly, and all of a sudden that becomes, discredited, well, now you're most likely going to have yourself a not guilty when you may have had a guilty just because the best practices wasn't followed, or there was a mistake in the identification. I just give a random example when the defendant had a beard. Well, there was a lineup of 8 photos for the identification process. Well, out of 7 of the photos, no one had a beard. So you understand, I said, what is this? Where's Waldo? I mean, seriously, there's not a single person in the lineup that has a beard, except for the defendant. And then, so talk about an easy identification. I looked at them, I thought that was an egregious use of witness identification, and I won't go any further into that. So I'm just explaining, it's my opinion that having a identification procedure followed correctly really serves the public, it serves the defendant, it serves the police, it serves everyone. But why have best practices if no one's required to follow them? It's just an idea. I mean, there's a lot of money gets spent putting this all together, implementing a system. If the majority of the police departments are following this already, that's great. But that just, they will be unaffected by this. That's just my thought. Representative Chesterman?
Thank you. They didn't say they.
Point of order.
Your point of order is recognized.
Thank you. I believe you've called on Mr. Testament before, and the whole committee hasn't had a chance to speak, and you're calling on him a second time?
Representative Marston, the point of order you're raising is taken, and that, by the way, was a correct point of order, because he's actually discussing the rules of the chair and whether they're being followed. Thank you for making a correct point of order. I do appreciate that. There's been a lot of misunderstandings of what is and is not a correct point of order. The Mason's manual does suggest that when you call on a committee member to speak a second time, you're supposed to let everyone speak for the first time. I will say, and I'm going to plead with you to withdraw your point of order. The problem with that is you also want to have a healthy discussion amongst the members as we're in a executive session. Because I was directing my comments and specifically looking at Representative Chesterman and Representative Burke the whole time, in order to keep that healthy discussion going, I would presume it would be more clearer for them to respond right away to those comments. I don't mean any disrespect to any members on the committee, but your point of order is actually correct. So if you don't withdraw it, I'm going to agree with you and then not recognize Representative Chesterman to participate in a healthy discussion. Representative Marston.
Myself?
Are you withdrawing your point? Are you withdrawing your point of order?
May I speak, Mr. Chairman?
I'm out. Are you withdrawing your point of order?
No.
All right, I'm going over myself. Representative Marston, you're recognized.
To my point of order, or am I recognizing?
I'm recognizing you to speak now because you haven't spoken yet.
Thank you. At this time, I'll point out that Representative Rhodes had her hand up as well. on this particular bill.
I'm sorry.
I'm good.
You may be good, but your hand was up, my hand was up.
I noticed.
Okay, so my point on this bill, I always ask myself this first question. I was taught this when I first came up to the State House. What are you trying to accomplish with the bill? What problem are you attempting to solve? Well, as we listen to the testimony, especially from Officer Testament, I may not have his name quite right here, right? Testaverde, he pointed out that the Attorney General's Office of New Hampshire has a policy for how the police department is going to do it. Now, he cannot, as an Attorney General, go out to every little town and village and hamlet and city and tell them, you must follow these procedures. But they are codified. They are there. And like Testaverde said, Nashua follows them. He believes Manchester follows them, being large police officers. The point being that we're not solving any problem with this bill. That's my question, and I will, at the end of it, unless I can get turned over, there's no grievance prior to this, in my opinion, for anything. They never brought up any case where the witness in New Hampshire had a wrong identification. And last but not least, I don't think there's any cost to this bill, but there's none. So ultimately, in my case, and I'm only going to speak to one time, I see no remedy here, and I too will not vote to ought to pass and will be willing to make a motion to ITL. Thank you, Mr. Chairman.
Well, there's an active motion on the floor. We're going to see how that works out. If it fails to pass, I'll be sure to recognize it thereafter. Representative Rhodes, and to the members that haven't spoke already yet, I do apologize.
Thank you, Mr. Chairman. I actually respectfully disagree with a lot of things been said. I think that this is a classic case of if you fail to plan, then you've planned to fail. And just because you don't always have a situation right here, right now, it's also called being proactive. And it seems to me that one thing that is very consistent is there's a lot of inconsistency. I personally have had a situation where, in my prior life, when I sold real estate, I was, getting ready to walk into a vacant home and somebody was stealing all the copper. And, I looked right at the guy and said, oh my gosh, are you seriously stealing the copper? And the guy took off and I had to, go identify him like an hour later. And it was very difficult to do that, and I'm reminded of another situation where I was, someone was talking to me about like a study that was done in a room full of college students that they gave a situation where it was like a really stressful situation, like a guy came in, it was all like a play, and everybody almost describes something differently because everybody's brain thinks differently. So, some people might notice the shoes while somebody else notices the hair. I think this actually does solve a lot of problems that you don't really know are out there until it's too late. So I'll be supporting the ought to pass.
Representative Bordenay.
Thank you, Mr. Chair. I will support the ought to pass, but my preference is that we amend the bill to take out the date. And actually, we could put back the language of latest version, but without those changes, I'm willing to support the bill. Thank you.
Thank you, Representative Bordenay. If I may inquire of a question, would you have any opinion on an amendment that says current as of January 1st, 2019? Or well, never mind, withdrawn. Representative Bordenay, if this was not to be, would you be willing to request an amendment and offer that today?
I would be willing to do so.
Wow, how's it going to be?
And what would that, hypothetically speaking, if the chair may inquire, I hope I'm not out of order, what would that amendment say?
That amendment would put back in, sorry, amendment would remove the strikeout and remove current as of January 1st, 2019.
Thank you, Representative Boyne.
All right.
Thank you, Representative Boyne. Representative Knight?
Thank you. I don't know if this was already said, but I appreciate you hearing the reasons why I'm going to vote ought to pass. The goal, I believe, of our committee and our jobs here is to do our best effort to protect our people and our police from doing the best jobs that they can. And one of the things that came up that was really terrifying that Chairman Abbas brought up is that, like, we have the potential here to have guilty people continue to do the crime because we have the wrong people, because we don't have the proper protocols in place. This would protect our police from making fair cases and getting the actual criminals and make them more prepared so our criminal justice system is working efficiently and streamlining across the entire state. And with all due respect to my colleague across the aisle, I feel like making sure the state is running smoothly in every single criminal justice town and city is the AG's responsibility as part of his job description. So with that, I think this is a definite need.
Before I recognize Representative Kessler, who may want to respond to my comments from 5 minutes ago, I got to call on Representative Newman.
Yes, Mr. Chairman, thank you. And my comment is I would think that instead of having the current version with a date, that just current version would cover it so that when the next current version comes out, it's covered. Thank you.
Representative Kesterman, would you care? Oh, excuse me, Representative Green.
Thank you, Mr. Chair. Reading the testimony of the chief of police, he was quite thorough in his testimony, and he asked that we ITL it.
I recall.
Okay. I feel I'll be voting that way.
Representative Pratt.
In regards to the latest version, one of the things Manchester Police did mention was it takes time to implement any kind of new version. So if the new book comes out, the next day they don't have time to enact this kind of new SOP, new procedure. So it actually needs to be some time after the new book comes out for them to have time to implement. So it should say latest version within 120 days or something like that, getting time to get up for the versions.
Representative Welch.
Yes, these manuals that come out from the AG's office, they don't come out on a regular basis. At one point, earlier, probably 20 years ago, I got a collection of them from the AG's office, and I took them out to the local police in my town, and they were anxious to get them because they hadn't had one for years. They don't come out on a regular basis. I don't have a problem with the date in here, if we go back to the original. But you can't expect the AG's office to be writing these manuals every year, because it doesn't happen. And I think the reason this date is in here is because that is the first time that they caught up with the law that we passed before.
Representative Muse.
I just wanted to respond to something that Representative Green had said about Chief Testaverde. One of the things that he did say in his testimony was that the courts are already holding police accountable for these convictions. And if you actually sort of use the same standard, you know, waiting for a case to get to court and then trying to create a situation where, you know, errors in procedure are kind of brought up in front of the judge and things like that. I'm not sure that that happens in every case and that every lawyer is qualified to do that. And as Representative Rhodes and some of the other folks have said, I think it's really important to have those pre-conviction procedures tightened down as much as we can. And one of the things that we heard during testimony is that, well, one of the ways you know that's happening is when police departments are responding to the survey. And because the response to the survey wasn't that great, and one of the police departments that evidently didn't respond to the survey was Nashua, it's just very hard to know if this is happening consistently. So to me, the remedies seem to be a very good idea. And they also, and essentially, I think one of the other things that we heard is that the vast majority of police departments are already complying with this. This is not going to have a big impact one way or the other, but where it may have an impact is on somebody who's improperly identified or where a procedure has been used incorrectly. So I'll be voting for it.
That's why there's no list. Representative True?
Thank you, Mr. Chair. In this session, I heard people say that there are police in New Hampshire that, in this session, in testimony, I did not hear anyone testify that we had police in New Hampshire that did not follow the AG's memos or procedures. I did not hear any testimony like that at all. I heard testimony that people didn't respond to a survey, but I did not hear any testimony that we had police in New Hampshire saying we aren't going to follow the AG's memos. I did not hear that testimony. Please bear with me if I talk about an amendment that we don't have in front of us, but it has been discussed. And we ought to be very careful when we start changing, when we start talking about the printed manual. Because the printed manual comes out every 10 years, and the AG is updating that manual. He can update that every week. And that updated, his copy of the updated memo by procedures with his memos are part of the procedure. So it's not the printed copy we're talking about. The AG is updating that every day. He can update that manual. I digress. A lot of people talking in testimony about the faulty eyewitness testimony. This bill has nothing to do with faulty eyewitness testimony. It doesn't address it. It doesn't deal with it. Eyewitness testimony is faulty in itself. One of the examples they gave was a poor woman who was being raped, and she tried to concentrate and memorize this guy's face. So she went and she identified him, and she was wrong. Okay, but none of this addresses that. None. Because it's not dealing with eyewitness testimony. It was a sad case, but it has nothing to do with that bill. As far as the remedies, I heard testimony that the remedies are already in effect. The court shall consider. Yep. The court may consider. Yeah, that's all judges' prerogatives. So if and the judge may say if failure to comply with the AG's procedures, that is an admissible item into court, and that is something that can be considered and may weigh evidence at a lower value, or may disallow the evidence. Is there comments were made, is there a demonstrated need? Which is always a very important thing to look at a bill. Is there a demonstrated need for this bill? Is there a demonstrated need that procedures that are already being followed, and if they aren't being followed, the judge rules inadmissible? I don't see a demonstrated need. Is it already on the books? Yes, it's already on the books of the procedure manual issued by the AG and all police in New Hampshire, as he is the chief of police of New Hampshire. All police are to follow his procedures. There's no demonstrated need. It's already on the books. I don't see any purpose for voting OTP on something that already exists in our state now, and I would vote ITL. Thank you, Mr. Chair.
Thank you, Representative True. If I could just, well, I'm gonna let Representative Custin respond, or do you wish to speak, or?
See if I can remember what I was trying to respond. But Representative True summarized a lot of things. This bill is not solving a problem. It's giving a judge some instructions that is not solving a problem of people supposedly not doing their jobs. If we had any evidence of that, we don't have any evidence of that. But you know, I would like to vote for it, but I just don't see a reason for it.
So let me just explain what would happen here. If this is passed and signed to law, if a police officer does not follow the procedures as we stated in the manual from January 1st, 2019, the remedy is, okay, well, what they're able to do in court, this is a pre-trial issue. It's just like a motion to suppress evidence obtained through a search warrant that you believe was outside the scope of the warrant, or the search warrant didn't have probable cause. What this will do is, if they don't follow that procedure, that can be considered as evidence for the judge to consider whether to suppress the identification. If the judge does not want to suppress the identification, the judge would be allowed to provide a specific jury instruction, telling the jury about weighing the credibility of the identification. All this is doing is saying, and if the police are following this already, that's great. I don't believe they keep track of the statistics on how many motions to suppress are allowed on suppressing the identifications, because they're so fact specific to why that particular identification was suppressed. The one that I used an example of, we never even got that far to argue it because it was so egregious. It was just out the door. Sometimes that will happen. But what this does, with an officer that does not follow this procedure, is not, that's not the egregious problem. It's just it does provide an outline remedy of what to do when that happens. And it leaves the judge's discretion. I would argue that there is some discretion the judge has already, but this codifies what the judge can and can't do. And that would actually making the argument of motions to suppress easier for the defense counsel. So I think that's important. So the state doesn't have a remedy. I think it does. But to identify the problem, I mean, this is the issues of identifications. This is a problem that happens in every state, and it's very common, especially when you're dealing with someone who doesn't know. I mean, there's been false identifications that I've heard of that are, and I had a client he was identified, and I was able to prove he was 2 hours away. He worked in the medical field, so the medical documents were time sensitive. So that identification was not even close. Whether that witness was lying or whether that witness was mistaken, that was really what it is, what the concern was. So it does happen, but following the correct procedure, I believe would be easier for law enforcement to really do their job, but also to evaluate the reliability of the organization.
Follow.
You may respond to that. Does anyone else? Good?
We're talking about the judge, not the police. We're talking about the judge has these various options. He had, I'm assuming, and I'm not, and don't intend to get into a court of law, but I'm assuming he has those options anyway. What am I giving him new that he doesn't have? And why am I telling him how to do his job? Is he incompetent?
Well, that's a fair statement, but I would say that applies to all the rules of evidence. So there are codified rules of evidence that apply. And this, I think this gives a fair amount of discretion, depending on how the judge wants to perceive it. And that's really because, and I believe that's the best way to do it, because the actual, the issue of whether to suppress or not, it's going to be very fact specific, depending on how egregious the situation was. So I think we've had enough discussion. Everyone's had a chance to speak. Has already spoke already.
We've got some hands.
Representative Newman has already spoke. Would you like to move the question? And for the members, I'm only going to recognize members who have not spoken already.
Well, I mean, I got new information I want to say.
You do?
Yes.
All right, Representative Newman, you recognize first.
Thank you, Mr. Chairman. I believe I'm agreeing with the chairman. I think that having a list to go by is something that helps everybody to do the right thing the right way and solves the problem. Thank you very much, Mr. Chairman.
Representative Burke.
Thank you, Mr. Chairman. I agree with everything Representative True said, and then my friend Representative Muse, what he was saying too is that, if I understood him correctly, that the police are following this. So again, we come back to why are we doing this? But the biggest reason I'm definitely now going to vote no is a good friend of mine, a state representative, a chairman in this building, sent me Article 23 that does not allow, and it was June 2nd, 1784 is when this was put forth. Article 23 does not allow us to backdate anything. And this is backdated in the bill to January 1st, 2019. So that's against the Constitution as far as I'm reading it.
So the ex post facto clause, let me just clarify. Any retroactive application of laws are unconstitutional. I agree with that 100%. That is a correct statement of law. And the ex post facto clause is the federal constitution also has that. So we have it twice. This is not retroactively going to apply. This does not take effect. This shall take effect 60 days after its passage. So for any mistakes that are made 60 days after this is signed into law, this is not going to apply to them. This is going forward. So this does not violate that. An example of that we had last year was the raising the smoking age on tobacco. They wanted to raise it to 21. Sounds like a great public health reason to do so. However, there was no, it would have applied right away or within a short time period. So if you're 20 years old and you had a carton of cigarettes, what you legally own today would become a crime tomorrow, right? And there was no just compensation for that. And they would have been, that's an unconstitutional case because now you're at the ex post facto. That's the way I looked at that. That was, they were not being compensated for that. They were also being penalized for something that they were doing that was legal. It's called a constitutional case. To apply retroactively, though, would be if you didn't even have the cigarettes in his possession anymore, but he had them in his possession, you still charge someone for what they did at the time was legal. This is not charging anyone with something, and to the extent that it is.
So we are.
No one's being charged with anything. They've already, this is only going to apply 60 days after it takes effect. It's not applying to anyone that's been charged already.
I agree, but we're telling, if you don't mind, Mr. Chairman, we're telling the AG that he has to go back to January 1st, 2019. So in my eyes, we are going back retroactive.
No, that's the date of the manual. All right. Trust me, if it was written that way, I would have recognized Representative Marcy. Really nice, yeah, right away. That, and to be honest, that, I would be surprised that bill, that was that egregious of a constitutional violation would, even be presented. I'm very confident that's not the case here.
That's existing man.
Representative Pantelakis.
Did you hear me?
No.
Did you hear
I
that?
would like to move the question and take the vote.
Would it be the Dean of the House if I recognize Representative Pratt for the very last comment?
Fine.
Representative Pratt?
I just learned today, that's more, Representative True, that document is actually updated regularly by the Attorney General. So that manual they're talking about, it also says the Attorney General can update. So we are talking about a document that is fluid. But we need time after it comes out for the people to implement this. So a fluid document that could change daily needs time after it changes for the wise police departments to come up with procedures and meet procedures that they need. So it does go back to the data again, as Bert was talking about.
It's the understanding of the chair, and I think it's consistent with the testimony, that's only updated every 10 years.
The manual, the Attorney General adds to that manual, correct? The Attorney General adds their SOPs and their manual to that manual. That's, I believe, what the document.
Representative Gathright? Sorry, Representative Pantelakis.
Well, I just want to say. Thank you. I did have confusion around the date, but I'm very clear on the date now that it is a book that's updated every 10 years. So for me, I believe that we need to keep the date because it's not updated for another 10 years, so 2029. And with the testimony from the innocent group from Buzz, if there was a change to this piece of the document, it would have been stated. We had, I think, 4 different emails sent with testimony, and all through that document, nothing of any update to this, and that's why they were expressing that we want this to go through because there are people that are not following their own policy and practice. So we might not be able to, we might say right now today that in New Hampshire, we don't know anyone that was affected by this. However, if this is made law, personally, I think you're gonna see a change. And you will know exactly what's happening in New Hampshire. So for those that are afraid, I would say this is a good bill and it really should be in law as it stands. And I would be curious as to what happens over the next year. And we will still be here together.
Before everyone starts yelling at me and say I'm out of order, I'm just gonna say now, that the chair does, although this is not a public hearing, the chair does have the discretion to ask a question of a member of the public if they're present. And I see Albert Scheer is present. I'm gonna ask a single question, just one, and try to answer as concise as possible. As you can hear us talking about this 10-year manual, it's updated every 10 years. Is that a living document to your knowledge, or is it something that's updated every 10 years? The chair will just recognize Mr. Scheer to just answer that one specific question.
As hard as that is to answer the one specific question, it is it's updated every 10 years.
So
the Attorney General's office may send out a memo now and again on a particular issue, but the manual itself is updated only every 10 years.
So therefore, you do not believe that to be a living document?
Correct.
Thank you.
Can I ask him one question?
That's a lawyer.
It's okay, I'll drop it.
I think we should move the question. We. Is he standing in the hallway?
I don't know.
If he's standing right there, just tell him, once I started, if he's not in the seat, he can't come back in. So I'm gonna give.
Are we gonna vote on this
Yes.
Yes.
without the amendment?
Yes.
Persuasive amendment thereafter, we're still being the committee, we can deal with it.
I got a question to you. So Bud says they send out memos.
Advisories.
Advisories.
Yeah, it's just an advisory.
So if he had received one in regards to this, he would be speaking to it, right?
I suppose so, but it wouldn't necessarily, wouldn't be part of.
Right.
Seeing no hands raised, sorry that took much longer than I ever anticipated. The clerk will now call the roll. The question is, off the pass. If you are in favor, please say yay. If you are opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burt,
No.
Representative Hopper,
No, thank you.
Please say yes or no.
Representative Green,
Nay.
Representative Wallace,
Yes.
Representative Testerman,
No.
Representative True,
Nay.
Representative Pratt,
No.
Representative Marston,
No,
the clerk votes yes. Representative Harriet Gathright,
Yes.
Representative Pantelakis,
Yes.
Representative O'Hearn, Representative Bordenay,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman Abbas.
The chair votes yes.
Mr. Chairman, the vote is 13 yea, 7 nay.
By a vote of 13 yeas and 7 nays, the motion ought to pass. Passes. Representative Gathright, will you be majority report? Will there be a minority report?
Representative Chesterman?
Representative Marston?
thank you, Mr.
Are
Chairman.
you a volunteer? Are you gonna do a minority report?
Yes, I am gonna make a minority report.
All right, thank you. At this time, we will close the executive session. House Bill 436. This time, we will open the public hearing on House Bill 408 relative to employment restrictions for registered sex offenders. At this time, the chair recognizes Representative Herbo.
See here, yes, yes.
Hold on 1 second.
Representative, thank you very much for your patience. Sorry we were running behind schedule, which is usual.
Yeah, my pleasure. Can you hear me?
Yeah.
Great, thank you. So for the record, I'm Representative Kevin Burville from Deerfield, New Hampshire, representing Rockingham 2, serving the communities of Candia, Deerfield, and Nottingham. I'm here today to present to the committee, and thank you, Mr. Chairman, members of the committee, for your time. I'm here to present House Bill 408 relative to employment restrictions for registered sex offenders. This bill was filed at the request of constituents. When you get a chance to check your email, if you haven't already, you'll see there's an email from me citing news clippings from the 2 cases that brought this bill to a head. So There was a bit of a loophole in the law regarding employment restrictions on registered sex offenders. This bill simply fixes that loophole, closes that loophole. This bill, really is not a partisan bill. It passed last year on the consent calendar out of the House, and because of the COVID issue, it was laid upon the table in the Senate where it died. So the bill before you today is the exact same language that was agreed upon a year ago by a bipartisan subcommittee. It was reviewed by, at the time, going off memory, the state police, the attorney general's office, the ACLU, and so at that time, all of this language was agreed upon. And so, like I said, this simply closes a loophole that exists in the current law. And with that, I'll take any questions the committee might have.
Representative True.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. I'm not that good on computers, so before I get to your email, what was the loophole in the law?
Yeah, so I'm not a lawyer, and lawyers actually hammered out most of this language, but it allowed registered sex offenders to be employed in jobs which had them on repetitive, access to minor children, and that was sort of the issue. The first case revolved around a landscaper in Deerfield, and the court ruled that the registered sex offender could work as a landscaper, hiring and having direct supervisory role over minor children, because the language in the law wasn't clear enough to prohibit it. And that occurred back in, give me 1 second, my apologies. I have too many screens open. I might have accidentally closed it. Well, I think it was around 2018, 2019. And then there was a second case that ended up coming out, and that was a registered sex offender who was a ride operator at the Deerfield Fair, again, putting him, in a position of not only repeated contact with children, but, close contact, right? Helping people on and off rides, et cetera. And so it's those two cases that really brought to light the need to clean up the language in this RSA.
Thank you, Representative. Representative Byrd.
Thank you, Mr. Chairman, and thank you, Representative, for taking my question. What happens, and we need to protect the children at all costs, but what happens if this individual works at, Shaw's, Hannaford's, McDonald's, Market Basket, convenience store? I mean, there's kids running around those places all the time. What would happen in that case? Would this proposed law restrict that?
And I apologize to Representative True. Thank you for your question. And Representative Byrd, thank you for your question. So the answer is a most definite maybe. And the reason I say that is it really depends on what the job is, right? So the law is being tightened up so that a registered sex offender cannot knowingly engage in any employment or volunteer service which purpose involves the direct care, instruction, guidance, or repeat interaction with a minor. So it's not that there may be many individual interactions with children, with minors. It's the repeat interaction with a minor. So if the person is a manager of a department that is staffed, with a minor, then no, that person couldn't do that job, because that's the direct supervision, right? Direct care, instruction, guidance of a minor. So no, they couldn't do that. Now, could they be a grocery bagger or a cashier? Yes, as long as the other person or people working that station were not minors. I hope that answers your question. And if it doesn't, I'll take a follow-up, certainly.
Yes, if I could.
Representative Byrd?
Thank you, Mr. Chairman, and thank you for taking my follow-up, because these people have to work somewheres, and usually if you have a conviction, I'm assuming you're working at a lower paying job, which possibly would be McDonald's, but I did see $13 an hour offered. But I guess, how would we regulate that? So the individual doesn't lose his, to end back up in jail once he's, served his time. If he was working at McDonald's, because there is a lot of kids there.
Let's just try to name any businesses or franchises specifically. It just implies the wrong message. I understand we're using a hypothetical.
All right.
And your reference to the business was only in hypothetical.
Yes. Fast food.
Yeah, thank you, Representative, for the follow-up. So, for one thing, I will not agree with the supposition that people under the Registered Sex Offender Program are necessarily in lower-paying jobs. I don't believe there's necessarily a correlation there. The intent of the bill is not to deny people a right to work, a right to earn a living, and to participate in society. The intent of the bill is to make sure that registered sex offenders that are not supposed to be near minors are not employed in occupations that engages with which the purpose involves a direct care, instruction, guidance, or repeat interaction with a minor. So that the person should not be holding a job where they have repeat interaction with a minor. Now, sexual offenses are varied, and I'm certainly not an expert in that area. But one of the things that we know, and I believe is common knowledge, or at least relatively common knowledge, is sexual predators often groom their victims before the crime is perpetrated. And the grooming activity takes place over a period of time, over multiple, dare I say, repeat interaction with said minor. So this bill prohibits that opportunity to be made available to a registered sex offender. So it doesn't preclude them from holding a job which has interactions or potential interactions with minors. What it prohibits is that repeat interaction with a minor, so that they're not working with that same person, each day or each week or each month. And the intent of that is to make sure that sort of grooming and communication pathway is not allowed to create itself. That's the intent of the bill. And that was, I believe that was the intent of the original law, right? Was to prohibit this type of employment. It not only protects the children, I mean, clearly that's our priority here, but it also protects the registered sex offender by preventing them from being in, a situation that potentially could make recidivism that much easier. So this really benefits both populations.
Thank you for clarifying that. That makes a lot of sense.
Representative Pantelakis.
Thank you, Mr. Chairman. Thank you for taking my question. Are you saying that these people should not be in management positions?
Thank you for the question, Representative. And it's a good question, and absolutely not. I am not saying that they shouldn't be, I'm not saying they should be precluded from management positions, but they should be precluded from managing minors, right? Because if you're managing somebody, that is a position that requires repeat interaction with the employee. And if the employees are minors, then that is not management position for a registered sex offender. So, if they're managing the accounting department, which presumably would be staffed with adults, there's no issue there. But to have them be the manager of cashiers or stocking clerks, jobs like that are often staffed by minors, that would simply not be appropriate.
Thank you.
Thank you, Representative.
Representative Muse.
Thank you, Mr. Chairman, and thank you for allowing or for taking my question. One of the things, just looking at the way that the bill is worded, the language that's being struck seems to have taken an approach before of specifically naming the professions that would be impacted or the types of jobs that would be impacted. The changes make it much more ambiguous. And I'm wondering how you think a person would know if they were in a job that they shouldn't be if they had this kind of a conviction.
Yeah, thank you for the question, Representative. So when I originally filed the bill, those exemplars were not crossed out. And that was a decision that was made by the subcommittee in the previous term. And again, this bill passed last year unanimously through the committee and on a voice vote on the floor of the House. It was decided by the subcommittee at the time that to make these examples, because both strikeouts start with including but not limited to. And so the question was, should there be such a laundry list provided? Because that list is not a narrowing of the scope of the bill. It was included language originally to sort of illustrate examples, but both places it struck out, it starts including, but not limited to. And so it was believed by last year's subcommittee that it actually made the bill more confusing to include that sort of laundry list of occupations. Registered sex offenders, when they're released, right, and are allowed to enter into society, they have people that explain to them the do's and the don'ts, right, that they have to follow going forward. So a registered sex offender, if they move from one community to another, right, they have a specific amount of time in which they must notify that they've moved, right? They have to notify the authorities. So all of these, and that's just a restriction on registered sex offenders. There's a lot of them.
Hillside Village residents will remain.
I'm sorry, I've got somebody coming over on the audio. So this is simply another restriction, and it was that's why the in part 2, paragraph B was added as an extra protection, really for the registered sex offender, that they would be notified upon employment of this prohibition. So, we're trying to protect everybody. We're not trying to create added penalties. We're really just trying to make sure that, the registered sex offender is not put into a position that, could potentially cause them to backslide, if you will. And obviously the primary reason for the restriction is to protect minors, the most vulnerable in our community. And so that's why the subcommittee last year had chosen to strike the laundry list.
Follow up, please.
Representative Muse, you're recognized for a follow-up.
And thank you for the explanation. That was very good. Just wanted to confirm that the bill from last year that we're talking about is HB 1462, which was actually heard by the Labor Committee, not by Criminal Justice. Is that correct?
Thank you for the question, Representative. Yes, that was the bill number, and that was the committee that it had been assigned to last term. I never said that this committee is who heard it last year. So I apologize. I didn't make that that clear in my opening remarks. But yes, you are absolutely correct in both of those points.
Thank you.
Thank you.
Representative Conley.
Thank you, Mr. Chairman. Thank you, Representative. The risk of what ifing this bill, something I don't like when people do mine, and I try not to do it, but what would happen if this passes to people who already hold positions that would be covered under this bill, who are, to the best of anyone's knowledge, not doing anything illegal or untoward towards minors who interact? Would they be forced, would they lose their jobs? Or I guess I'm curious what happens.
So if the bill is passed as it's before us, it would take effect next January 1st. And at which point, yes, if a registered sex offender is in an occupation that gives them repeat interaction with a minor, that yes, they would have to change jobs.
Representative Conley, you're recognized for a follow-up question.
Thank you, Mr. Chairman. Representative, thank you. I guess, again, along those same lines of impacts on labor, in the event that one of these individuals is holding a position where they are not interacting with minors, and then a minor is hired by someone other than them, is, again, the individual relieved of their job?
Thank you for the question, Representative. It's certainly an interesting hypothetical. The registered sex offender is required to notify their employer of their status as a registered sex offender. And so the hiring and firing decisions by any business are made by the business owners or managers. So yes, it's not impossible to conceive that a business may choose to hire a minor into a position, and if the manager of that position was a registered sex offender, they would no longer be qualified for that position.
Thanks for the answer. I appreciate it.
Representative Marston.
Thank you, Mr. Chairman. And thank you, Representative, for taking my question, of which I have two, and hopefully I'll be recognized for a follow-up. In the first place, I'm questioning the validity of the last time, according to you, of striking out all of that stuff about, it says, including but not limited to, and then you went on and stated a lot, which I've seen before in many instances on different things, that you really want to be sure, you know that teachers, coaches, little league, people like that, people that work at camp counselors and scout masters and Girl Scout masters, school administrators, why are you striking that out instead of more or less leaving it in to amplify that you don't want them around those kids?
Yes, thank you for the question, Representative. Again, the bill was submitted by me last year, and the committee referred it to subcommittee for work, and it was the decision of the subcommittee, not my decision. Again, these strikeouts were not struck out in the original submission of the bill last year. It was the subcommittee that chose to strike that laundry list. That subcommittee had a working session at which the people that attended was the subcommittee, myself, representatives from state police, representatives from Attorney General's office with specific expertise in this area, the American Civil Liberties Union, and so quite a bit of thought and discussion went into the changes, basically the amendment to the bill that I originally submitted, and it was that subcommittee that chose to strike that language. So whether that language is struck, and to make sure we're being specific, starting near the end of line 9 through 12, as well as the end of 17 and 18, it has no effect on what the bill does, right? It is simply language that lists examples. So whether that language is in or out does not change the effect of the bill at all.
Representative Marston, you're recognized for a follow-up question.
Thank you, and I appreciate your comments to that extent. If I were to consider this bill, I would like to see an amendment put in that would make those changes back, take out those lines struck. I also do like the idea that you have a section 2B, which states about what the public and private employer shall do. And I think that's a great piece of legislation going forward that states they got to make sure if they have, they can't hire somebody if they got kids involved. But it doesn't get into, it does say private or public. And I'm just saying that I think what you're doing is trying to restrict employment. And with that being said, I'd like to see the lines put back in. Would you concur?
Representative Marston, was there a question?
Yeah, at the end I said, would you concur? That's a question.
With the statement. Okay, thank you.
Thank you for the question, Representative. So to be fair, I appreciate the compliment on Section 2, Part B. That language was actually from a former state rep from, I believe, Brookline, who crafted that language. And the next time I see him, I'll be sure to convey your sentiments. If I understand the question correctly, and if I don't, please let me know. The question is, would I, as the prime sponsor of the bill, be open to removing the strikeout that starts at the end of 9 and goes through 12, and removing the strikeout that begins basically halfway through 17 and goes through 18? If that's the question, then my answer would be yes. It would not bother me if a committee member filed an amendment to put that language back in, to remove that strikeout, because it has no effect on the working of the bill. The only thing I would caution, I tended to agree with the subcommittee and with the other experts a year ago that the bill more clear and cleaner without that language in it. But I would not be opposed to that language being put back in as it's shown on the paper in front of us.
Thank you.
Representative Gathright?
Thank you, Mr. Chair. Thank you for taking my question. At the very end, paragraph 3, Roman numeral 3, it alludes only to teachers. Was this whole situation about a teacher?
Thank you for the question. Thank you for the question. If you could just give me one, because this is, okay, it's a very serious matter. If you could give me 1 second just to reread paragraph 3 so I can answer intelligibly, I would be obliged.
Please take your time. You may read the paragraph.
Thank you. So the answer is no. So this bill, let me gather my thoughts 1 second, my apologies. Paragraph 3 is already a part of RSA. So the bill is not whole cloth. The bill was to modify existing RSA. And so what we're doing is, because this is 632 A10, right? 632-A:10. That's the part of the RSA that we're changing. The crossouts remove language from the existing RSA. The bold is inserting new language into the RSA. And that language, which is in a normal sort of 12-point font, is already existing law. So 3 pre-existed the bill last year and pre-exists this bill. So it doesn't change it. The 2 cases that made my constituents request this bill to be filed did not revolve around educators, certified or otherwise. One was a landscaper and one was a ride. I forget, amusement park type rides.
Thank you.
Representative Brian Knight.
Thank you, Chair. Thank you, Representative Verville. Do you currently know how many sex offenders there are employed in the state of New Hampshire?
Thank you for the question. I do not.
So potentially follow-up, sir?
Thank you. You're recognized for a follow-up question.
So potentially, we have no idea how many of these people will be immediately unemployed and have zero resources available in place or structure set up for situational of this occurring. Or do you have any resources available or protocols put in place for maybe a lot of people that we could be putting in a homelessness situation, a starvation situation, or any of these situations that might be out of their control once we discontinue their employment across the entire state?
Thank you, Representative. So you've asked me 3 questions, similar but different. So which question, if I could take them one at a time, if you could give me your questions one at a time. No, if you could re-articulate a question that I could answer, I would be obliged.
This answers the question. And I apologize as the chair. Please ask one question at a time Everyone, member of the committee, you are limited to 2 questions per witness, at the discretion of the chair. Representative Knight, you already asked 1 question of this witness earlier, so please just ask a single question. It's within the chair's discretion to not recognize you for further questions.
Does the state have any available resources for an unknown number that you want to make a law for to provide in the after effect that they will be unemployed?
Thank you for the question. One, I will suppose that the number of individuals that this bill will impact will likely be limited. And I make that statement going off memory of discussions from over a year ago, primarily from the representatives from, I believe it was the ACLU. It might have been a different group that sort of tracks and works with these people. There's been 2 cases brought. It seems very limited in scope. The state does have resources and makes resources available to poor, to needy, to unemployed, and to indigent persons. We have a fantastic food bank. Communities have food pantries. There's other welfare programs that are available to people in need. And so to answer the question, does the state have programs to take care of people that may lose their job for whatever reason? The answer would be yes.
I think everyone on the committee is exhausted with questions. Representative Arnott, thank you for your testimony and for fielding more questions than I can count.
Yes, thank you, Mr. Chairman. Thank you, members of the committee. I appreciate the very good questions. I appreciate your time. I know you're running a little late, and I know you probably want to get to lunch because you have some more public hearings. So thank you for your time, and I look forward to working with you in the future.
Thank you, Representative. Witness is excused. The chair now recognizes Representative Baldessaro.
Thank you, Mr. Chairman. Mr. Chairman, I'm going to try to be brief on this here. I first, for the record, Representative Al Baldessaro, Rockingham County, District 5, which is Londonderry. I first want to say, I want to compliment the chair last year, who, matter of fact, Brian Sullivan, that did a great job on the subcommittee on this bill on making the proper changes, because they're the ones, the committee there that deal with labor all the time, and these different cases understand and knew the needs for this bill. So I have to compliment them because, like Representative Ravel said, this wasn't him that made those changes. This bill was in the hands of the committee, okay, and it was definitely nonpartisan, but I compliment the chair because he was the one that really pushed and did a great job. But anyways, this here bill is more of a housekeeping bill, cleaning up the language, tightening up the language, with many hands in it to make sure that the language was proper. I think it's a good bill. It makes sense. And if you take a look at, I use Manchester for an area. They were asked how many people. While you were talking, I did a Google search on, sexual offenders in New Hampshire. And the first thing that popped up was 2,500 in Manchester. Okay, and then I'm sure I have about 15 in my district here in Londonderry. But the bottom line is they already know, per other laws that are out there, that they do not work with minors. They do not hang out with minors. They do not try to groom minors. Okay, that stuff's already in other laws, because I believe there's about another 5 or 6 laws that pertain to predators. So what is very important as a former human resource manager when I retired from the Marine Corps was Section B, which is important because this is something that human resource management under hiring people should say, that a public or private employer shall either verbally or in writing advise an applicant for an employment or volunteer position. That position applied for may involve contact with minors, which may be prohibited under the section if the applicant was convicted in this way. Okay, any jurisdiction of any of the offenses specified in paragraph of this section. That was dissected with the committee last time, and they came up with some great language, which they're cutting off the pass. They're actually doing the job of the parole officers, because the parole officers already know that their people that they're watching and supervising do not get jobs with children. So that's already done. New Hampshire has a great record of protecting the children. Democrats and Republicans in the labor and in criminal throughout the years of my time have done an awesome job, even in children and family law. So this language already passed. It would have already been in law if COVID didn't come forward, because it already passed the House. We all supported it on both sides. So I'm hoping that we move forward with this bill, pass it one more time, and it's a children's protection bill, basically, and it's just reinforcing the laws that are already in place. And that's all I have, and I will take any questions.
Thank you, Representative, for your testimony. Representative Marston, you're recognized for a question.
Thank you, Mr. Chairman. Thank you, Mr. Baldessaro, Representative Baldessaro, for your testimony. My question is only one. As it stands right now, the line item from 9 through 12, and then the other one in 17, I looked it up. I went into the RSA book, and those are in the RSA. And you're crossing them out, and I'm asking you if you would be okay if we don't cross those out, leave them in, and bring along the new part to the law, which is B and all of that. You understand my question, sir?
I fully understand your question. I want to thank you for the question. Yeah, I mean, that's fine. You could do that. But what you're doing is you're changing all these duty experts that came in and came up with this language, and worked with the Labor Department under Chairman Sullivan there, and, which came up with a great bill. And they thought the words that were in there, they tightened it up. So if you want to open it back up and make it a little more confusing with more language in there, that's fine. I respect, I'll go whatever you want, as long as we're protecting the children.
Representative Pantelakis.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. This really clarifies, this bill really clarifies minors, which is supposed to be in it anyway. And the other language that was in there was very confusing. Am I right?
Thank you for the question, Representative. You are 100% right, because I think even Ben Baruti and the other Republicans on that committee there thought the same thing, why it was important to them to change it.
Thank you.
Representative Gephardt.
I'm trying to remember when we kind of went through this last term, and I guess there's different levels of, sexual assault and what have you. So if I remember correctly, I think there was a bill that talked to this a little bit, but it also talked to the different degrees that a person, and I don't remember what the numbers were, whether it was like a degree 1, 2, 3, or something like that, that allowed sex offenders to do certain things based on whatever level they were, if I remember, something like that. Do you know of anything like that?
No, I remember something like that. I think Representative Pantelakis would probably know better than I am, since she's kind of one of the gurus there in criminal law and got a probably better memory than I do. So I know there was something that came forward on the different stages or groups within the sexual predator law, but I'd be lying to you if I try to even come up with something to remember.
All right. Thank you. I think that needs a little more research here for my part.
Representative Pantelakis, you have your hand raised? Welcome aboard. Representative Klein Knight.
Thank you, Chairman, and thank you, Dear, for taking my question. The other representative said these people that would lose their jobs have amazing social systems, and you just gave us a figure of about, was it 2,500 or was it larger than that?
2,500 that I got off of the internet. I just
Yes, thank you so much. So the number, that wasn't a question, that was a statement that you gave to us. And that figure, I'm very thankful for, but are you aware, since you are looking up Manchester statistics, are you aware of the homelessness crisis?
Representative, I've been working with the homeless for 15 years. Been working with homeless veterans. We got about almost 450 veterans off the street through HUD certificates through the BASH program. So I'm very aware of that. I also know that we got many homeless that don't want to go off the street. I also know that I've gone around with people counting homeless throughout the years that are out there and help. So yes, I am probably one of the duty experts when it comes to homeless here in the state. Did I get a question?
Representative, for answering that question. Seeing no hands raised, I want to thank the representative from Londonderry for his time, his testimony, and answering our questions.
Thank you, Mr. Chairman. Have a great day, committee.
Seeing no hands raised, at this time, we will close the public hearing on. Representative Muse, you want to do the honors?
Yes, on HB 408, we had one person sign in support, one person sign in opposition, and we had one person sign in as neutral.
Okay. Thank you, Representative Muse. And if there's any members of the public who have not testified already, please raise your hand. Seeing no hands raised, the public hearing on House Bill 408 is now. You have a hand raised. Chair recognizes Aaron Eder-Linnell.
My name is Rebecca Eder-Linnell. I'm a sergeant with the state police and the unit commander for the sex offender registry. I just wanted to be available for any questions that may come up. I know there was some discussion about the number of sex offenders, the number that are employed. And so if there's any questions that I can answer, I want to be available for that.
Well, I'll make it easy. I'll ask the question. Thank you, first of all, thank you for your testimony. And thank you for taking my question. Do you have any information on the amount of registered sex offenders in the state of New Hampshire that are currently employed?
So I've reached out to our IT department to get specifics on their employment and the unemployment rate. I can tell you that we have about 2,900 sex offenders within the state of New Hampshire, not just in Manchester, but throughout the entire state. Manchester alone has about 400. I can tell you that there's about 27 of our offenders in Manchester that are homeless. But I can, until I get the numbers specifically from our IT department who need to pull that from our database, the majority of our offenders are employed and are employed in various ways, whether it's construction to a service of other kinds of vehicle service, in other areas where they may come in contact with children on a regular basis. Certainly one of the areas to think about is a convenience store. You have children walking into a convenience store every single day after school, the same convenience store, they're going to see the same people working there. So that's the type of interaction you're looking at with this bill. And we have many offenders that are employed in those types of situations.
Representative Hopper, you're recognized for a question.
Yeah, thank you, Mr. Chair. Just ask the witness what, in the case of a convenience store, if this bill passes, would that mean that that person would be in violation of the law?
Oh, that's not here. No, that's fine.
So I think one of the things to think about with a bill like this, it's all about interpretation. If someone is charged and arrested, then it's going to be how it's interpreted through the court procedure, through the jury, through the judge, whoever's handling that case. If you say a repeat interaction and somebody is in a convenience store every single day buying a candy bar after school, and that person is selling them a candy bar, that is a repeat interaction with a child. Now, it's not involving the care, instruction, or guidance of minor children, which is what the current law says, but it is repeat interaction.
Thank you. Representative Bolden.
Thank you, Mr. Chairman. Thank you for taking my question. I'm sorry if this was already covered today, but can you tell me, of the 2,900 in the state, how many were convicted of crimes involving children? Because as I understand it, it's possible to be a registered sex offender for crimes that do not involve children.
That is correct. We do have adult victims. I would have to, give me 1 second. It is roughly around 2/3 of that number. If I would have to do some research to get the exact numbers, but it's around around 2,000 offenders have child victims.
Yeah.
Repeat?
2,000. That's a question.
Representative Gathright.
Thank you, Chair. Thank you for taking my question. Earlier, I was trying to determine, I think that sex offenders have certain levels of, based on their crime, I believe.
That's correct. We tier offenders in New Hampshire. So it's tier 1, tier 2, and tier 3. Tier 1 offenders are mostly misdemeanor offenses. And then tier 2 and tier 3 would all be felonies, with generally victims under the age of 13.
Thank you.
Representative Klein Knight.
Sorry. Thanks for taking my question, and thank you, Chairman. Really appreciate you having that data pulled up. As the numbers you just gave us, this, I just want to clarify, as this was written, this was determined as a housekeeping bill. Would any of those people be in danger of losing their jobs if this bill were to pass?
I mean, I can't say whether or not they'd be in danger of losing their jobs. Again, it would be all interpretation. If an employer can justify that an example that I think of a lot is a farmhand. We have a lot of offenders who are farmhands and within the state. You also have a lot of children and child groups that go to farms for school trips, for birthday parties. So whether or not that employer can justify that there would be no interaction with children, he has to determine if he's going to keep that person employed or not.
Follow up, Chair, if I may.
You're recognized for a follow-up question.
Thank you. So as this bill is written now, it doesn't clearly determine the guidelines for protecting people that are in rehabilitative like they're getting their lives together, versus people that are actually a risk to the public.
I think that it's open for, if you change it from what it currently is, it is certainly open for interpretation. I think that the phrase specifically repeat interaction, if it was repeat interaction with the purpose of direct care, instruction, or guidance, that's more clear. But because it separates direct care, instruction, guidance, or repeat interaction, that can be interpreted many different ways.
Thank you.
Seeing no hands raised, I want to thank the witness for taking our questions and providing information for the committee.
You're welcome. Thank you.
The witness is now excused. What was her name? The witness mind repeating your name if you don't mind?
Sure. It's Rebecca Eder Linnell, EDER -LINELL, and I'm the unit commander for the Sex Offender Registry.
Thank you very much. Seeing no further hands raised, at this time, the public hearing on, we will now close the public hearing on House Bill 408. At this time, we will open the executive session on House Bill 408. The chair will recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I make a motion of ought to pass for House Bill 408.
Representative Welch?
I'll second that.
Thank you. I now open the question up for discussion. Representative Rhodes?
Thank you, Mr. Chairman. You know, a person as an adult has a hard enough time being able to put pieces together and move about their daily lives after a sexual assault, let alone a child that is just probably so ungodly confused on what has happened and why it has happened. And this bill is going to protect any future children from being a victim of this heinous crime. And that's all I have to say. Thank you.
Thanks. Further, the way the record reflected, Representative O'Hearn has now joined us. And he is allowed to participate in the vote because he was in his seat prior to us calling the question. So we'll just clarify that now. Representative Marston, you're recognized.
Mr. Chairman, I just have a question. We're doing 408,
Yes.
and that bill is in regards to what? I didn't understand what the Representative Rhodes was saying. So it didn't make sense to me because I don't have the bill in front of me. I haven't had a chance to pull it back up. But what are we dealing with?
Sex offenders.
It's the bill we just did. I apologize, Mr. Chairman.
Oh,
No, I was
I
just looking for the, I was looking for the paper.
thought we were doing a previous bill that,
I also thought that, but it is the current bill that we just finished.
oh, okay,
It's all right.
thank you.
Representative Knight. Representative Knight, you're muted. Please unmute yourself.
Oh, I'm sorry, I couldn't hear you recognize me. Thank you. So I think this is very serious, and I want to go on public record saying that I have my own personal stories.
My mistake, my apologies.
Thank you. I want to say that this is a very serious matter, and this is a personal matter. I do take this very serious, but trying to be a representative that's fair and also represent other people that have rights, especially if they paid their time and they are working without any problems. I just don't think that this is clear on the consequences that would happen to their lives. And I don't think that's fair. I think this bill needs to be retained and worked on. And that's why I can't support this motion. Not because that I don't think this is a very extremely important issue. I do. Thank you.
Representative Marston.
Thank you, Mr. Chairman. I wonder if we got a report from Mr. Representative Muse on support and opposed on it?
We did.
The numbers, may I have them?
111.
111.
One,
One
And then-
supporting, one
Yeah.
opposing, one neutral.
thank you.
Yeah.
In
Representative
regards,
Marston, you recognized?
yes, in regards to this bill, if they do not strike out, if they do not return to the original RSA, which has those wordings in it from line 9 on down through 12, and then again, I looked it up, 17 and so forth. If they don't leave them in the law, which is there now, by breaking all of this out, I go along with what the B is. I think the section 2B with the public and private employer, et cetera, et cetera, et cetera, I like that in there. But if you're not, if you're crossing out all that stuff up above that's in the law now, that causes me to not vote in favor of ought to pass. And would I be willing to make an amendment to that? I would.
Representative Welch.
I would like to point out, to Representative Marson, that anytime you create a list in a bill with penalties, you're gonna leave something out. Even though it does say in here, kind of a.
Yeah, it says notwithstanding.
Yeah, but you create a list, you're gonna leave something out. And I've always felt as though it's better to get the broad brush approach. And this is really what happens, if they eliminated the list and they put in something that's much more comprehensive. Just a thought.
May I respond?
Well, there are other hands up, so I should probably recognize.
But
the
he
witnesses.
spoke to me.
I am well aware of that. But that is there was a point of order on that earlier today, so we're not gonna follow that to its strictest sense, so I don't get called out again. Representative Trevor.
It is with fear and trepidation I will speak on this because I don't have the gift of gab. I've never kissed a Blarney Stone and I don't express myself very well most of the time. 2 points I wish to address. Is it on the books? Yeah, it's on the books already. This whole thing is already on the books. Is it enforceable? I'll get back to that point. Sexual assault, Roman numeral 1. A person is guilty of a Class A felony, child abuse, sexual child abuse. Right? Some words were crossed out. That part's already on the books. It is a Class A felony. We're all in agreement with that. The changes, I don't see why they're needed. Part 2, a person is guilty of a Class B felony if, after having been convicted, he knowingly fails to provide that information. So you can add more words to that. From here until eternity, it's already on the books. What we are left with, that's not on the books, is a public or private employer shall either verbally or in writing advise an applicant, employment, a volunteer position, blah, blah, blah. That is a horrible thing to put in law. A public or private employer shall either verbally or in writing. Now, there's something that will keep lawyers employed for their entire lives. They can argue those, or did he say it verbally? Did he say it? Just a horrible, horrible thing. Other than the stuff that's already in the books, we're left with this meaningless statement of public or private employers shall verbally advise an applicant. They shall verbally advise an applicant. This bill says he must have already told them about the information of his prior conviction. So the applicant must tell the employer, I was guilty of, I'm convicted of a sexual offense. And then the employer must say, have you ever been convicted of sexual offense? Other than the stuff that's left on the books, we're left with nonsense, in my opinion. And for that reason, I could not support this bill as it's changing the RSA. Thank you, Mr. Speaker. Mr. Chairman.
Representative Muse.
Very much. I'm actually going to support the bill because I think it's more protective of children. I also know that we have a separate RSA, 651, which actually gets into the different tiers of sexual offenders. So people who've been convicted of felonious sexual assault and felony level sexual assault crimes are on the list for life. People who are convicted of the misdemeanor crimes are on the list for 10 years. I think as long as you're on that list, you're potentially a danger to children. I don't have a problem with the way that this law defines, or with the way this bill actually defines the offenders. I think the bigger issue may be with the other RSA and whether or not we actually have a good process to get people on and off that list. But that's a separate issue. For now, I support this bill.
Representative Gaffney.
Well, right now, I'm not sure if I support it or I don't support it. But what I have taken the time to do is read the letter from the Department of Corrections. And they were the ones that were neutral, but they shared the same concerns as the commander of Sex Offenders Register, Rebecca. And the concern was the open interpretation, and particularly around repeat, the terminology repeat. And that's a concern to me as well when I read this, because we keep in mind that, yeah, we send people off to jail, but on the same token, it's supposed to be rehabilitative to come back out into the world. And when people come back out into the world, whether they're sex offenders, whatever they've done wrong, there's so much set up to help them to restart their life. So when you say a year from now that if someone working in a grocery store and where kids come all the time, they no longer going to have that position, I would have a problem with that, because I look at it as, and I suggest that you do take the time and read the comments that they put in here, even though they were neutral. The real concern was that we spend a lot of money to rehabilitate people, and we send them back out and hopefully have them continue rehabilitation. And so I don't know, I'm struggling with that, and mainly because of who's going to call the situation a repeat? You know, do they have the best judgment of it? You know, it's kind of like a slippery slope, in my opinion, that we could be dealing with this particular one.
So what I can say in this group looking at this, the first thing is I understand there's some concerns that people might lose their job. I understand there's concerns with how that will affect, especially in an economy like we're dealing with now, especially during a pandemic. With that point taken into consideration, this bill is designed to protect children. I think the Representative Verbal, when he testified, did an excellent job explaining the psychology that goes behind how this offense is often committed. It's not committed the first, second, third time someone interacts with a child. It's usually something that's planned over a longer period of time. From what I understand is that child predators, they literally scope out children that are vulnerable to take advantage of and to exploit. So what this says is it will prevent the repeat interaction with a minor. So if you work in a grocery store on the loading dock in the back of the store, there's not any perceivable situation that I can see where that person would interact with a child, never mind repeat interactions with the same child. I'm not sure why a child would be on the loading dock at a grocery store. It's the interaction with the child. If your job duties require you to interact with the child, that's different. I would say like a daycare, for example, probably not the best place to have a child sex predator be working. I would hope there's already a law in the books preventing that, but by listing professions, you have now narrowed the way that's often interpreted by courts is that the legislature intended to narrow the scope of its application. That's why you don't want to have the list, because if you're gonna forget something, we can sit here for 2 days straight, come up with all the places that we don't feel that a child predator or child sex offender should be working. And I'll tell, we can put the smartest people in the state all in a room, we're gonna forget one. So this leaving it open-ended allows the discretion to include stuff in case there is something. You want to include any profession, period, if you regularly interact with a child. And having the employer know about the person's history. That goes to liability. Now the employer can't say, I didn't know. The employer still wants to hire the child sex offender or the child rapist, or whatever, that's their, I mean, that, now they know, they can't say they didn't know. So I would certainly, I believe this is a very good bill. It passed on consent last year. It passed out of, I believe it passed out of the Labor Committee 19-1. It was on the consent calendar. I understand the concerns people have, but I think this strengthens, it doesn't necessarily create new law, but it's strengthening and clarifying existing law on a very important subject, and I would hope that I would be supporting the law to pass. Representative Green.
Thank you. I have a question for you. I was late getting in, and what was the status of the state trooper on this bill?
I don't believe they took a position. They just offered to answer questions to help answer any concerns of the committee. Representative Conley.
Thank you, Mr. Chairman. I think there's a strong argument here for retaining this bill. I think collectively, we all strongly support the concept. There were some problems identified though. One, people losing their jobs through no fault of their own since they've come out of prison or whatever the adjudication process was. And then we would thus limit where they could work moving forward for potential impacts with people's livelihoods. We also know just through the data and through the statistics that one's coworker is often not a perpetrator of childhood sexual assault. We know it's more often than not family or a friend of the family, or a coach or a trusted person. We heard that 2/3 of these crimes are committed against children under 13. A horrible statistic if there ever was one. But under this law, we would then be limiting where the other third of people who did not commit that heinous act can work. And we are, well, I'll say that. So I guess I would say, I'm not going to support this now. I want to support it. It needs work. I'd be willing to do that work.
Representative Bradley.
Thank you, Chairman. I will be supporting this bill. I appreciate that it's more broad in scope and doesn't list out certain situations. So I think it's a strong bill, and I think that the importance here is really protecting our children.
Representative Testerman.
Thank you for taking my question, my comment. I get a regular update for my city and the sex offenders who happen to show up in the last week or so. And I am appalled at the number I see who come in, who in most cases have an interaction with some child under the age of 13. And they don't, people will tell you that they've already served their time, they've rehabilitated. As I understand, that's not true. And I think this bill is really important. I think we ought to pass it, retain it, whatever people want to do. I think that's the wrong thing, because essentially we're saying the kids are not near as important as the offender. And I don't agree with that.
Representative Byrd.
Thank you, Mr. Chairman. Mr. Chairman, I think it's no secret that I have resisted many times to enhance, like from lower crimes up to class A felonies and et cetera. But I don't think this bill is out of reach. I think it protects children. I think it protects the child predator person. I'm going to support the bill because I just think that is the right thing to do for the children of New Hampshire, and I hope we can agree on that.
Representative Pratt.
For the last 29 years, I've been the person that signs the charter for the Boy Scouts in Raymond, New Hampshire. I also handled the Eagle Scouts for 20 years, and on youth in various churches groups. I know the background checks that I've had to do. You'd be surprised how many people have come forward, sex offenders, that have been told, they've been through the process, that they're not allowed to associate with kids. And after they've been told that they're not allowed to associate with children, have applied to become scout leaders or applied to become some kind of leader of a child program. So the only way we find out, and they're supposed to tell us, they didn't tell us. Some of them haven't registered locally in their own town, they're just supposed to do it. That's government trouble for applying with us. But I think it's tightened up a lot, it needs to be tightened up, and it will help take care of the problems, the reforms and cracks.
Thank you. I think in seeing, I believe I recognize everyone to speak. Representative Hopper.
Yeah, just quick, I'm not sure how I'm gonna vote. Thank you, Mr. Chair.
We're gonna find out soon.
Guidance or repeat interaction with a child, minor. And if you go down to the bottom of the thing, it basically makes, put some of the responsibility on employers also. So if I was had a convenience store in Manchester and I found out one of my employees, regardless of how good he was or she was, I would fire them. Just on the just for the liability probability if something did happen, even though that, like it was already said, most sex offenders are abusing children that they're related to and or close members of the family. It's not, I don't know of any instance where a store clerk offended, there probably is nationwide, but the probability of a store clerk molesting a child is probably pretty rare. So I don't know. I don't know, but I really don't like the ambiguity in that that part of the bill. It seems like that should be clinched up before we pass it.
I believe everyone has now spoken with the exception of Representative Newman. I honestly don't remember, so this is the last comment. Representative Newman.
Thank you, Mr. Chair. I was originally concerned about the paragraph that required the notification by the employer. But I noticed for the other paragraphs, there are penalties assigned when those are violated. But in that section, there is no penalty. So if they should be doing that, but if they inadvertently don't do that, I don't believe there's a penalty to the employer. And if it gives the defense lawyer something to work with, then so be it. But I think I'm going to support this bill. Thank you.
All right, well, seeing no hands raised, the clerk will now call the roll. If you're in favor or in support of the motion of ought to pass, please say yay. If you are opposed, please say nay.
Vice Chairman Welch.
Aye.
Representative Burke.
Yes.
Representative Hopper.
Yes.
Representative Green.
Yes.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
Nay.
Representative Pratt.
Yes.
Representative Marston.
Nay.
The clerk votes yes. Representative Harriet Gathright.
No.
Representative Pantelakis. Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes, yeah,
Representative Bolden,
Yes.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
Yes.
Chairman Abbas.
The chair votes yes.
Mr. Chairman, the vote is 15-6.
By a vote of 15 yeas and 6 nays, the motion is allowed to pass. It passed.
Consent?
Well, we were almost there. We didn't quite make it. Representative Rhodes, would you like to do the majority report?
Who's gonna do the minority?
Minority report?
Yeah, there'll be one. I don't know who yet.
We gotta do a better job of getting those reports in, by the way. That's why something's getting held up. Okay,
Question?
you have a parliamentary inquiry? We might be, we could answer, get to another executive session quickly.
A quick one.
None of them are quick, but okay, what's the
Of
question?
course it is. Linda, did you say you would write a report and,
No, I just said that someone would write it. I didn't get it. Oh, I'm sorry.
That's a conversation that can happen at any other period of time.
I wasn't here.
I know, I understand, but let's just keep it moving, because that's at this time, we can close the the executive session on House Bill 408. That's nice. Okay.
What time is it?
6:20.
You never get on that. Oh, yeah.
Okay, I'm going to open the executive session. We can get that one pretty quick.
All right.
And then I'll hold it up in the, At this time, we are opening the executive session on House Bill 620. The chair is recognizing Representative Gathright for a motion to retain.
Thank you, Mr. Chair.
Are you making the motion?
Oh, yeah, I make the motion.
Is there a second to that motion to retain? House Bill 620. That was seconded by Representative Conley. Seeing no hands raised for discussion. Representative Marston.
correct me if I'm wrong, but we on February 10th had this in a hearing.
I don't recall the exact date, but we've had a public hearing on House Bill. It was the 10th. Thank you, Madam Clerk.
What's the number we're doing?
620.
Thank you.
And my understanding that there was some desire to present an amendment due to our time constraints in this committee, which I have expressed to this committee members several times over. We are under time constraints. It's unlikely we would be able to get the amendment in on this bill and able to do the work on that it deserves. It was requested that it be retained so they can at least be assigned to subcommittees to work on the summertime. I believe that that's a very fair request of the members of the committee who want to work on something. But as you can tell, for some bills, we're limited on when we can meet, on what we can do. So the chair will be supporting the motion to retain as well. Representative Marston.
Thank you, Mr. Chairman. Looking back at my notes, now that I have a chance and I know what we're talking about, I found some problems with this bill. And I found the fact that there would be some consideration to ITL this rather than retain it. And if we retain it at some point in the future, can we then ITL it?
Correct, we can, and I will say that if this bill is not retained, I would be supporting an ITL, but speaking with members of the committee, I who want to work on this issue in good faith, and I believe that the bill itself is well intended, does have problems. And by retaining it, it will allow those members the opportunity to work on the very serious issue that the bill brought up. But you can, after that subcommittee, which will probably be during the summertime, into the fall, if we have an executive session then, I think we may probably have a different looking bill by then. I think we can make a determination then.
Thank you for the clarification, Mr. Chairman.
Seeing no hands raised, the clerk will now call the roll. If you are in favor of the motion to retain, please say yay. If you are opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burt,
Yes.
Representative Hopper,
Yeah.
Representative Green,
No.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yes.
Representative Pratt,
Yes.
Representative Marston,
No,
the clerk votes yes. Representative Harry Gathright,
Yes.
Representative Pantelakis,
Yes.
Representative O'Hearn, Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman Abbas.
The chair votes yes.
Mr. Chairman, the vote is 19-2.
By a vote of 19 yeas and 2 nays, the motion to retain has passed. There will be a subcommittee appointed. Representative Gathright, would you be interested in chairing that subcommittee? And Representative Conley, would you be interested in participating in that subcommittee?
Sure.
And so appointed. Representative Welch?
Representative Marston.
control yourself, sir.
Sorry, it is hard to breathe in this.
Yeah.
Representative Hopper? Would you
Yeah.
be in the subcommittee?
What subcommittee?
Are there any volunteers? I'm just going to appoint Representative Hopper and Representative Marston.
I would like to be on that subcommittee, sir.
There we have it. You both are on together.
Okay.
Thank you. At this time, we will close the executive session on House Bill 620. We are opening the public hearing on House Bill 316.
I'll introduce it.
This bill is being introduced by Representative Testman. Representative Testman, you have to take the grand stage.
Oh.
And
This spring, I'm here to introduce Bill 316. I'm Dave Testerman. I'm a representative from Merrimack 2, that's Franklin Wards 1 and 2, and the town of Hill. This spring, I was asked if I wanted to sign on to a bill. I didn't think it was as a sponsor. And I said, fine. And that was about the last I remember of it. For the last couple of days, I've been reading this, what this bill tries to do, and I can't support it any longer. So I'm going to remove my support from it. I don't know what that means as far as what happens to it here in the committee, but I can't support it any longer.
Representative Tesserman, you, as I recall, you did that last term as well.
No, I killed it last time.
You did ITL your own bill last term in this committee?
Yeah.
Would you like to do it again?
But we do have witnesses present to testify in support of it. So
I'm gonna say, my difficulty with it is I couldn't figure out how you can make it work. So. 316. Anyway.
The chair will now recognize Chief Andrew.
Shiguri.
Oh, sorry. Sorry, Chief Shiguri.
I've asked him to unmute, Mr. Chairman. He's there, he should unmute. Again, I've asked him to unmute. Yep, there he is.
Chief, you're recognized.
The chief experience, he's unmuted, Mr. Chairman. I don't know if he's having technical issues on his side.
I believe he is the only witness signed to testify, so we'll just give it another minute or two. Can the members at home hear us?
Yes.
Yes.
So while we're, Mr. Chairman, there is one other person, if you want to move to that.
Please call in the witness.
Richard Head. I'll bring him up. And he is allowed to talk. Yep, Mr. Head, you are unmuted.
Great, thank you. Thank you, Mr. Chairman. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. You should have received a letter from me last week. I don't know if this bill is going to go forward in light of Representative Tesserman's testimony. We do ask, and this is actually an issue with bills generally sometimes, where it has an effective date upon passage. And when bills like this are passed within the judicial branch, it requires a substantial amount of work on our end. If there are forms that get changed, if the uniform charge table needs to be updated, any one bill doesn't take a substantial amount of time, but the cumulative total of bills over the course of a session creates a fair amount of work in terms of creating the modifications within our systems, within the forms, educating police, law enforcement generally, judges, and then also some of the technical changes, the electronic changes that are needed. RSA 14:9-A says that any changes to judicial process actually should have an effective date of January 1, 2022. And you may see a similar testimony from me throughout the session where we see a bill that has a short effective date. We just ask that this bill, if it is going to go forward, be amended to January 1, 2022 as an effective date. We also just note, without any position on it, that it does have some oddities in terms of structure. It creates a misdemeanor in a document that is essentially a form. And we have not seen where a crime is actually identified and described in a statute that is a form and not a criminal code provision. And it also does not have a definition of good behavior. But again, not taking a position on it. Those are just things that we're noting in terms of the bill. Happy to take any questions, but my primary purpose was just to ask for it to be amended if it goes forward.
Chris True.
Thank you, Mr. Chair. Thank you for taking my question. Well, you might have begged off at the last second there, but the title of the analysis of the bill is "The Defendant Remain in Good Behavior." You tell me what, so do you know what that means?
So it's it's actually in the context of this bill, I do not. It is not clear from the bill as to what that means. Typically, the good behavior is used in the context of revoking something. So, and in fact, the current form has it in that context, in which the summons, by receiving a summons, you're essentially receiving a benefit. You're not having a warrant issued for your arrest, and you have to remain of good behavior. By sort of, and then you also see it in bail. You also see it in probation. It's typically defined in a bail or probation order as to what that means, as to sort of what are the requirements of good behavior. In this context, if you default to some case law, it talks about it has to be a statutory violation. It becomes very unclear when you get into like ordinances, things like that is a violation of an ordinance, a violation of good behavior. But in this case, it's not sort of taking away the right to a summons. It's not taking away bail. It's not taking away probation. But in this case, the addition is creating a crime. So then the question is, is somebody who might commit this crime on notice of what that crime actually entails by not having a definition of good behavior?
Thank you, Mr. Chair, and thank you for taking my follow-up question. I was pre-med, not pre-law, but is good behavior basically saying, I'm expected to obey the laws because I'm a citizen all the time. Is good behavior saying, we're gonna release you until your court date as long as you don't break any more laws?
And so in this case, it's just saying, so at least in the current form, yes, in the short answer is in very, very broad terms, I would generally agree with that. But what becomes less clear is when good behavior or failure to remain of good behavior is itself a crime, as would be the case in this bill. Where it then becomes, it's not in that case, in this case defined, where normally in a criminal code, those types of phrases would get defined.
John Burke.
Thank you, Mr. Chairman, and thank you, Mr. Head, for your testimony. You stated that you wanted, if we did pass this, you wanted the date changed to January 1st. Is that 2022 or 22?
2022, correct. So the way the statute reads, RSA 14:9A says that the effective date of bills would be that modify court process, create new crimes, which this one does, should become effective the January 1st of the year after the session.
All right, thank you, sir.
Representative Martin.
Thank you, Mr. Chairman.
Maston, sorry.
I understood. Thank you for taking our questions, Mr. Head. My question to you is simply this. If he goes out and he creates another crime, that in itself is a violation probably of his release. Is that not correct?
Well, this is not a release. This particular form is a summons for arrest. So this form is simply you're being issued a summons of arrest instead of having a warrant issued for the arrest. So this is before anybody has gone through trial or been convicted or pled to anything.
Oh.
Thank you. Correct. I misunderstood and I misstated when I said that he was being released. My question is, if he doesn't behave himself, regardless of whether we have a law or not, and he commits a crime, we just do the process, don't we?
Yeah, that's, if I understand it, thank you for the question. If I understand, if somebody receives a summons, they go off and commit the crime, that crime still has its own penalty associated with it, and they can be duly charged for that separate crime and go through trial on that separately. That's correct.
Thank you.
No other hands up. Thank you.
Chair. Sir, Mr. Chair, my hand is up.
Oh, I'm sorry, I didn't see it. You may go ahead and question.
Thank you. Thank you, Mr. Head, for taking my question. Could you just educate me maybe on the policy or the reference that you use that guides us on that we ought to use January 1st, 2022 as an appropriate date?
Yeah, absolutely. So there's a statute, RSA 14:9-A, and you should have last Friday I sent a letter to the whole committee if you've had a chance to see it. That statute says, and I'll just read it, each law affecting judicial practice and procedure or establishing or eliminating criminal prohibitions, civil causes of actions or remedies, or limitations of actions shall take effect on the January 1 following passage. And in this case, this particular bill, since it would affect judicial practice and procedure and create a crime, being a misdemeanor, the law that governs effective date of bills says that it should be effective on January 1, 2022. It's a fairly common thing. We see it in a large number of bills. And I try to identify it where I see it for the committee and ask for an amendment to that effective date.
Further question?
Yes, follow-up question. Could you just repeat the RSA number, please?
Absolutely. RSA is 14:9-a.
Thank you.
You're welcome. Thank you for the question.
I see no other hands up.
Chief Shigori, I figured out my technical issues.
Chief, you'll be next up. We've excused the current witness and we'll call Chief Andrew Shigori.
Thank you, Mr. Chairman and members of the committee. I was a little surprised by some of the things that Attorney Head said because, so 2019, 594-14, summons instead of arrest, was amended to add the language to remain of good behavior, a warrant of arrest may issue. So it was already there about warrant, but it didn't say what the warrant was for, what the offense would be. So that language of good behavior already existed in this statute, and it already said it was a misdemeanor. The next sentence is any person who fails to appear in answer to such summons shall be guilty of a misdemeanor. That language already existed. To say that a form doesn't say that is kind of surprising because it was already existing in the law. But to go to why that I asked for this bill to be filed, and I thank Honorable Representative Testerman for doing this on my behalf because I was the one who asked for this. I'm on the Interbranch Criminal and Juvenile Justice Council, and I will say this was a discussion I had with Judge King during one of those meetings when he told me, and he's the head of the circuit courts who handle most misdemeanors, which a summons can only be issued for a violation or a misdemeanor, in lieu of an arrest, that it's a misdemeanor if they don't behave of good behavior. And I said I don't see that. I see a warrant can be arrested, a warrant for arrest can be issued for not being a good behavior, but I don't see where it's a misdemeanor because there's a period in there. And I said if that was the intent of the legislature, then they should have added that to the second sentence in that last little bit that has to be part of the form. This is a long-standing law. Goes back to 1941, summons instead of an arrest. But this was a change that came in 2019. When this bill was discussed in 2019, I approached through our lobbyist. I said, we need to get that little bit clarified as to what happens if they're not of good behavior. We charge them with a warrant for what? It wasn't clear. And it already says if you don't appear, which appears in the first sentence of that last little bit. And the second sentence says, it said before, upon failure to appear, a warrant for arrest may issue. Any person who fails to appear in answer shall be guilty of a misdemeanor. It added, or to remain of good behavior, a warrant may issue, but it didn't say for what offense that would be. And I didn't hear any discussion in 2019 about there was no definition of good behavior. It wasn't an issue apparently until now. I mean, this law has been in effect over a year with good behavior added to it. And I just wanted clarification that what exactly we're charging this person with, because it says a warrant, but it doesn't say what for. It was a minor change. I'd asked for it in 2019. And from the discussion I had with Judge King, that was the practice of the court, or what he thought the practice of the court should be anyways. Thank you.
Any questions? The witness.
Representative
Representative
Still in session. I don't remember that much.
Representative Newman, you,
Thank you. Thank you. I think the chief might know is unmuted, so thank you. Chief Andrew, do you think that a change to the wording of the bill as it's written that references the definition of good behavior as a crime in another RSA might be sufficient to solve the problem of this?
Well, I think two points. It has to be added, as I state, that it has to be added in there as to what the warrant's going to be for. And I don't have an objection to adding a definition of good behavior. By case law, when you look at good behavior as regards to suspended sentences or or to revoke bail, it has to be a crime, a criminal act, which is a misdemeanor or higher offense or a serious motor vehicle offense as stated on the bail forms and the suspended forms. It's not spelled out. It wasn't spelled out when this was put in effect in 2020. If that is what's needed, I certainly don't disagree with adding that. It would be misdemeanor or felony under state or federal law. That's what's on the bail forms. Or a serious motor vehicle offense is what's on the bail forms. But it requires, so somebody, the idea, I think, behind passing this last year, well, make it effective last year, passed in 2019, was to make it so that that law enforcement would be more likely to put people on a summons than take them into custody. Unfortunately, and so they added good behavior because that was a concern, is that we didn't have anything, if we release somebody on a summons, to say you have to be of good behavior. But and it says you can arrest them on a warrant, but I don't know what for because it's not in the second sentence. That's why I added it. But a definition of good behavior, what's intended, that's certainly, I believe, appropriate for the legislative body to set what the legislative intent is. The courts have defined it and through case law as committing a criminal offense, which would eliminate violations because they're not technically crimes. Does that answer your question properly?
Yes, thank you.
any further questions?
I think one other point I'd like to make is that when I had this discussion with Judge King, one of the points I made with him was I'm not likely to use a summons unless I know, because the intent was to give more summonses out rather than arrest people. Okay, but I need to be assured they're going to be of good behavior and that I have some teeth to the good behavior. That was the idea behind this, is a warrant, but what do I charge them with? So I said, I'm unlikely to release somebody, to arrest somebody on a warrant that I don't know is going to show up and I don't have anything to do if they're really not of good behavior, because I don't know what I'd charge them with an offense, what an RSA is. If somebody fails to appear right now, if I give them a summons and they fail to appear, I can charge them with a misdemeanor under 594-14. It's right on the form. I can do that. I think, good behavior, add a definition, great, but I think it needs to be in there that that's a misdemeanor so I know what the arrest warrant will be for. And just to clarify the legislative intent when this was modified in 2019. And I understand the need to give some time. I don't think this is a huge ask for changing law enforcement training because it's not a big, good behavior is already in there in a sense. The big change would be in the forms, getting new summonses printed up and changing there may be a minor change that's needed to the UCT, the Uniform Charge Table. I doubt it would be much though, because 594-14 should already be in there for failing to appear. So it shouldn't be a huge change for failing to abide by a summons. Shouldn't be a huge change because it's the same sentence, same RSA, that should already be in there.
That's an interesting comment on your part. It clarified a lot for me. Is there any other questions? Seeing none, we thank you very much for your testimony.
Thank you, and thank you for the challenging times you're meeting under.
I see no other witnesses. I guess we will close the hearing. Okay, House Bill 316. Recess, I guess, until the chairman comes back.
And Mr. Chair, we had 3 people signing in to support this bill. We had 3 people signing in opposition, and we had 1 person who signed in as neutral.
Thank you.
Finally. Wouldn't this be a quick?
Was to change a couple of words and he wasn't listening to him.
ITL.
Actually, yes, it was my error. When Chief Sigourney
Just hold a minute.
Members, can they hear us at home?
Representative Newman, can you hear me?
And now,
All right. Were we on mute before?
Yes.
Okay.
Hear my motion, everyone?
All right, just everyone forget the last 1 minute. Sorry about that. The members at home were not, they were muted, so we're just gonna, no, listen, let me just start over. We have to start over because, please. We opened the executive session on House Bill 525. And at that time, we opened it about maybe 2 minutes ago. Representative Burt was recognized for a motion of inexpedient to legislate. Then that motion was seconded by Representative Waltz. And at this point in time, I recognize Representative Hopper to speak on that topic. While he was speaking, I realized that the members from home were non-reactive to anything, and we've now figured that out. So, does anyone have any objection to us continuing with this process?
No.
Point of order.
But I would like to talk at some point.
You were recognized for a point of order. Are you challenging a ruling of the chair?
No, I just have a point of order. After a representative makes a motion and it's seconded, the person making the motion is usually recognized to speak to his motion. And you did not give Mr. Burt, Representative Burt, that opportunity.
I appreciate you pointing that out. I will most certainly recognize Representative Burt. If your hand was up and I did not see it.
It was not.
So that is my mistake, but considering that his hand was not up and I did not, I recognize Representative Hopper, whose hand was up. And I'm sure if Representative Burt was upset by that, he would have made a point of order. So I'm just going to let Representative Hopper re-begin his point.
All right.
And I assure Representative Burt will be recognized thereafter.
Thank you.
Thank you, Mr. Chair. Okay, so, for the people online, my point was that I think this bill should be retained. I believe that there is an absolute clear connection between people who abuse little kids and pornography and the abuse of pornography. And so therefore, I think if we carefully rewrite this bill, it seems like we should be able to write it so that when a person is charged and caught sexually abusing a child, that any electronic device that contains information within the scope of that person's control is subject to a warrant for investigation. I think in this particular case, I am willing to bet if they were able to get that guy's computer, I'm pretty sure there was probably a lot of information, other information that might have led to the arrest of people that are involved in child pornography also. Because the two behaviors go together. So I think we should be able to craft this so that the police could have more easily obtained a warrant in the case of the folks that were testifying this morning. I think I said that right.
Representative Burt, and please accept my apology for recognizing a different member before you. So.
No need to apologize. My hand was not up, Mr. Chairman. Mr. Chairman and committee members, the reason I make the motion of ITL, and I just want to make it for the record, I've been on criminal justice. This is, I believe, my 4th term. My record will show that I support anything that we can do to slow child molesters down from abusing their children. But the reason I'm making the motion to ITL this is the original bill was totally against the Constitution. The second, or the amendment was added in, which removed, got away from the constitutional issues, but it went back to current law that we have now. So we heard from the police chief that they did request a warrant to seize the computer. sadly, CAC or SAC, I'm not sure what it was called, where the kids got interviewed. They couldn't draw out enough information from those children to secure a warrant. Now, what I feel on this is the system failed those children. And this bill is not going to fix that. What I feel on this particular bill, why I think we should ITL it, is because if we were going to retain it, let's just work on it over the summer. We don't need this bill. We can work on anything over the summer. Bring a clean bill back, because where the issues are, we go back to that dusty old piece of paper called the Constitution. We need to make sure that the courts are going to be okay with the language, and that's going to take some time. And, you know, it's a huge hurdle to work around that Constitution, which I want it to be that way. But again, we need to ITL this particular bill and just bring a clean bill back next year. Thank you, Mr. Chairman.
I agree with that.
Representative Rhodes.
Thank you, Mr. Chairman. I don't think that I'm alone when I say that everybody in the room is very sorry for the unfortunate circumstance that happened with the family and their child. And it's just absolutely disgusting. I don't think that this bill is the solution to that problem. And I think that if it was the chief of police that testified, basically even said that as well, that the circumstances that played out were just very, very unfortunate. And that unfortunately that family is the one that, you know, fell for that crap, but that's not normal. And normally that is what happens, is you would take any of that evidence. And I just don't think that this bill is fixing anything at all, and everybody kind of testified to that as well.
Representative True.
Thank you, Mr. Chair. I support the ITL for House Bill 525 because, I can't remember who, no offense to the sponsor, but as it's written, as it's drafted, through nobody's fault, it's unconstitutional, and I always vote against unconstitutional bills.
Representative Marston.
Thank you, Mr. Chairman. No disrespect was taken from Representative True, and I would only point out that the Office of Legislative Services has attorneys, and the attorneys draw up our bills, and they drew this up. I didn't go in and dictate, and I say you're correct. He did a piss poor job. I stand admonished.
And let me just clarify, Representative Marston, you did do an excellent service by your constituents, and I think they should be thankful that this is a very serious issue. And, you know, working in the legal field, I know firsthand how difficult this subject is when I'm defending someone or representing a victim. So you did a great service by your constituents, and they also brought awareness of a situation where I think we all agree the system failed that family. You know, in fairness to what we heard before the committee, and I appreciated that everyone in this committee had respect for that family and didn't ask the detailed specific questions. We are talking about a minor, and this is a public hearing. And so we didn't get all the information we probably wanted. So I want to thank the members for that as well. As drafted in legislative, whatever reason why they drafted this way, we're not going to require a search warrant for the police to come into your house and take your electronic device. I think that's, and the Fourth Amendment is very clear that that's just not permitted. There was an amendment at least that would have fixed the constitutionality problem of it. I know we didn't adopt that amendment. I don't think it be offered on a positive motion, but just the Fourth Amendment, the right of the people to secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. under the Fourth Amendment, going way back to the Fourth Amendment, it sounds like the police followed that process. They applied for a search warrant. I'm not saying that the warrant wasn't written properly, but under any scenario, I agree with Representative Hawk. In its statistics will show this, that all likelihood, a sex offender who physically does their sex offense on a minor, before they even get to that level, they often start with child pornography. And I would not be surprised at all if those devices had child pornography on it. And it's horrible. And I agree that I wish the police found a way to seize those devices and look to see if there's evidence, because it might not just be this particular victim, it could be others. But for whatever reason, a judge did not find probable cause. I would say even retaining, we were not rewriting the Fourth Amendment. And to me, this is just a very unfortunate situation. But again, we don't know what the affidavit said. We don't know what much more than that. All we know is that the court did not find probable cause. And if that device was seized without the warrant, wouldn't matter what was on there, would be suppressed. So it's an unfortunate situation that happened. But when we had laws on this last term, I often said I wish we could pass some of these. I would love to give an exception just for this issue, but the Fourth Amendment is as it's written. I'm sorry, if I can think of a way to fix this, I would be on board with retaining it, but I can't figure it out. So that's just what I gotta say. Representative Knight.
Thank you, Mr. Chairman. I appreciate the intent of where we're trying to go with this. And I would say that we can resolve a lot of the issues with the intent that we were trying to get at would be with some of the other bills that we heard. This is an extremely important issue. I don't think that this bill was properly prepared. I feel that it's not appropriate and it does a disservice to the lawyers that work with us to throw them under the bus.
That issue was already addressed by the chair of the committee. We don't need to revisit it. And the representative withdrew his comment after, and we don't need to discuss it any further.
I deserve to have a voice for my people.
I was trying to unmute you, but I can't until you approve it. But we don't need to discuss that.
I just want to say for the record, please, Mr. Chairman, if I can, that it's a completely, we have to hold ourselves accountable to the duties of which we were elected and voted into office for. And it does a certain disservice to our entire committee because I
already issued a warning on this.
Okay, I'm done. Thank you.
Representative Bourdonnais.
Thank you, Mr. Chair. I don't think this bill is necessary, and I'm wondering whether or not police standards should be corrected. Because if we're looking at sex crimes, we probably should be looking at electronic devices at the same time that we are arresting them for molesting children, right? Because those two crimes go together. I'm not sure why the sex crimes unit was not involved in this case that we heard. So do we need a new law, or do we need to correct police standards? That's a question.
Representative Gabbard.
I don't know. A good question coming up. Representative Bourdonnais. But I think it was before, I think Representative Burke mentioned.
Can you speak up, Representative Gabbard?
I believe the issue might have been even before, I guess, the judge. I think it happened and because we're not privy to anything that really happened there, I think that whoever interviewed the children screwed up. So that has nothing to do with the law here that we have because it's in place. But for a judge to say that probable cause was not there, something happened before that, that made him say that, or her say that. So, therefore, I will be supporting ITL.
Representative Pantelakis.
Thank you, Mr. Chair. It was stated when I asked the question, was a reason why the computer was not taken was because no one said that pictures were taken. And we have to stand by the Constitution. And I don't think we could rewrite this bill. I feel very bad, but I always heard in other cases that they did have the computers and whatnot to prove their cases, but evidently something went wrong here. Thank you.
Thank you, Representative. Representative Pratt?
Is there a list in the law, I'm asking questions I don't know this, is there a list in the law that causes probable cause for search and seizure? A law that says what probable cause is?
So it's not a list where it will say this will establish, it's not like this fact will establish, this one won't. It's really, it's a legal standard, you know. So probable cause and more likely than not is somewhat very close to each other. I know we heard that testimony on an earlier bill today.
Interpretation.
Yes, I don't have the exact, specific phrase, but it has to be, after articulating the facts, basically it's more likely than not. It's very close to that.
If there was a way to affect that, child sexual abuse should be a probable cause for search and seizure or what.
So what you're saying is, if hypothetically, if someone, let's say, is a known addict, and you search that person at any given time, right?
Yeah.
And if you see someone who's a known drug addict, if you were to search that person at any given time, you can make an argument that they're highly likely to have a controlled substance on them. But I would argue that the mere fact that a person's a mere addict does not give someone, the police officer, the probable cause to get a warrant to search them or just search them every time. So that's the problem that you have, is that even though there is a link between the two, and you may know it, just knowing it or having a hunch is generally not enough. There would have to be some fact that the computer itself is involved in some type of crime. And we're just basing on statistics. So unfortunately, I don't think there will be a list. Seeing no hands raised, I think the matter we put the question on the clerk will now call the roll. If you are in favor of the motion of inexpedient to legislate, please say yes. If you are opposed, please say no.
Vice Chairman Welch,
Aye.
Representative Burke,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yes.
Representative Pratt,
Yes.
Representative Marston,
With no disrespect to the committee, I will be the lone nay.
the clerk votes yes. Representative Harriet Gathright,
Yes.
Representative Pantelakis,
Yes.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
Did we lose him?
Is he there?
Representative Bourdonnais,
He was.
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley,
Yes.
Chairman Abbas.
The chair votes yes.
Mr. Chairman, the vote is 20 to 1.
By a vote of 20 yeas and 1 nay, the motion of inexpedient to legislate Passes. I'll move to consent. Representative Marston?
Yes, I would move to consent.
Thank you. Representative Walls?
It has a financial note.
But it's ITL.
On it, when a bill has a fiscal note, if it's ITL, it is not required, it can still go on the consent calendar. I also did check on the other bill we had, HB 945, HB 270, that also is still permitted to go on the consent calendar. I did consult with the clerk, so that may remain. It's because the fiscal note was a zero.
Bert, and then Wallace.
Representative True.
Thank you, Mr. Chair. So on one of the bills I saw, under 10,000, is that the cutoff? Did the clerk say?
My understanding is that a bill does not require a fiscal note if it is under, if the fiscal impact is under that price, under $10,000. So the issue when that came up, it involved like a piece of paper and really small marginal cost. So that did not require fiscal. But that just means it can't go on the consent calendar. And it also means that the bill is required to have fiscal. All right, this time we can close the executive session on House Bill 545. Would anyone like to write the majority report?
It's 525.
Oh, sorry, 525?
Yep, I'll write it.
Thank you, Representative Burt. At this time, we are opening the public hearing on House Bill 200, increasing the penalty for certain invasions of privacy. In addition, at the same time, we'll be hearing House Bill 296, establishing a crime for unsolicited disclosure of an intimate image. We will be limiting testimony for the members of the public to 1 minute for these bills. I will allow an exception for the representatives who either sponsored the bill or are introducing the bill that testified for the committee. Is Representative Vincent present?
Chairman, I'm not seeing.
Representative Nottingham Wong, you're recognized.
Hello?
Yes, and I believe, are you in your interview, just to clarify, you are being recognized to introduce House Bill 296?
Yes.
Thank you.
I am Representative Allison Nutting Wong. I represent Nashva's Ward 5, and I'm here to introduce HB 296, establishing the crime of unsolicited disclosure of an intimate image. This is more commonly known as cyber flashing. This bill, if it were to become law, would make the unsolicited sending of genitalia via electronic device a violation, with multiple offenses being a Class A misdemeanor, punishable by a fine of up to $1,000. The bill in front of you is the exact language that came out of this committee last year. It passed on the consent calendar, but was a victim of the pandemic. While it's not a pressing issue, it did seem like a larger issue with the COVID-19 pandemic. This law would be part of the harassment laws, which is what cyber flashing is. I have received these unsolicited intimate images before and is incredibly violating. It's illegal to flash someone in person, and I believe it should be illegal to do so digitally. Regardless, for the reason of sending these messages, the action of sending these images is harassment with nearly no recourse for the people who receive them. When I receive a message or an email, I expect to have a conversation, not send graphic images with no warning. These images are often sent without prior contact, purely to get a response. When I've received one, the advice I'm given is to block the sender. Indecent exposure is a similar crime with similar recourse that I'm asking in this bill, but cyber flashing can be, but a cyber flasher can send many more images at a time, which is why I think similar action and therefore similar crime. So thank you very much, and I will send this to you.
Thank you. Representative Marston,
I just have a question. I do not have a copy of 296, and where do I go to get one?
Here, you can have mine.
Perfect. Representative Bourdon.
Thank you, Mr. Chairman. Thank you for taking my question. So you said that most likely this would happen by phone, and usually these kind of crimes might be sent. These images may be sent to more than one person at a time. If that is the case, would that be one crime or multiple crimes?
I would assume multiple crimes. It would have to be reported by the person who received them. So I think that by that manner, it would be multiple crimes, but I guess it's not listed in the bill itself.
Follow up, please.
Representative Bourdon, you recognized for a follow-up question?
Thank you. The reason I asked the question is because under the provision, there's a section guilty of a violation for the first offense and a misdemeanor for second or other offenses. So I guess isn't really an important question.
Yeah. So in the original bill last term, it was going to be a misdemeanor every time. The committee changed it to a violation for the first offense at the recommendation, I believe, of the ACLU. But yes, that would be something we need to look at.
Thank you.
First, I want to thank the representative for testimony, and if you don't mind, the chair will inquire for question. And just to clarify, I was opposed to that amendment last term of making it just a first offense. That didn't work out so well with me. But I was going to ask you though, do you have would you support an amendment that changed the first offense to say either a misdemeanor or a Class B misdemeanor?
Yeah, I would be open to any amendment.
Thank you. Representative Marston.
Thank you, Mr. Chairman, and thank you for taking our questions. I have a simple question. I'm curious if this situation of unsolicited disclosure of intimate images, would that constitute a probable cause and be allowed to confiscate the computer?
That is a relatively complicated legal question, but I will allow the witness to answer it if she wishes.
I'm not a lawyer and don't work in criminal justice for the most part, so I would not be able to answer that question.
Representative Burke.
Thank you, Mr. Chairman. And there's a possibility I may have a follow-up, but the first question is, I'm assuming this is going to be only in-state because it is rare, but I get these weird friend requests on Facebook. And occasionally it is a woman that is dressed very loosely, and I'm not welcoming it, so I delete it instantly. I don't accept friend requests, and I'm like, and from what I understand, everybody gets them. How are we going to stop that from coming to us through our computers?
I would agree that this is a much better federal law than it is a state law, but I am only a state rep. I guess it would be at the discretion of, I don't really know. I would say that as the victim, it would be where the victim is, but I'm not the boss on this.
In fairness to the witness, that was also a very complicated legal question.
It was.
Back to back. So we respect the representative for hanging in time.
And if I could do a follow-up?
Representative Burr, you're recognized for a follow-up.
Yes, thank you. And thank you again for taking my question. That was, I just didn't know how to even begin to answer that last question. What would happen if if a girl was sending a boy some pictures that both of them enjoyed, and then all of a sudden they broke up and the boy says, hey, stop sending me pictures, and she continued to do that, you know, where does it become consensual to where it becomes a crime?
So if it's unsolicited, which I would say is anything that wasn't specifically, hey, can you send me this? That would make it a crime.
All right, thank you.
Representative Klein Knight.
Thank you, Chair, and thank you, Representative, for taking my question. I have a follow-up if I can after. So just for clarification, there's currently nothing in place that would allow people of New Hampshire to report a crime like this and hold these offenders accountable. Is that correct?
There is a law that applies if you're a minor, if an adult is sending a minor a image of this nature.
And my follow-up?
Representative Knight, you're recognized for a follow-up question.
Thank you. So if this were to be law, there would be some mechanism in place for reporting, getting the data of how many people sexually harass others. Is that correct?
Yeah, you would file a police report, and therefore the police would then have that record.
Representative Bolden.
Thank you, Mr. Chairman. My question for you, Representative, I've been flashed. I was on Elm Street and a man walked by. My friend and I were sitting outside of a cafe, and a man walked by, and you know, I'm sure you can imagine what else happened. And then he went to the Ben & Jerry's down the street and did it again, and it wasn't pleasant. And I agree. It makes 100% sense that if this is happening on the computer, on the phone, in text message, that it's going to produce exactly the same experience, the same unwanted result in the recipient. So I was curious, did you file this legislation because you'd had an experience that led you to the realization that this legislation was necessary? Or did you just observe that there was discontinuity between the law as it applies to in real life interactions versus online interactions? Because I know that we wouldn't have legislation like this 30 years ago because of the advent of the internet.
This Representative Bolden, before the witness answers that question, I did mute the witness for a moment, and I appreciate the question. It is a very personal question. So I'll give the representative the discretion to answer that or not, but I would just, I think you understand what the point I'm trying to make, but.
Hello. So it was part of my testimony that I have received a few of these as a state rep and then as a private citizen before that. So yes, it was inspired by that. I also had seen it in the news that other states in town, in like the city of New York, had also banned it. So it would be one of the first states. We would be one of the first states to do this, but I think it is definitely needed.
And thank you, Representative. And the chairman, no disrespect by, you know, cutting off your, I just wanted to make sure you were comfortable answering this. You had, I will say, you've had some very difficult questions in our. So, if I can just get clarification, I believe you would. The chair was asking you would support an amendment that would make this the first offense a misdemeanor. If said amendment was prepared, would that be a? Would you support a Class B misdemeanor or Class A misdemeanor?
I would support either. Whatever you think is most appropriate.
Representative Muse?
Yes, Mr. Chair, and I'm not sure if the sponsor also has the same recollection, but my recollection last year was the amendment was made to change it to a violation because of concerns over some members of the committee about a underage or teenage person doing this because this is what stupid teenagers do. and possibly having that go on, their permanent criminal record. So I think that was part of the rationale for changing it to a violation and having subsequent crimes be misdemeanors. But I'm not 100% sure, and maybe the sponsor can refresh us on that.
While there was a work session on this bill, I had my own committee to be a part of.
Okay.
So I just remembered that it was at the advice of the ACLU to make it a violation.
Thank you.
Seeing no further questions, I want to thank the representative for her testimony. At this time, the chair is going to recognize Representative Conley, who I believe is going to be introducing House Bill 200. Oh, excuse me, Representative Gabriel is representing here. You have to take the main stage. Representative Gabriel is introducing the House Bill 200 on behalf of Representative Vincent, who I believe is unavailable.
Yeah, this is 200. This bill is increasing the penalty for certain invasions of privacy. A person is guilty of a Class A misdemeanor for a first offense and a Class B felony for a second or subsequent offense if such person unlawfully and without the consent of the persons entitled to privacy therein installs or uses. And I believe that the sponsor of this bill was referring to like the bathroom and hidden cameras and things of that nature. And wanted to increase the offenses. That's about all I have. Let me see what else.
Representative Marston.
Thank you, Mr. Chairman. And thank you, Representative, for taking my question. Excuse me, I have a frog in the throat. As I understand this bill, it's just to completely up the penalties involved in the situations of all cases.
That's what it looks like to me. I haven't personally spoken with.
You didn't write.
Yeah,
And I
haven't,
apologize.
but I believe that the intent was to increase the criminal penalties for these violations.
Thank you.
Seeing no hands raised, I want to thank Representative Gabriel for assisting her colleague who could not be here today and offering the bill. If there's any members of the public who wish to testify that have not already, please raise your hand.
Oh, this is one.
Yeah, too.
While the chair is looking for his list, Representative Burt, you may call witness.
All right, thank you, Mr. Chairman. I'll be calling Audrey Friedman. Hopefully I pronounced that correctly. And Audrey?
Yes, I'm here.
Yeah.
Can you hear me?
Yes.
Okay, thanks. Aubrey Friedman, I live in Bridgewater, private citizen, just representing myself. Mr. Chairman, committee members, I totally oppose, this is on HB 296. I totally oppose this bill. And it was, as was mentioned before, the thing with the, if a couple is intimate and they're sending them and then something changes, it becomes a very hairy issue. So that's an issue right there. But the biggest thing is police are for it to take care of murders, assaults, rapes, break-ins. That's their job. And we don't need more laws on the books. This, if they have another law for this unsolicited images thing, it just takes the police away from what they're supposed to be doing, the more important work. I mean, this can be easily remedied. You get a, dirty image, whatever, on your phone or your computer, you just delete it and block it. I mean, how simple can this be? Why do you need another law? Get the police involved, the courts, don't they have enough to do? Let them work on the real stuff. And let's not forget, every new law, then you have enforcement. And when you have enforcement, you have police dealing with civilians. And you know how that works out. Sometimes somebody gets, abrasive, and then there's overreach. And a simple little incident can turn into like a deadly, somebody gets stopped for taillight not working, and it becomes a whole blown out of proportion, and somebody dies, a shooting. So let the police do the work for the important things. This is a really trivial issue that a person can fix. It's annoying. It's, I agree, it's tacky, but you can just block it. Do you really need another law for this? That's it. Thank you.
Thank you for your testimony. Representative Knight.
Thank you. I have 2 questions.
Start with the first one.
Thank you, Chair. Thanks for taking my question. What's your current relationship to law enforcement?
Are you speaking to me?
Yes, sir.
Oh, I'm just a private citizen. I don't like getting involved with police, and the less let them do their thing. And I think I got stopped once for I didn't do a signal or something like that. But I don't mess with police, and I want to have as little to do with them as possible.
Thank you. And my follow-up is, oh,
Your
sorry.
follow-up question.
Apologies. You think that sexual harassment is an inconvenience and not a serious crime?
I think it's tacky, and it's ugly, and it shouldn't be done. Should it be involving the police? No, absolutely not. When you can fix this yourself, you can just block it. What do you need to get the police involved for?
Thank you.
Representative Burt.
Thank you, Mr. Chairman, and thank you for taking my question, sir. I guess I got the same concerns, and I didn't know if you could elaborate a little bit more on it, because I was concerned also if you have a girl sending the boy picture and the boy sending the girl picture back, and then all of a sudden one of them breaks up with them. When does it become, against the law, and when, like you said, they could just delete it, but where do you think that could lead to, if that behavior happened?
It's a big mess. I mean, that becomes a he said, and she said type of situation. And they're both going to argue from their point of view. Maybe she just doesn't want to have anything more to do with him, and period. But the actual bill says that he knows that she didn't give consent. So, it's quite messy. And to make a law on this and get the police involved, I just think is just will be an endless, not going to get anybody anywhere, to be honest. That's a very messy area to get into, especially if it was a couple that was intimate and they were sending images back and forth. Everybody was happy with it. And then the relationship turned sour. And suddenly that very first text after the souring point became, that's harassment. And that is now against the law. How are you going to find out exactly? Maybe he thought that she was still consenting to it, but no, in fact, she no longer wanted to be part of that. So it's hairy. I wouldn't get the law involved in it.
Seeing no further hands raised, the witness is excused. I want to thank you for your testimony.
Thank you. Thank you.
All right, well, seeing no members of the public with their hand raised for either House Bill 296 or House Bill 200, Representative Muse, will you do the honors for each bill?
I sure will. For House Bill 296, we had 41 people signing in support and one person signing in opposition. For House Bill 200, we had 20 people signing in support and one person signing in opposition.
Thank you, Representative Muse. At this time, we will close the public hearing on House Bill 200 and House Bill 296. We probably won't hear this one. Maybe we can do 316, right? Yes. At this time, we are opening the executive session on House Bill 316, requiring a person issued a summons to remain on good behavior. Representative Testman, would you like to be recognized to make a motion?
I make the motion ought to pass. I'll second.
That, Please. 316?
Yeah. 316? Yeah.
After I took notes, you said it. Okay.
Well, good luck.
Okay.
Representative Testman, you testified that you were not supporting the bill and wanted ITL. I recognize you to make a motion, and now you want to make a motion not to pass, which is highly unusual to represent the chair that you're going to make a motion and make a different one, given that discretion of the board.
I can explain. The chief came to me months ago, and I put that bill in, he offered it, and I completely forgot. And it's a good bill. He has the idea of putting good behavior in there to clarify it made sense to me.
I would recognize you.
Point of order?
The effective date should be changed. It creates a crime, and not if it needs to be written in the book, would have to be.
I understand that, and my understanding of this, and I'm glad that we have the sponsor here to correct me, is that in lieu of being arrested, a police officer can issue someone a summons. So they now release on the summons and they're notified that they're going to have an arraignment on so-and-so date. In between the time that they have the summons and the time that they have their arraignment, this summons states they must be on good behavior. That's what this will do. I guess my question is, what would happen if we didn't pass this, but someone was not on good behavior in between that time period? Would they be arrested anyway or charged with a crime?
It would be arrested for the new crime.
So they would be arrested for the new crime, that's what I believe. And then my other question is, so the term good behavior, that's usually a condition of your release. Basically, if you don't commit any further offenses. But in here, we're not having a judge create the new conditions of the release. It's being done by the police officer, which I'm not saying the police officer is anything wrong, but I'm not sure it's appropriate for the police officer creating those conditions in the sentence. That's just my thought. But that's no disrespect to the police officer, but you may respond. May he respond without that point of order?
I have a point of order.
You are recognized for your point of order.
Thank you, Mr. Chairman. I spoke out of turn. I thought he was gonna ITL. He opposed, he presented it the opposite way, and I jumped in. I'm gonna take back my second.
You are withdrawing your second?
Yes, I am. I withdraw my OTP.
Okay, hold on. All right, I'm trying.
It's just getting better every day. Is this like Pizarro? It's Friday.
What's the flag in the football game? Help me out.
All right. Representative Marks, I'm not 100% clear you can withdraw your second at this point, but at the same time, you would the Representative Testman to withdraw his actual motion.
I withdraw my actual motion.
Okay.
Oh, God.
And is there, I'm not sure we need a second, but for good practice, is there a second to that withdrawal?
I withdraw my,
You would like to second his?
yes, I'll
request to
withdraw,
withdraw?
I'll second
Thank
his
you.
withdrawal.
Clean sweep. There's 4 minutes of there's 4 minutes of everyone's life will never get that. Okay, okay, it was fun. Would anyone, would you like to be recognized for a motion to ITL?
I don't make a motion to ITL.
Representative Marston, you wish to be recognized?
I wish. I will second the motion to ITL.
All right.
That'll move.
Representative Pantelakis.
Well, take your hand down.
She wants to cook it. She probably wanted to yell at all of us. Is there any discussion to be had? Anyone wish to speak who hasn't spoken already yet? Seeing no hands raised, the clerk will call the roll. If you're in support of the motion of any expedient to legislate, please say yes. If you are opposed, please say no.
Vice Chairman Welch.
Yes.
Representative Burt,
Yes.
Representative Hopper,
Yes, I think.
Representative Green,
If Testament does also, yes.
Representative Green, are you yesing?
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yes.
Representative Pratt,
Yes.
Representative Marston.
Yes.
The clerk votes yes. Representative Harriet Gathright.
Yes.
Representative Pantelakis.
Yes.
Representative O'Hearn.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Bowden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley.
Yes.
Chairman Abbas.
The chair votes yes.
21-0. 15.
By a vote of 21 yeas, 0.
Mr. Chairman,
Representative Pantelakis?
yes, I believe Representative Marston owes me an apology. He is not my boss. I'm elected by the people. He's not to tell me whether I can raise my hand or not.
Representative Pantelakis?
It's just my opinion.
And Representative
No,
Pantelakis?
you don't have to think.
No, I will, because I, first of all, during orientation, I said that it's an honor to chair this committee, having someone as experienced as Representative Welch as to work with me as a vice chair, and then have the dean of the house in this committee. And I certainly respect the stripes and the tenure of the representatives have been here longer than me. I did not hear any comment of that nature, but if there was anything, Representative Mark, but I would just, if that comment was made, I would find it inappropriate and not fair to any member.
Well,
You know?
if you didn't hear it, it's fine, but I just gave my opinion.
If it was said, that would be inappropriate. I would agree with the dean on that.
And we've always been able to do that within the committee.
Representative Marston?
Thank you, Mr. Chairman. I don't recall that I made any disparaging remark, and if it was taken as such, I will still extend a apology to the Representative Pantelakis.
Thank you.
Representative Marston, I do appreciate that, what you said. Thank you. At this time, I'll move for House Bill 316 to be put on consent. Will there be a majority report?
Do I have to make one?
It is custom that someone make one.
I will make one. I will do that.
Thank you very much. We'll now close the executive session, House Bill 316. 30 seconds. Looking for the paperwork. At this time, we are going to open the executive session of House Bill 307. Find the bill. And I believe that there was an amendment that was sent out. Before we begin anything, the members at home have the amendment. And just, but please turn your videos on with a thumbs up or thumbs down. No reaction is not helpful.
Representative Bradley has it, Mr. Chairman. I sent it to everybody last night about 9:30 to 9:45.
I see a prior amendment from
Which means we don't get a chance to look at it.
2024,
I don't work at night.
04, 11, 8.
11H.
Okay, I just want to make sure we got that before we begin anything. Okay. Representative Burt, do you wish to be recognized? I recognize you to make a motion.
On the amendment or on the bill, Mr. Chairman? Which one has to come first?
The chair's understanding is if you make a motion off the pass, and you wish to offer the next.
Yes, okay, I would like to make a motion of off the pass with amendment. Amendment 2021-04-11H.
Is there a second?
Wait a minute.
Hello?
I got a question.
Is that seconded by Representative Green, Representative Gathright?
Don't we have to do an amendment first?
Well, you make the motion about the pass, and then once you recognize that, he can then offer the amendment. That's,
We're ought to passing this amendment, and then it would be ought to pass.
then if the amendment is adopted, then there would be a vote to be ought to pass as amendment. So right now, we're only considering adopting the amendment.
Okay, I think it's the way it was worded. It's confusing. All right.
I've only been here 11 years.
Yeah,
You'll get it figured out.
Yeah, I will, when I get to Representative Welch's age. Right down to a science.
Representative Welch, Representative Burke, do you wish to speak to the amendment?
Yes, I do. Thank you, Mr. Chairman. Mr. Chairman, we had several concerns on the actual bill, and the amendment fixes all of those. That's it.
Representative O'Hearn.
Thank you, Mr. Chair. I guess mine would be just a question for the chair. Since I've been sitting on the Criminal Justice Committees, this is, I guess, the first time in regards to an amendment that usually when we're in executive, the amendment has to be sponsored by a committee member. And I see that there's a representative's name before Representative Burt's name, which seems kind of strange that it should only be Representative Burt's name on it. Am I incorrect or am I correct?
We had, that question came up last week or week before. I did actually check with the clerk, and Representative Welch just told me lunch over there. What I understand is this, and this is what after consultation with the clerk, is that although it's a good practice to have a member of the committee be sponsor the amendment, a member's name does not have to be on the amendment. It's still, but it has to only can be offered by a member of the committee. So if it didn't have a member's name on it of the Criminal Justice Public Safety Committee, that is still acceptable, provided there's a member willing to adopt, or sorry, willing to offer the amendment. So it's not out of order for Representative Burke to offer this amendment. Representative Muse?
Yes, just some questions. It is a rather lengthy amendment, and it looks like essentially a rewrite of the entire bill. There were several issues, more than several issues that were raised during the public hearing on this bill. We had testimony that educational institutions should be exempt from this bill. We had issues from the Municipal Association with the whole idea of penalizing municipal officials for doing their job. We had a whole series of issues, and it would be helpful if Representative Burke could speak to the differences in the between the amendment and the bill.
So Representative Muse, what I can explain is involving the issue of liability involving the individual board members, whether it's board of selectmen, board members. I understand that the amendment does fix this, at least fix that one issue. A board of selectmen or a school board member or any public official will not be deemed liable for any reason, merely for the way they voted, whether to support or object to any type of rule, law, regulation that's applicable at the municipal level. So the amendment does resolve that.
So where the changes?
And then in regards to the issues of schools, and this is something that this was actually in the first, the original draft, and I believe it's still be here in the amendment. It basically says what it does is that the schools, a school system is not allowed to make any rule. They would be preempted unless explicitly authorized by statute. So when that's the case, at the state level, there can be an authorization for expressly authorized for a school to make said rule. Under the current law, and it's RSA 193:13, the school has the authority at this time to suspend or discipline a student if they were to carry a firearm on school property while the school's in session. They would actually be the superintendent or the designee would have the authority to expel the student. When I first read this bill, the biggest concern I had was, well, would this allow a student to, let's say, open carry on school property while the school's in session? And that seemed to go too far. And it was discovered that there was a law that law would protect that from being able to happen. And I would presume that most schools would keep that rule in place.
Mr. Chair, when you say schools, are you talking about universities like the University of New Hampshire?
I'm reading chapter, this is under education, chapter 193, and that would be colon 13. Representative Gabbard?
I guess this is a question to the chair. Okay. I'm kind of struggling with this right now because this is 1, 2, 3, 4 and some change pages. And I really would like to read this. And I understand that Representative Burke sent it out last night, but yeah, at 9 something at night, I'm not actually setting up to read something like this. So I really think it would do us better to take time to read this. And maybe we can cover this on Monday, just recommendations. And we just had 2 bills that we probably could just knock out, like if that's what you wanted to do.
I understand the point. If I recall last term, we were given a 15-page bill with about, I would say about 2 minutes notice. It was like walk-in anecdotes. So this has happened before. This is not, I would say, addressed.
This is different than last term.
Well,
We have a whole different setup.
I understand that.
A lot going on.
No, I understand that, but with looking through the amendment, if members want to take time, we're still discussing it, I would encourage people to continue reading through it, and if those are the major issues been changed, the majority of this bill is, from what I understand, the same language as before. It
Well,
did, I mean,
if you can take me through and show me or tell me what was changed, then.
line by line?
Yeah.
I don't believe that the chair is required to do that, but I'm just explaining, because to go line by line, that would take hours.
Section.
It would be faster if someone actually independently read it.
Okay. Can you give us a chance to read?
You can read now.
Okay.
Not stopping anyone.
Read.
Representative Marston.
Thank you, Mr. Chairman. Can I ask a question of Representative Burt?
Yes, you may. And I do, during executive session, I encourage the free flow of discussion amongst the members.
Representative Burt, if I understand, you wrote the amendment to the bill.
I had help drafting this, yes.
Follow up?
Yes.
As somebody already somewhat stated or asked, this almost totally replaces the bill.
It does.
Is that correct?
Yes. Correct. From all the concerns, we took care of all the concerns from the previous bill that was in existence and basically rewrote it to this.
One more follow-up.
Yes.
Thank you. Why not just rewrite the bill? An amendment is, it's convoluted. I'm confused. Why not just a bill and state it?
Because how the legislative process works is I didn't write the original bill, Representative Silber did. There was a lot of concerns, and the only way to fix House Bill 307 is with an amendment. That's the only way we can do it, because we can't introduce a new bill. And we don't want to wait till next year, so it's better to, as process, many bills are amended, and that's what we did here.
Thank you.
Question.
Representative
How does this affect schools like the UNH?
Well, I know when it comes to schools, what we looked at was, the RSA 193.13, which allows schools, I'm trying to think, find the language, I got it here. It does still allow schools, any pupil who brings or possesses a firearm as defined in section 921, Title 18 of the United States Code. It allows the school boards and the superintendent to still regulate that. I have if you'd like to look at this.
Representative Testament.
I know this will
Do you want to see
fly
this?
in the face of my good friend Representative Burt and probably the chairman, but last year, when we saw the red flag bill, we had, I don't know how many replace all kind of changes. And I specifically remember the representative, who was the sponsor, coming in and doing a replace all day of the final day that we were executive. And that it ended up just coming apart and getting tossed out. And I question, somebody, all it is the same as we had before, but with a few changes. And so I said, well, who told you that? Well, the sponsor told me that. And I said, well, I don't trust the sponsor. Now, I trust Representative, I trust you, but I don't think it's unreasonable to say, let's take a look at this over the weekend, and we could vote on it. It's going to pass. I'm not worried about that. But I think, Representative Carter, you had the right answer. Give me a chance. I mean, last year, Representative said, well, I sent it to you at 5:30.
Well, I recall that was 5:30. It was the town election, sent to us on a town election day. We had to get to executive first thing in the morning. I actually took the time to read the 15 pages that were sent to me at night, then show up the next day to have an amendment there after. So that was actually particularly frustrating, because I read 15 pages for nothing. And I, at the time, still my first year, my first term, I used to like to reference the lines and page numbers. Well, you change 3 paragraphs, all my notes were completely out the door. So I can appreciate the frustration and, it is coming back, that can be frustrating. So
Second, this,
and
this amendment?
I understand we had a very long day yesterday, even a longer day on Wednesday. So if I'm assured that the members, at least we know everyone has the amendment, right?
Yes, we got it.
So that solves that problem. No one did not have it. So if you don't have the amendment, you maybe give me a thumbs up or a thumbs down.
I don't have it.
It's in our email.
All right,
Well, I'm sorry, but I didn't get to do my email this morning.
what we'll do,
Went into session at 9 o'clock.
yeah, what we'll do is, for the time being, rather than answer a bunch of questions about the bill, the feeling of the committee is that people want to have more time to read the amendment. So why don't we recess this executive session? You can save the questions about this amendment until a different time.
Thank you.
I'll make a hint. Monday, March 1st.
Yes.
I don't know the time, but it will be between 9
and 4.
Whenever Representative Conley gets here, slightly after 9, maybe closer to 5. But, so we'll do that. So what we'll do is the executive session of House Bill 307. Guys, we have members. We have a lot of bills that we need to exec. We can answer 10 questions on this. If they're above this amendment, we can talk after. But let's exec as much as we can, please. So
thank you.
307 is now recessed. You have the amendment for 471.
I do.
Before we open the next session, I'm gonna give you a hint, it's at HB 471. For the members at home, there is an amendment that was on that. I assure you that it's much shorter than the amendment on HB 307.
Parliamentary inquiry.
I'm not taking any questions at this time. I'm just simply asking if people, I asked the question and I didn't even get a response from everybody yet.
Good.
Yeah, but they were different amendments.
I got the bill, but I don't know if I got the amendment.
Pass out this one here.
Thank you.
Point of order, Mr. Chairman.
We're not in any type of hearing to make a point of order. I'm just simply trying to see if everybody has the amendment. If you want to interrupt while everyone's looking for stuff, do what we want to do. We're not in any formal hearing to make a point of order. There's no ruling that I made for you to even challenge. That a point of order requires the chair to make a ruling, and then you challenge the ruling. We had a very appropriate challenge of the ruling, a point of order today, where I let someone else speak and before anyone else said yes. That's challenging the rules and follow the committee. We're not even in a hearing. Please let me see if everyone get the paperwork out, and then we will start. So we have the amendment, Representative Newman. That's what we're trying to figure out.
Since we are not in a hearing, could I ask a question of the chairman?
Yes, ask a question. But
Thank you. My only question is, and I know what a point of order is. I know I know how sensitive you are about correct parliamentary language. My question is, I did not hear the bill number, and all I wanted was a clarification. So if I could have that, please, that would be helpful in finding the material, because we don't have a list of the bills to have that already.
HB 471.
471. Thank you very much, Mr. Chairman.
Representative Pantelakis?
Yes, Mr. Chairman, in all due respect to you, we're not used to hearing a bill and executing it, so please be patient with me. I'm not anyway. Maybe the rest of them are, but I'm not. So please be patient with us.
Thank you, Representative Pantelakis. I appreciate the comments. Now, does everyone have a copy of the amendment? Just a thumbs up, thumbs down? Representative Newman, it should be in the email, and
I'm looking, Mr. Chairman.
in
So when did we do 471?
the amendment, from what I understand by Representative Welch, it was one of those disciplinary hearings.
Oh, the first day, I think. 55.
And I believe the amendment, according to, and I don't even have it in front of me, but I believe it's only adding one sentence to the original bill. And I believe that Representative Welch will speak on that amendment. But it's obviously the preference that people are able to access that, so.
Well, how come 471 is relative to police disciplinary?
Let me open the hearing first.
Yeah.
In regards to emails, can you just re-forward a copy? Representative Newman?
No, Mr. Chairman, I have the copy.
Okay.
I was just going to tell you, the assistant sent the copies out just now in the email. Thank you very much.
At this time,
Mr. Chairman,
Representative Androgis.
Mr. Chairman, I'm not trying to give you a hard time, but it's very hard to hear about an amendment that you can't get up and just walk to the table and get like we used to be able to. I know it's very hard on you too, but
I agree, and
you're doing a good job.
I think we're doing, overall, we're doing our best, and I think we're all getting better each time around. But this amendment's at least shorter. That's the one thing I can promise you all. So let's open the executive session. This time we are opening the executive session on House Bill 471. It's relative to a police disciplinary hearing. At this time, the chair is recognizing Representative Welch to make a motion.
I move House Bill 471 be not to pass as amended.
Second,
And just to clarify, that amendment is that 2021-0386H?
Right.
Representative Welch, do you wish to speak on the amendment?
Yes, during the hearing, we had testimony from a retired law enforcement officer who made the point that while this bill opens the disciplinary hearings up to the public, there are some things that shouldn't be in the public. For instance, the suggestion that the person, the present language of the bill talks about the ability for an involved party, presumably a police officer, to seek closure of a portion of the hearing that would disclose confidential, perhaps solicitous information related or perhaps not related to the allegation. That we also support. However, the bill suggests that the party must prove with specificity that the portion of the hearing will reveal confidential information that creates a compelling interest outweighing the public's presumed right of access. And he included a suggestion as how we should change that. So while the bill says, the original bill has the one sentence added to it, any disciplinary hearing shall be public. However, a portion of the hearing may be closed to the public only if the party seeking closure can prove with specificity that the portion of the hearing will reveal confidential information that creates a compelling interest outweighing the public's presumed right of access. The amendment adds to that this sentence: the council may, in a non-public session, hear and consider the request for closure and rule on such request. That way, I think we'll cover everything.
Representative Martin.
Thank you, Mr. Chairman. I have a question on the amendment in the wording of who or what is the council?
Police Standards and Training Council.
Thank you.
Representative Bournet.
Thank you, Mr. Chair. This amendment takes care of the questions that were raised during the hearing. I can support it full-heartedly.
It does. In fact, it's pretty much the language that they suggested.
Who seconded it?
Laura,
Okay, so Representative Candelabras.
yes, I'm sorry.
I'm done.
Representative Conley, thank you.
I have nothing to say. I have nothing to say. I agree with David.
Thank you.
Make the motion.
Representative Conley, you're recognized.
If I get a question, Representative Welch.
You may.
Representative, do you, I'm sort of looking to you for your expertise. Do you feel that, or do you have concern that this language could essentially make the entire hearing be, somebody can make an argument to essentially put much or all of a disciplinary hearing behind closed doors based on the language here, as opposed to a smaller part? I mean, you see that with cities and towns going behind closed doors to make certain decisions, that they can cite that statute with basically at any moment. And I guess I'm curious, is this sufficiently narrow in your opinion?
I guess it would depend on what the hearing is about. There could be any number of issues, some of which may actually be entirely non-public. All depends on what's being argued.
Okay, thank you.
And Representative Conley, I think that the concern was this was legitimate, that if someone were to assert confidentiality, that's one step. But if it were to be challenged, but if the board did not agree that confidential, subject or the hearing was involved confidential information, in order to argue that one way or another, it would be rather difficult without breaching the confidentiality. So the idea is to kind of to close that hearing, the hearing off, to argue that point. If it is confidentiality, then the board will also make a decision whether the public interests are waived. But I would agree that there would be no effective way to argue that point without violating confidentiality. For example, if it involving a confidential informant, it could be not only problematic for the officer to say that, but disclosing the identity of the confidential informant could put that person in safety concerns.
Understood. Thank you both.
I mean,
Representative Kessler.
if they get out of it, if it's obvious that they're violating the spirit of this, behind the close of confidentiality, we can always open the hearing up much more by changing the law. And I know why they want to do it. I mean, it's not like the Nashua School Board that just closes it for the heck of it, but
that's not nice.
in this case,
It's not nice.
Representative Justman, specific references, especially to, we have two representatives, members of the committee that are from Nashua. We don't need to open that can of worms for them to have to defend the school district, nor is the school. And that is a school board hearing, not a police discipline hearing.
Yeah.
So even the analogy is, thank you. You may continue.
That's fine. I just, we can always come back and readdress this if they decide to get out of hand or they're being a little bit too lenient with their closing of the hearings.
All right.
Representative Marston.
Thank you, Mr. Chairman. Just all of a sudden, we interrupt the chain. Mike, I have a question regarding, this is a disciplinary hearing, and I don't know if we asked it when the bill was being discussed or brought up. Are there a lot of disciplinary hearings? Is there hundreds of them every year?
I got it.
No, not hundreds. There's a few now and then. In fact, I've had 2 law enforcement officers decertified because of
But
testimony.
that's different. That was decertified.
Well, it's a hearing. A disciplinary hearing, which resulted in them being decertified.
Follow up?
You may follow up.
I'm under the impression that a disciplinary hearing and a decertifying hearing is 2 different hearings.
It could be. One would run, one's gotta come first.
So again, a follow-up?
You may.
So what I'm trying to understand here is if there was just a hearing every now and then, once in a great while, it should be opened. But if all of a sudden the police, that council, as you called it, if they're hearing disciplinary hearings constantly all the time because the public at large finds out, oh, we can just make an accusation and it's gonna have to be a hearing and it's gonna have to be open and then they're gonna just expand and expand and expand on it and now they're doing hundreds of these kinds of things. Wouldn't that be deleterious?
If they're gonna do hundreds, they're gonna do hundreds whether we know it or not. And I
If
think
it's in
best
secret, you don't get that.
Representative Pantelakis?
Yes, thank you, Mr. Chairman. I think the only reason, or one of the main reasons for these hearings before that board is to really fire them. They can't work in the state of New Hampshire. Other hearings I have heard by their chiefs and board of police commissioners. So I don't think we're going to hurt anybody by passing this.
Representative Byrd?
Thank you, Mr. Chairman. I'm not sure who wants to answer this, but who is going to police this? Because I know in my town, they hide behind confidentiality all the time with personnel matters. They'll just say, oh, hey, let's talk just an inch about personnel matter. And then the whole meeting is under wrap.
This specifically limits the portion of the meeting that raises the issue of confidentiality. It does say that, so.
Okay.
They can't simply make the whole entire hearing. Like today, if we were discussing confidential, we couldn't make the whole day closed. That would not.
So this, if I may, Mr. Chairman, so this will clarify that to them, that cannot happen.
Yes, it's very specific that someone has to raise the issue of confidentiality. It's almost like it's parallel raising a privilege in the courtroom. And you can challenge the privilege and say, I don't know, I don't agree that's the privilege. It can then be ruled on. If the board rules that it's privilege and confidentiality different, but the board rules that way, it agrees that it's, even if they find it as confidential, they still have to make the determination that, not disclosing the confidentiality outweighs the public interest. So even if it is confidential, there's possible it could still be disclosed, but the argument for that is going to be done here.
Okay, thank you for clarifying.
Representative True?
Thank you, Mr. Chair. Just maybe clarification from the chair. A couple of people, I believe, have made reference to other meetings. Representative Welch made reference to a particular council. Well, this only deals with the police, whatever Representative Welch called it. It doesn't refer to meetings by towns.
No, it does not.
Doesn't even affect a meeting by town. Only if perhaps if somebody could say the name of the council again.
Be the Police Standards and Training Council. And by the way, the AG has a position on that as well. I think there's 2 members of the public and other law enforcement people.
65 in support, 2 opposed.
Does anyone else, any other members who have not spoke yet wish to speak? Seeing no hands raised,
I'd like to read one part of the testimony, to make it clear.
Representative Welch, you're recognized.
Yeah, this is the actual testimony that we got from former police chief in Dover. And he starts off on his testimony that the New Hampshire police chiefs are in support of public hearings on matters involving police conduct and allegations of misconduct or abuse of office. That's pretty clear. They support it. But it didn't support it was the fact that we're amending. The council may, in a non-public session hearing, consider the request for closure and rule on such request.
Representative Marston.
Thank you, Mr. Chairman. I'm now starting to recall our hearing on this, and I remember asking a question because we had a young lady that wanted to testify, and she did. But what I'm getting at is, this is taking the policemen, in my mind, and hanging them out to dry, if you will, the phrase that's been said many times in different things. Because we're gonna have a public hearing, whereas I think if you're gonna discipline one of your officers, that should be done behind closed doors. It's not something that should be splashed across the newspapers and the radio stations and embarrass the officer. He's gonna be disciplined, and I don't have a problem with that, but making it a public hearing, I find it a little intrusive, and I like to protect my policemen because I don't want that guy afterwards going off half-cocked or maybe even resigning, and we need as many policemen as we can get. With that being said, I will vote nay on the ought to pass.
Representative Marston, although I appreciate the comments, I think whether a member votes yay or nay on the amendment, I think this is not something that's meant to harm police officers. I mean, I respect police officers. They have the public service they provide is it's an essential part of our society. And I'll tell you what, they are underappreciated, and and that goes for a lot of first responders for that. There is also a public interest on the right to know. So when these happen, if there's a disciplinary hearing, there is a public interest to know what the circumstances relate to that incident, especially if it can involve exculpatory evidence, which is a mandatory disclosure in some circumstances. There's a circumstance where the public has a strong interest to have the information on what the circumstances around the hearing is. I don't believe that that's necessarily going against or putting our police officers in harm's way, and that's why the confidentiality provisions. A lot of us members felt it was important to address that concern before passing. So this amendment does address that. That was, I believe, the biggest primary concern that was the Houston Police Association. I believe that was the primary concern that they had, was the issue of confidentiality and how that would be addressed. Representative Knight.
Thank you, Chair. Thank you, colleagues. I'm going to be voting on ought to pass because the prime sponsor I respect and admire the experience that he brings to the table by being. He used to be a police officer, correct me if I'm wrong. And I think we're in a very tumultuous time, and part of our responsibility is to mend the relationships between our communities and our police officers. And this gives us a choice to start doing that because people want to know that the police are being held accountable, and there's no transparency of that right now. So with that, I think this protects the police officers and highlights, separates a potential bad one from naming all of them bad and damaging the trust of communities. I think this is a a much needed bill that can repair our relationships with the police. Thank you.
Representative Rhodes?
Thank you, Mr. Chairman. I agree with Representative Klein Knight. I think that if you're going into a hearing, it isn't because you didn't do anything wrong. And I think that it's unfortunate, but I also think that there's reasons that a lot of the public, their perception is that a lot of times officers feel like they're above the law. That's not necessarily my opinion. That's just what I hear to be the opinion of others. And I think this is just, I think this is a good thing, actually. And you're still going to protect. I mean, if there's a victim specifically that doesn't want their name to be said, or, you know, that's all going to be kept secret as well. You're not bringing that person into the light. You're just bringing the charges into the light. Two times.
Representative Pantelakis, I believe I saw her hand raised at one point.
Yes, I just wanted to clarify that I wouldn't want to hurt any police officers either. But I was told that it was when they went before the police standards and training for disciplinary, and that has to be very bad to be sent up there. So I believe in this bill.
Representative Gaffrey?
What, I just want to say that the only thing that changed in this amendment is the very last sentence. That's what was added. Which is a good thing.
Well, I told, I probably should be much shorter than the last one. I know this is, I saw the skepticism. All right, seeing no further hands raised, the matter will be put to question. The clerk will call the roll. This is the question to be considered is whether to adopt amendment number
03868.
You heard it? If you are in support of adopting the amendment, please say yay. If you are opposed, please say nay.
Vice Chairman Welch.
Aye.
Representative Burt.
Yes.
Representative Hopper.
Yes, ma'am.
Representative Green.
Yes.
Representative Testerman.
Yes.
Representative True.
Yay.
That's somebody.
I know, hold on.
Yes.
Wallace.
Representative Wallace.
Yes.
Representative Testerman, Representative True, Representative Pratt,
Yes.
Representative Marston.
Yes.
The clerk votes yes. Representative Harriet Gathright.
Yes.
Representative Pantelakis.
Yes.
Representative O'Hearn.
Was he here at the beginning of the call?
I think so.
Oh,
I can't see.
He might have gone to work.
He was so much fun.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley.
Yes.
Chairman Arbus.
the chair votes yes.
Mr. Chairman, the vote is 20-0.
By a vote of 20 yeas, 0 nays, the amendment 2021-0386H is adopted. Representative Welch, do you wish to be recognized to make a motion of ought to pass as amended?
I move House Bill 471 be ought to pass as amended.
Second.
Representative Vargas has now seconded that motion. Seeing no hands raised, the clerk will now call the roll. If you're in support of the motion of ought to pass as amended, please say yea. If you're opposed, please say nay.
Vice Chairman Welch.
Yes.
Representative Burke.
Yes.
Representative Hopper.
Yes.
Representative Green.
Yes.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
Yay.
Representative Pratt.
Yes.
Representative Marston.
Having been shown the errors of my ways, I vote yes.
The clerk votes yes. Representative Harry Gathright.
Yes.
Representative Pantelakis.
Muted.
Sleeping again.
Yes. I'm tired. Yes.
Okay.
Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Golden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley.
Yes.
Chairman Abbas.
The chair votes yes.
Chairman, 20.
By a vote of 20 yeas and 0 nays, the motion about to pass as amended. It's passed. I'll move to put that on consent. Representative, you're preparing a majority report.
I will do that. Who do I send it to beside you?
Send it to myself and to the committee assistant.
Okay.
At this time, we will close the executive session on House Bill 471. And we will be in recess for just 5 minutes. We will be doing more executive sessions. We have more to go.
On what?
I'm telling you, we have 296. There's going to be a CACRA, which is still in committee. We really, there's going to be a reconsideration on that one. And we're not going to do 307. So I'm not sure of the order, but we're going to be in recess. I'll just put a specific time. We're going to be in recess to 4:05 p.m.
Can you find out if everybody got the CAC?
Do you know what bill you're gonna accept?
While we're on break.
Yes, I know, we can do that. We are now in recess until 4:05 p.m. Because members at home, please give a thumbs up or thumbs down if they have the amendment to CACR 8. If you don't have.
Yep.
Oh,
Question of the chair.
Chair's gonna step up.
Could you just repeat the numbers of the bills that you're going to do? I didn't have a chance to copy them down.
We have HB 200, which was today. HB 296 and CACR 8. I'm not guaranteeing in order, but we just had the hearings on 200 and 296.
Thank you very much, Mr. Chairman. That information is very helpful.
And I hope you have the amendments. The CACR.
I've seen that one somewhere, so I'm going to go get it.
Okay, everybody.
If anybody is in the room that is doing a minority or a majority report, I would just ask that you make yourself a little note. When I go home, I don't take this paperwork with me, and people all, reach out to me at home. I don't have the answer to people and what, so. Talking to you specifically.
Well, I thought Karen would have a copy of that access.
Well, the she normally does, but I don't think it's
Chairman.
must be,
You
so that they have
left
to
the
get the
room.
book and they
The room is not muted.
email everything to her.
It appears that we have already voted on CACR 8.
John, they're on recess.
You can answer the question for
Yes,
me.
that is correct.
It's going to go for reconsideration.
Recommitted, that's correct.
Recommitted or reconsideration?
Yeah, reconsider it. We're gonna do something with it, that's for sure.
So just letting them know.
I'll leave it on.
David, you're not muted either if you're interested.
Oh, thank you. I'm not saying much, so. but
That's
thank-
okay. It's all being recorded though.
Okay.
What are you looking for?
I'm looking to see if there's any mail.
I have not looked. There may be mail, there may not be mail. What are you doing? Do not do this to me.
I'm turning on the vent because there's smoke coming out.
John, you're not muted.
You've never flown a
All right, guys, we're gonna get back to it.
Representative
We'll
Conley,
wait for,
do you have a note
Not
in
after
your,
that.
for your 270? Or you remember? Your majority report?
Yeah, I'll do that.
Yeah.
Thank you.
Karen gave me a form, so I'm just trying to keep track of it.
I'm gonna do the majority.
Yes.
Put that down. Let me check that.
Minority,
It was gonna be me, but she's gonna go.
Oh, okay.
And that can happen.
so IT, your motion would be ITL?
I know, no,
Yeah.
listen,
I think that might be.
that's why that was the joke, right?
Did you want to do that?
What was the
Or were you
retention?
happy with it?
Yeah.
Did you want to?
Short, son.
Somebody was gonna do it.
Can you just keep the question marks?
we have a voting process today, there's still.
I think you were trying to get it up close.
Remember that, Mark said I talk about it?
But anyway, I
Well, I can
got.
get my 10 PM. I don't understand why it's a problem.
I don't know how many-
Sometimes you're supposed to- Well, no, I. Mine are in law. And I work.
Okay.
Do I have?
Actually, at this point, I just can't choose.
I thought I did mine.
I was just.
I had one now and I sent it to you.
I'm not ready.
Right now.
Right.
All right, just.
That's the only thing I realized.
You can work with that.
No,
I've been seeing my class for a decade.
We all ready to rock and roll?
Do it.
You on mute? Unmuted, mute.
We are live
You're live?
and transmitting.
Speak for yourself.
All right. Thank you. At this time, we are reopening the executive session on House Bill CA-CR8. Here recognizing Representative Burke to make a motion.
Yes, I'd like to.
What's the, you're asking to reconsider.
Reconsider, I apologize, I drew a blank.
Motion for reconsideration.
I would like to make a motion to reconsider CA-CR8.
And is that seconded? Can the person please speak? Representative Wallace, would you recognize?
Thank you, Mr. Chair. I second the reconsideration motion. Thank you.
Just, never mind.
Representative Boardman.
Thank you, Mr. Chair. I consider reopening this amendment is a waste of time. And if you want to bring up a new amendment on the floor, I think that would be a better use of time for both our committee and the House. Thank you.
Thank you, Representative Bourne. The bill is still in the committee, so we're permitted to reconsider it if the bill is still in the committee. If it was out of committee, it would either have to be a floor amendment or recommitted to the committee. But if you don't support the amendment, that's a different conversation to have. But seeing no hand raised, the clerk will call the roll. If you're in support of the motion of reconsideration, please say yay. If you're opposed, please say nay.
Vice Chairman Welch,
Yay.
Representative Burke,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harriet Gathright,
No.
Representative Pantelakis,
No.
Representative O'Hearn, Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman Abbas.
Chair votes yes.
Mr. Chairman, the vote is 11-9.
By a vote of 11 yeas and 9 nays, the motion for reconsideration, CACR 8 has been allowed. Then I recognize Representative Byrd to make a motion.
Thank you, Mr. Chairman. I would like to make a motion of ought to pass with an amendment. 2021-05-168.
Thank you, Representative Byrd. Is there a second? That's seconded by Representative Green.
2021-05-68.
And Representative Byrd, do you wish to speak to your motion, or the amendment?
Yes, I would, Mr. Chairman, and thank you for bringing this, allowing me to make this motion. The amendment is very easy. We cleaned it up. It basically says that the New Hampshire Constitution shall be enforced and not allow our law enforcement to enforce any federal gun related and laws that they may pass.
Thank you. Seeing no hands raised, the matter put the question, the clerk will call the roll. If you're in support of adopting amendment 2021-0516H, please say yea. If you are opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Byrd,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston.
Yay.
The clerk votes yes. Representative Harriet Gathright,
No.
Representative Pantelakis,
Oh,
Representative O'Hearn, Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman Abbas.
Chair votes yes.
Mr. Chairman, the vote is 11-9. Motion passes.
By votes of 11 yeas, 9 nays, the amendment is adopted. Representative Byrd, you making a motion ought to pass?
Yes, I am, Mr. Chairman. I'd like to make a motion, CACR 8 ought to pass as amended.
Representative Wallace?
Thank you, Mr. Chairman. I'd second that motion of ought to pass as amended.
Mr. Chairman, if I could, the motion to reconsider was Representative Byrd, but I was not able to get who seconded that motion. Do you know?
Seconded by Representative Wallace.
Thank you.
Representative Knight?
Can I make a motion to reconsider a bill? So that's a question of the chair.
At this time, there is a motion already made. It's not proper to make a motion. It's not in order to make a motion for reconsideration. And you would have to be recognized to make the motion, which you have not. Representative Muse?
Thank you, Mr. Chair. I would just like to say that there is nothing in the amended version of this bill that makes it any better public policy now than it was a week ago. I plan to vote against it.
Seeing no hands raised, the matter we put the question, the clerk will call the roll. If you in support of the motion about to pass as amended, please say yay. If you are opposed, please say nay.
Vice Chairman Welch,
Aye.
Representative Burke,
Yes.
Representative Hopper,
Yes.
Representative Green.
Yes.
Representative Wallace,
Yes.
Representative Kesterman,
Yes.
Representative True,
Yay.
Representative Pratt.
Yes.
Representative Marston,
Yay.
the clerk votes yes. Representative Harry Gathright,
Nay.
Representative Pantelakis,
No.
Representative O'Hearn, Representative Bordenay,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman Abbas.
The chair votes yes.
Mr. Chairman, the vote is 11-9.
By a vote of 11 yeas and 9 nays, the motion is brought to pass as amended. Okay. Representative Wallace?
Thank you, Mr. Chairman. Just a point of order, friendly reminder, members need to be visible on video when voting.
Thank you. Although a point of order is not normally appropriate while in the voting mode, I suppose this, in regarding whether someone's camera is on or off, if it's not on or, if it's not on while they're voting, I'm assuming it's done by incidental, just please point out to your chair. I would not find pointing that out of order for myself, really by any means. But
I don't have concern with all of this.
would there be any majority report?
Yes,
Representative Berger, will you be preparing a majority report?
I will.
Will there be a minority report?
Yes.
Mr. Chair, I believe you have a minority report already on this particular bill.
We can discuss that at a different time. Thank you. We now close the public hearing, excuse me, the executive session, CR8. At this time, we open the executive session on House Bill 200, increasing the penalty for certain invasions of privacy. I don't have anyone recognized to make a motion, so if someone that would like to speak, you can offer any type of motion. The floor is open. One. Representative Conley.
I don't have a comment.
This is the Nutting Wong bill, correct?
No. Which one did you
This is
say?
Representative Vincent's bill.
I will do by 3-0.
Okay, good.
Is that seconded?
Yes, I second it. Yes.
Representative Gabbard.
Yes, I second it.
Second the IPR.
And if I may speak to that motion briefly.
You are recognized to speak on the motion, Representative Conley.
Thank you. Representative Vincent is, he lives in Somersworth District, that's part of Dover. I know him well. This has been indisposed this week. I know he would have liked to have been here to explain more about what his bill was about. He had approached me to co-sponsor this bill a while back, and it really was intended to put more strength and more teeth behind sort of egregious invasions of privacy involving exactly what it sounds like, cameras placed in places they shouldn't be. I would have liked to have known more about this, having not had that opportunity. I think IPL is the best course.
Thank you. I will state that, and I understand he's on here, this bill is relatively straightforward. It involves really disclosing intimate images that were, one, the image was, or video was captured without the person's consent. And then it was publicized. It does create exception if you have a wildlife camera on, I suppose that's outside, and if a person's nude or engaging in a sexual act outside, there's not really as much of an expectation of privacy as much as it would be inside your home or at least inside of the building. But what happens is that people nowadays, there's cameras everywhere. And people make recordings. I mean, people take screenshots. There's a lot of inappropriate things that can be done with a camera without someone's knowledge or consent. And if that were to be done and then it was to be shared, I will say that just once it's out there in cyberspace, it's probably never going away. I mean, I hate to, not naming any names, but when it happens to celebrities, unfortunately, more than, you know, that's when it gets a lot of news. But once it's out there forever. It's not going away. It's a permanent injury. The person will be 20 years old when it happens, and when they're 50, that new photo will still be up. So what this will do is Representative Newman, you're on the phone while we're in an executive session. Thank you. What this would do is simply, this would increase the penalty. I think for the, right now, the first, it's a misdemeanor, but what would happen for a subsequent offense, it would be a Class B felony. As wrong as this act is the first time, I think it's worse to do it second. That's just my thought on it. But you're on a motion ITL. Probably you may respond in part of I would say a healthy discussion.
Yeah, I mean, so I respect that. And you may have brought me along. I mean, I would have liked to learn more about it. The concept is sound. Your description, I think clears some things up. So if seems like a good faith effort, and if the will of the committee is to make another motion, I'm happy to pull mine back and to try another approach.
We've had several motions withdrawn in this committee. So you're free to withdraw your motion.
Mr. Chairman, I'd be happy to pull that motion back, withdraw that.
And just to make it consistent, would there be a second to allow Representative Conley to withdraw that motion? Then seconded by Representative Rhodes. Representative Conley, would you be recognized to make a difference?
I would like to move on to pass on.
Representative Gabbard.
Yes, I have a problem when we try to increase penalties. I really do. So that was my problem that I had with this, but unfortunately, I wasn't able to talk to the prime sponsor. So I cannot vote for this in good faith with penalties increasing.
So what we need to do is right now, I appreciate the comment. There's been a motion now ought to pass. The question now is, will someone second that motion?
I'll second.
That is, Representative Rhodes, you recognize to second the motion.
I would like to second the on to pass motion from Representative Conley.
It's now been seconded. Just to clarify, so repeat, when enhancing penalties is a concern, and I understand that there's different movements in enhance some penalties and reduce others. And I understand we all have different opinions, but what this does, this really enhances the second offense more than the first. So the first offense will not be, let me correct that, Roman numeral 3, at the very bottom, the person is guilty of a Class A misdemeanor, the first offense, and a Class B felony for the second or subsequent offense. The way that is written, it just says, when it says just misdemeanor, and this is just maybe a learning point too. And I was taught this by the chairman last time. If you ever read an RSA and it just says misdemeanor, it doesn't say A or B. That means it's likely an older law, but what that does is that the prosecutor, the district attorney, has the discretion to then charge that as an A or a B. Most laws written now today will specify A or B what they wish. So, and the difference is with a Class B misdemeanor, there's no chance of any jail time. So when you look at Roman numeral 3, where it says a person is guilty of a, now specifies Class A misdemeanor for the first offense, before that was within the discretion of the prosecutor, or the district attorney. of how to charge them. This will eliminate that. And then it's then a class B for the second or subsequent offense. It doesn't keep elevating to eventually a class A felony. So when I say that it doesn't enhance any penalties for the first offense, that's not entirely accurate. But it would eliminate that discretion. Sure. My understanding is a lot of these are, when this would occur, is normally charged as a class A misdemeanor. That's just from what I hear in the community. So that may clarify that. Representative Muse.
Yes, thank you. This is actually a bill that we heard last year. It was HB 1175. And we passed it in committee 19-0 after we decided to amend it. And last year, our debate mostly focused on the fact that originally what the bill did was it made even the first offense a Class B penalty. And so I have a note that Representative Welch had submitted an amendment that reduced that to a misdemeanor. So that is sort of where we are, and just kind of looking through the bill, it seems to be what we passed last year, 19-0. One of the issues that we have sometimes when you have bills that kind of go over multiple sessions is, you have notes and longer memories of the testimony. And one of the things that stuck with me in the testimony for 1175 last year was that we had a sitting state representative who came and testified in a really kind of a heartrending way, and described how this had happened to her. And she had been in a situation, where time after time after time, somebody that she trusted used a hidden camera to take pictures of her, video of her that he put out on the internet. And to sit there and listen to that story was just heartbreaking. And I know we didn't hear that testimony this year, and we hear so many bills that sometimes the testimony in individual bills can be really hard to remember, but this particular one did stick with me. This is another one of the bills that sort of disappeared into the COVID haze last year. It would be really nice to sort of pick out of the haze and find a way to support.
And Muse, I am 100% in agreement with you on this one.
It happens.
Representative True.
Thank you, Mr. Chair. Probably a question of the chair. I'm just trying to figure out what a felony charge is and misdemeanor. So I think if I'm reading it correctly, a misdemeanor could be pled down or even just charge you with a violation, like having a tail light out. But a Class B is up to 7 years in jail, $4,000 fine, and 5 years probation.
Well, let me clarify this. So a Class B misdemeanor, there is, okay, well, is it a misdemeanor or felony?
Felony. It says felony in here.
Oh, well, I understand what the bill says. I asked Representative True, because Class B misdemeanor.
A misdemeanor can go down to, they can charge you, the state could charge you with a violation.
Essentially, it's not exactly the same as a violation, but because it's still a criminal offense, a Class B misdemeanor, but the only penalty is a fine. There's no, you can be on probation as well, but you can't, there's really no chance of, you can't be incarcerated. But the Class A, you can't.
I'm just trying to figure out what the Class B is. Class B is when you're sent to jail for up to 7 years.
Class B is when you go to state prison.
Yes. And that would be the second offense, which is my understanding. And I will say that if a person does this once, it is inherently wrong. We talk about as intimate of an act as it can be, to secretly record that person without their consent, and then to distribute that, and that I would, in a domestic violence context, Often these images are often used as blackmail or to enhance abuse. They use it as a form of abuse, meaning they will threaten to disclose it or publish it in exchange for, I don't need to get into the details, you understand what I'm saying, so. Happening a second time, I can't imagine, I mean, now we're dealing with, it's more of a pattern. I don't have a problem with increasing to a felony. Representative Knight?
I actually would really appreciate to see this law passed for a lot of people's protection. I've seen some mentally ill people being photographed and taken advantage of in Manchester, and their images were disseminated by a public official on social media pages where everybody, like I said, shamed this person that was unbeknownst to them. And that's it, that's there forever. So I would really appreciate this being passed, I think. Thank you.
Thank you. Seeing no hands raised, the clerk will now call the roll. If you are in favor of the motion of ought to pass, please say yay. If you are opposed, please say nay.
Vice Chairman Welch.
Not gonna like this. Nay.
Oh, okay. We're still friends.
Representative Burke.
I'd like to follow Representative Welch.
All right.
No.
Representative Hopper.
Yes.
Representative Green.
No.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
No.
Representative Pratt.
Yes.
Representative Marston.
No.
The clerk votes yes. Representative Harriet Gathright.
David threw us off. Sorry.
Yes.
Representative Pantelakis.
Yes.
Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Maybe so. Oh.
Yes, yes,
Representative Bolden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley.
Yes.
Chairman Abbas.
Turn my video on. The chair votes yes.
Mr. Chairman, the vote is 15-5.
By a vote of 15 yeas and 5 nays, the motion ought to pass passes. I will not be going on consent. Will there be a majority report?
No.
That's
No, it doesn't.
Well, Representative Conley will be writing the majority report. Will there be a minority report?
No.
All right. At this time, we can open the executive session on House, oh, excuse me.
Oh, before you close, there may be a minority report.
Can you let the chair know by 10 p.m. tonight?
I can let the chair know before we leave today.
Thank you, Representative True. This time, we will close the executive session on House Bill 200. This time, we will open the executive session on House Bill 296. Let me just find the bill.
I gave away my 226.
Establishing a crime for unsolicited disclosure of an intimate image. Would someone like to be recognized to make a motion for
Sure.
that?
I move that ought to pass on HB 296. I think it's a good bill. And for a long time, we've been trying to address this issue.
Representative Gaffney has made a motion of ought to pass. Is there a second?
Second,
That motion has been seconded by Representative Pantelakis. Now open it up for discussion. Representative Gaffney, do you wish to speak on the motion?
I just did. I wasn't in here, I think, when Prime Sponsor testified, but I remember this bill from last year. We did have it. I don't remember what the vote was. I'm sure someone on the team might remember, but it's a great concern with what happens electronically now with cameras. It's sort of like the bill that we just passed. They're very close in nature about unwanted or unsolicited. Of intimate images. So, with that said, I think it ought to pass.
Any hands raised?
I have one more comment.
Excuse me.
The other thing that I liked about this, because I remember, I think it was last year, originally the penalties came out, they were really strong penalties. And I want to say it was David or either me that talked to the violations. And so this one started because we worried about young people and everything at the same time. Last term, we talked a little bit about, you know, how silly they can be. And so the prom sponsor, she said she had agreed that the first offense would be a misdemeanor and for second or subsequent offenses. A violation first and then a misdemeanor, sorry. I think you were trying to make it heavier.
That is a correct statement. That the last term as a representative, I fought very hard to, I think I did a good, well, I didn't do a good job. That did not happen. Speaking to members of this committee, despite being the chair, I still don't think I had the support for that. So I am the odd man out of that. But at the same time, just because it's not perfectly drafted the way I want, it's still creating a good policy. And I would support the not to pass. Even though I would have liked an amendment better. Representative Bolden.
Thank you, Mr. Chairman. I just wanted to share that the docket for the 2020 bill shows that this committee passed the bill 20-0, and it was on consent, I think, as well.
Thank you.
Representative Muse.
I was going to say that Representative Harriet Gathright has a really good memory. The one additional thing that we did in the subcommittee last year was the ACLU during the public hearing had an objection that the original bill didn't have a requirement that the recipient actually be harassed, annoyed, or alarmed by that electronic transmission. So one of the things that we did in the subcommittee was we made that change along with the change to the penalty, and that's what we passed 20-0 last year.
Representative True.
Thank you, Mr. Chair. Relying on everyone's memory, or Chair's memory, from last year, how does the sender prove they had consent, or how does somebody prove they didn't have consent?
So I can answer that. That's a little, that's gonna be very fact specific, but keep in mind that the state has the burden of proof beyond a reasonable doubt. If you are in an intimate relationship with someone and have been for some time, and there's been photos exchanged 3 or 4 months back, the biggest concern was people, the relationship went sour, and then all of a sudden, they out of the woodwork, all of this. There is data on when that photo was originally created, when it was sent. If there's evidence that the photo was sent while the people were in a relationship, it is going to be much more difficult to prove this. If the parties are going through a divorce, or if they separated, if restraining was involved, or in situations where the person doesn't even know the other person, or they barely know each other, you would be able to prove, that would be evidence of consent and non-consent. Also, if there's an exchange of back and forth of, I don't want to get into the details, but sometimes there can be messages or comments that, go into it. So there's a lot of ways to prove it, but ultimately, the state has the burden of proof. But if there's nothing to show it was just unsolicited at all, that would just be granted consent. It's really my understanding. Seeing no hands raised. Representative Bolden, you already spoken once. If you've already spoken, the chair is not going to recognize the person speaking the second time. It is Friday afternoon, and in the interest of just all the members. Seeing no hands raised from members who have not already spoken, the matter we put the question, the clerk will call the roll. If you are in favor of the motion of ought to pass, please say yea. If you are opposed, please say nay.
Vice Chairman Welch.
Aye.
Representative Burke. Representative Hopper.
Yes.
Representative Green.
Yes.
Representative Wallace.
Yes.
Representative Testerman.
Yes.
Representative True.
Yay.
Representative Pratt.
Yes.
Representative Marston.
No.
The clerk votes yes. Representative Harriet Gathright.
Yes.
Representative Pantelakis.
Yes.
Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley. Chairman Abbas.
Chair votes yes.
Mr. Chairman, the vote is 18-1.
So I have voted 18 yeas and 1 nay. The motion of ought to pass is passed. Put that on consent. Without objection. Now it's on consent. Majority report, would that be?
Is it 18 or 19?
There are 2 members absent.
Absent. I only had Andrew absent.
The representative from Goffstown was.
Oh, good. Oh.
And we didn't. And
Okay, I'm sorry. It's me. I didn't even know he was gone.
will it be a majority report? Yes. Representative Gafford, will you be making the majority?
Sure.
Will it be a minority report?
Mr. Marston.
Who seconded this? I don't remember who second. Who seconded?
Pantelakis. Representative Pantelakis seconded.
Thank you.
We will now close the executive session. on House Bill 296. All right, just before we depart, everyone. To my understanding, and please correct me if I'm wrong, the only bill that we've had a public hearing on that we have not exec yet is House Bill 307. Sounds good?
Yep.
And my understanding, just so people can plan ahead, that there's a likelihood that we would meet on
Wednesday.
we're meeting next Monday and Wednesday, but the following Wednesday is the 10th. The bills we have right now have a deadline of the 11th. So those reports need to be done right away. If you, and then any amendments you're gonna want for the bills that haven't been left, I'm not sure we're gonna have another meeting other than next Monday, next Wednesday, and then, so Monday the 1st, March 3rd, and then I believe March 10th. I'm not sure we're gonna have another meeting, so if you have an amendment for something on March 10th, for the love of God, just please bring it. You gotta be proactive with that, and then otherwise it's not gonna get done.
Meeting? Reaction on that?
Yes, there'll be a meeting on the 10th.
A committee meeting,
Yes, a committee meeting.
so on the 3rd and the 10th.
Right, in the first.
First and third. and tenth.
First, 3rd, 10th.
First, third, and tenth.
And then, bear with me one moment. Representative Bourdon, I have in my notes, which are not always accurate, that HB 125, you were gonna prepare the majority report for that.
I don't remember. I think that maybe either I did it or I sent it to Nicole to do.
If you have, if members can't stay, this is more than one. If you haven't done it already, please do so. If you've done it already and forwarded to me, I clearly lost that email. If you don't mind forwarding myself into the committee assistant again. I can check.
Sorry, John, there was a Representative Bourdonnais miscommunication on my end. I liked yours.
Okay, if someone could forward that to me into the committee assistant, that would be helpful. Representative Wallace, I have you down as ought to pass as amended from HB 180. You sent it this morning.
And you approved it, I got an email back.
All right. Representative Byrd, I have you down as ought to pass, so the majority report for 334.
Sorry. When was that? Did we do that today?
No. I think that involved snowmobiles and.
Oh, I think I sent that in, but I'll resend it.
Just resend it. I'm not denying it.
Yeah, that's my bill.
Yes, it is.
Some of the
Yeah.
House Bill 338. Representative Jeff, did you send me that?
2009.
So what was the last one?
I think that's the one that I sent to you either yesterday,
18.
because I
18 to
found
1.
one that I hadn't sent.
338.
Is it on?
All right.
Then I think you have it now.
Yep. I'll double check, but if you have,
I'll check
if you
too.
don't mind, just read.
I was the one.
If I'm not making
I
sense, just
think I
read
did
for it.
this like yesterday, because I think I came, when I got home last night, I was going through hundreds of emails.
The Criminal Justice Public Safety Committee, we will now be in recess. Everyone, please enjoy your weekends.
3:38.
I'll see you.